Okay, thank you, Madam Clerk. We have a meeting that's going to be taking place in privileges and elections. So what I'd like to do is call those members first so they can go and, we'll first present the bills here and then go across the street to privileges and elections. So I see Senator Spruill. So Senator Spruill. The chairman. Well, he's going to defer to Spruill, and thank you for, I'll be the chairman, guys. I'll be the chairman. All right, Senator Spruill.
Mr. Chairman and members, good afternoon. Mr. Chairman, Senate Bill 1030. This bill prohibits, I'm sorry, anybody say something? This bill prohibits a keeper of dangerous captive animals such as bears, tigers, elephants, allowing and etc. allow direct contact in public for free or cost to such dangerous animals. Look at the bill, Mr. Chairman. It definitely says specifies any animal which is caught in the wild, sort of. Not only the bears, but also the cougars, leopards, any wild animals. And we had testified before the committee a group who came before us who fit this criteria and had some problem with it. But the bill is dangerous, and we have no problem that if you have the animals and that they are fenced off somehow where the public cannot get to them and touch them. We're talking about wild animals. We're trying to keep that from happening, that you cannot touch or ride raw or wild animals. That's the gist of the bill.
Okay, so this is Senate Bill 1030.
Yes, sir.
Dangerous animals, and it looks like the gist of it is a keeper cannot provide an individual the chance to, looks like it, touch it, give it a hug, anything else like that. And it's a Class 3 misdemeanor, a fine of $500.
Yes, sir.
Mr. Chairman,
Yeah, Senator Favola.
we heard this in subcommittee.
Oh, I'm
and-
sorry.
and
Okay.
We offered an amendment, right, a delayed enactment clause.
All right, I apologize then. If I could get the subcommittee chair, why don't you tell us what y'all did on this?
Mr. Chairman, we came to peace in the valley. Subject to a fine. Can we take this file in just a few minutes?
Not really.
I've got to check my notes. Dave, real quick. Did we change this? Let's report the line amendment.
Okay, apparently we have a line amendment. Go ahead.
Mr. Chair, just one line amendment. It was, as Senator Favola said, to add a delayed enactment clause. So after line 30, it would read 2, that the provisions of this act shall become effective on July 1st, 2021.
Okay. Somebody want to make that motion?
That's it. So I move that we accept the line amendment.
Okay, we've had a motion and a second to accept the line amendment to become effective. What's the date again?
Mr. Chairman, July 1st, 2021.
July 1, 2021. All right.
Mr. Chair,
Yes, where's that? Yes. Senator McClellan.
just so that we're clear, as I understand this bill, so it says direct contact. As the bill has been explained to me, let's take an elephant, for example.
You had to say that, Jan.
You cannot, as I understand the intent of the bill, if there is a wall between you and the elephant, but there's an opportunity for you to touch the elephant, but there's a gate between you and the elephant can't get out, that's okay. Is that the intent of this bill?
Senator Spruill.
Mr. Chairman, that's a lawyer's answer, and I can't answer that. That was not my
Okay.
intent. My intent was that wild animals, you shouldn't touch them, whether they're behind or whether they, personally, you shouldn't touch wild animals.
Okay, I'm sorry, Mr. Chair, then I'm gonna have some more questions.
Okay, more questions, Senator?
Yeah, so, Mr. Chairman, and I know more about elephants than you would expect any Democrat to know, but, because I happen to have a son who loves them. So there are some zoos, I don't think we currently have one in Virginia, but we may, who under the, I think it's the AZA's accreditation, do not allow, like you and the elephant standing right there, that's not allowed. But they do, as part of education programs, will have an elephant behind a fence that the elephant can't get out of. And they do have interactions where someone is allowed to, feel the elephant's skin, feed the elephant. And there's enough protection there to keep the elephant from hurting the person and the person from hurting the elephant.
Mr.
And as
Chairman-
I read the bill right now, if that happened in Virginia, that would be a felony, is that right?
Mr. Chairman, we're talking about wild, we're talking about wild animals. We're not talking about those that's like in the zoo. We're not talking about those, we're talking about the wild animals who are captives. We're not talking about those who are in the zoo. You're exactly right, Roy. If you were talking about that situation, yes. We're talking about animals that's wild. You go get a tiger that you raise yourself. We're talking about wild animals, not those who are in the zoo that's training.
Okay, hold on a second.
Mr. Chairman?
Yeah,
That's not
Senator
what it
Marston.
says.
Well, Senator McClellan, we had a situation raised by someone who was testifying that an elephant reached through a gap in the fence where somebody was reaching through, ensnared someone and did some serious bodily injury by squeezing that individual up against the fence. And so it's not always as simple as
All right.
as a barrier.
Why don't we do this?
Well,
Yeah, Senator McClellan.
I'm sorry, Mr. Chair,
No,
but
not-
there are, and again, because we're dealing with not just what the zoos are doing today, but what zoos may do in the future. And there are criteria that the zoo accrediting agency, and I'm talking about the Atlanta Zoo, is the example I am familiar with. At the Atlanta Zoo, which has a elephant exhibit that complies with the accrediting agency's criteria for elephants. But as part of that, they have an opportunity with safety measures in place that comply with that zoo's accreditation requirements that would allow, as part of the education of people on elephants, to minimally interact with that elephant. It is direct contact in that your hand can touch through a wall that elephant cannot break the elephant. And as I read this bill, if that happened in Virginia, it would be a felony. As
Where do you-
opposed to, I know there are other zoos where there's no wall and you can ride the elephant, and I can see how that would be an issue. But if you are complying with a zoo accrediting agency's criteria for interacting with what we define as a dangerous animal, satisfying the safety mechanisms that they have put in place, I'm not sure why we would want to make that a felony.
Okay, Senator McClellan, maybe we're working off the wrong bill. Senate Bill 1030 has to do with a Class 3 misdemeanor, $500 fine. There's no felony.
Okay, well, maybe I'm reading the wrong one then.
Okay, Senator Marsden, first of all, can we move the line amendment?
We did.
Move the line amendment.
All right, can you re-report the line amendment, please, Mr. Kern?
Mr. Chairman, the line amendment is after line 30, in sort of new enactment 2, that the provisions of this act shall become effective on July 1, 2021.
All right, so we've had a motion and a second to add that line amendment. All in favor, say aye.
Aye.
Any opposed? Okay, that line amendment is adopted.
Mr. Chairman?
Yes, sir.
The committee on hearing the report, hearing the bill, voted 2-1 with this amendment to be reported, and I so move.
Okay.
Mr. Chairman.
Okay, we have a motion and a second. Yes, Senator Hangers.
Mr. Chairman, I'm going to need to offer a substitute, and I discussed this with the patron in reference to an elephant. There's already been a conversation here, and I would want to amend it before it's reported, if I could do that now.
Sure.
Just a short, quick story. When I first ran for the Senate, I was in the company and down in Natural Bridge of the Attorney General, Jim Gilmore. Unbeknownst to me, an elephant arrived at the Natural Bridge Hotel and walked in the back door accompanied by some people, and came up behind me with Jim Gilmore standing there. And you all know how serious our former governor is. That elephant reached his trunk out and tickled the back of my neck, and Jim Gilmore cracked up. It was just, it was funny. At any rate, I've got a good picture of that at home. I wish I'd have brought it for today. Point being, the animals described here are dangerous except for elephants that have been in a zoo, and this particular one's been there for like 35 years.
Okay.
So I would
Chairman?
move that we amend it to take elephants out.
All right. There's been an amendment to take out elephants, and,
Mr. Chairman,
yeah, hold on one second. Are elephants even in the bill?
Yep. Dangerous animal.
Okay, all right, fair enough. All right,
Chairman.
let the senator speak to that, Mr. Sponsor, Senator Sproul.
I also asked my friend, Senator Hanger, are you talking about this particular elephant when they had this since you were a baby? You understand? But he's old, bless his heart. And he's old, and but kid with this. And I also asked him, is it okay if we saying when this elephant go to heaven, then the rest of them become wild, that they can have another one? That was my question, and he did not answer that. I understand what he is saying. This elephant been had by the family for years and years and years and all, and the kids ride this animal, and then he's old. Sometimes when the elephant get old, I was told that sometimes they do mischief things. But I asked him, I said, well, if we can do this one, then when he dies, then the rest of them become wild. So in order to do that, Mr. Chairman, we can't guarantee that. So to me, I prefer that you don't do it.
All right, tell you what, why don't we do this? We've got a motion and a second to remove elephants from the bill. All in favor say aye. Aye. Any opposed?
Nay.
I think the ayes have it.
I believe I do.
I think they do have it. All right, so that amendment is adopted. Elephants survive. Okay.
I renew my motion to report as amended.
Okay, we have a motion to report the bill as amended.
Mr. Chairman, may I say
Any
something,
further
please?
comment? Last word for Senator Sproul.
Yes, sir. I promise my friend Senator Mason, I will not bring another dog beer. I promise him that. And I promise that this, sir, was not my fault. I promise to everybody in this room, I will never bring any kind of beer that deals with any kind of animal other than a human being. Thank you so much.
All right. Since we heard testimony in subcommittee, so we're not going to hear public testimony again, but what we will do is go ahead and open the roll.
Yeas 9, nays 6.
Thank you, Mr. Chairman.
All right, thank you,
Bless-
Senator Sproul.
Bless your hearts. Thank you.
All right, now, going back, we sort of stumped ahead with that initial bill from the Animal Subcommittee, and I'm going to go back to my original plan, which is Senator Deeds.
Thank you, Mr. Chair. I've got Senate Bill 621.
Right.
And I understand, I guess, a couple weeks ago, you all took this bill up and it died on a 7-7 vote. You graciously reconsidered it, and I appreciate that. In the 1999 session, when I was in the House of Delegates and Senator Hanger was over here, we carried legislation that created a tax credit for land conservation. A couple of years later, Bill Howell, before he was elected Speaker, carried legislation that made that transferable. Since that time, the Commonwealth has invested nearly $2 billion in land conservation through this tax credit program. In 2014, the Virginia Supreme Court, in their wisdom, took up an easement case, and they said, you've got to construe it in favor of development. Well, that puts that nearly $2 billion in tax credits at risk. And I guarantee you that nearly every one of you all have people in your districts who have benefited from these tax credits, whether they transferred it or whether they've got a lot of money and they took advantage of it directly. This legislation is designed to make sure that ambiguities are construed in favor of not development of the property, but grantee, which is usually somebody like the Virginia Outdoors Foundation or somebody else that's going to hold the easement. That's what the bill is about. That's what it does. I appreciate your consideration.
Okay, we had a pretty robust hearing on this a couple weeks ago. I know people have opinions, so Senator Hanger, you want to?
Thank you, Mr. Chairman. Just briefly, Senator Deeds is right. He and I worked on this legislation. It's been in effect. We have almost 900,000 acres in the conservation easements now as a result of this legislation. I'm going to vote against it today, though, hoping that somewhere in the process we can kind of come to some concessions on the needs of agribusiness in terms of developments in more intensive farm operations. That's my only concern. I want to protect this land, but there may be a word or two that we could add.
And Mr. Chair, if I could, I would say there may be a word or two that you could add, but nobody's required to apply for these tax credits.
Right.
They don't have to do it.
Exactly.
So the way to protect anybody is just not to apply for tax credits. These credits are for conservation. And if you're not going to conserve the property, don't use the tax credits. We've got caps on it. It's a limited commodity. A limited amount of money can be used for these things every year.
Okay, thank you, Senator Deeds. Senator Stewart.
Thank you, Mr. Chairman. Senator Deeds, I was part of this robust discussion on this bill the other day, and I grant that you are correct. People get tax credits for this, but they also give up a vast amount of rights in the property to be able to do things with it. And would you agree that they retain certain rights to maybe farm,
I would
maybe
agree.
timber?
And those rights are generally spelled out in the easement agreement.
But
But in order to keep all their rights, they don't need the tax credit.
But-
And what I'm saying is the language from that Supreme Court case is that puts every credit that's been granted so far at risk.
But
Yes, sir.
if language
Senator Stewart.
regarding farming or timbering was ambiguous, your bill would mean that the ambiguity would go against the grantor, the one who gave the easement to protect the land. Is that fair to the landowner?
Yes, I think it is fair. I think anybody who's going to have the benefit of one of these tax credits owes it to themselves to make sure they've hired an experienced person, experienced lawyer, most times to draw up a tax credit or to draw up an easement agreement that is as tightly drawn as possible.
Mr. Chairman.
You and I have probably both seen some pretty shoddy agreements out there.
Mr. Chairman?
Senator Stewart.
And I don't necessarily disagree with you on that point, and that was my point last time. Why don't we make this that the ambiguity goes against the draftor? And that is the current state of the law in Virginia in every other contract. That's what the law is. You're flipping the standard on its head essentially with this. Why don't we just say it goes against the draftor, so whoever drafts the document, which is the fair way to do it.
But the lawyer could be long gone.
All right.
Well, the draftor is the person who paid to have it drafted. So if the landowner had the easement drafted, it should be held against the landowner. If VOF had it drafted or DCR had it drafted, then the ambiguity should be held against DCR or VOF, just like we would do in every other situation under the law in Virginia. Would you consider an amendment to that effect?
I'll think on that, and if you show me something that makes sense, I'll certainly consider that.
Okay, I don't want to replay the entire conversation we had, and I know some people want to jump up and speak. Let me get any other questions or comments from the panel. Senator Lewis, and then I definitely have something to say. Go ahead. Senator Favola.
I will just say, this is a question to the patron. The way I currently read this, it would probably give an advantage to the state on a continuing basis,
It would
which I'm not disagreeing with.
There are some private holders of easements. It's not always the state. VOF holds a lot of easements, but there are other private agencies. In fact, the Supreme Court case, if you want to narrowly construe it, it involved one of those private holders of an easement. And that easement in that case was held by some local or private group. I'm not sure.
Okay.
All right.
Thank you.
Let me get to this. All right. While he's checking with his supporters there. Council, when we were last in front of us debating this 2 weeks ago, my recollection is I made an amendment specifying that it was not just the grantor and grantee, but also successors and assigns that would be bound by the easement. Can I confirm that? And we agreed to that amendment. You believe so, or yes? Well, what I would say is if we didn't, I thought we did, but I would amend the bill to make it clear that it's not just the grantor and grantee, but also successors and assigns, which is pretty critical I'm going to make in my next point.
Yes, we agree.
We did agree to it. Okay, so let me leave that aside. Second point. For those of you that don't practice real property law, and most of you probably don't, typically easements are construed against what's called the dominant estate. That's the estate that actually holds the easement. You know, they're applying the right to come across your land or dock a boat or have a path or what have you. I agree with Senator Deeds. This is a different situation because in this case, the dominant easement, or excuse me, the Serbian easement went forward and asked the state for this tax benefit, and it is a significant tax benefit.
Yes, it is.
And they are sophisticated parties represented by counsel. Nobody's doing this unless they're sophisticated parties represented by counsel. So I know I may be the minority opinion up here, but I do believe that this is a good bill. And there is a Virginia Supreme Court authority, which I disagree with, but that may become moot if we pass this bill. So having said probably too much, is there a motion on the bill? Okay, I have a motion.
I would second that motion, and the motion was to report as amended.
Okay, we have a motion to report as amended. That's been seconded. Is this requested in finance? It better not be. No, sir. No, okay. All in favor? Open the roll. All in favor, vote aye or nay.
Yeas 9, nays 6.
Okay.
You're
Thank
a
you very
winner.
much.
Okay. Okay. Next bill I have, and I know I'm going to go down the list, and just, I see Senator Boysko. Senator Reeves, are you waiting on a committee?
I am.
You are? Okay. Okay, I've got Reeves, Boysko, DeStep in that order, so. Bryce, I got you next. Go on. Senator Reeves.
Mr. Chairman, thank you. I have Senate Bill 510 for the committee. It's a bill on milk. And, Mr. Chairman, this bill is a bill to kind of bring some clarity to what milk really is. There's been a long-standing federal regulation that says milk has to come from an animal. You don't get milk if it's made from a seed, bean, or nut. And what this bill does is encourage the FDA to do its job and police misleading terms and labels in the dairy case. There are currently, let me count the states, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 14 other states that this bill would have to pass here and pass in 11 of the other 14, is my understanding, states, and it has 6 months after an enactment to do that if this bill were to pass today. And I think there's a bill coming through the House, Mr. Chairman, and I think I need to add an addendum to my bill. Is that right, Clerk? Okay, so if we could move that amendment that would provide for that provision.
Mr. Chair, I'll read the amendment.
Yes, go ahead.
After line 170, so at the end of the bill, it's a second enactment that reads 2, that the provisions of this act shall not become effective until 6 months after the enactment or on or before October 1, 2029 of a similar act in any 11 of the following states: Alabama, Arkansas, Florida, Georgia, Kentucky, Louisiana, Maryland, Mississippi, North Carolina, Oklahoma, South Carolina, Tennessee, Texas, and West Virginia.
Okay,
Mr. Chairman,
what's the purpose of that?
the bill is supported by the Farm Bureau Dairy Association. It's a pretty simple bill. It just defines what milk is, requires the board to promulgate some regulations on how to enforce it, and it's not milk unless it meets the definition in 3.25120.
Okay, thank you, Senator Reeves. Can someone explain to me the significance of that line of states that was just read?
Mr. Chair, I believe the enactment is there so that the act does not become effective unless 11 of those, I believe 15 states enact a similar piece of legislation before October 1, 2029.
2029?
Yes.
Senator Reeves, can you explain that to me?
It just came out from the House. First I heard of it was today when they wanted to have it in alignment with the same House bill. So maybe somebody from the Dairy Association
Can someone please explain that? I find that very
I have a
odd.
lifeline, I guess.
Okay, call a lifeline.
Mr. Chairman, members of the committee, Eric Paulson with the Virginia State Dairymen Association. Yeah, the reason that was put in, it was passed in North Carolina first, is I think they wanted to avoid any kind of interstate commerce issues with one state, I guess, holding it up. So they wanted a coalition of the states. Now, why those states were picked, I think those are just the states in the southeast that have dairy presence.
Okay, let me ask a further question. So this bill would not take effect until 2029 then?
Or if the 11 of 14 states passed before then, I think a 6-month enactment after that. But the deadline would be 2029. That's the absolute latest the other states would have to pass it by.
It's going to be like ERA? Okay, go ahead.
Mr. Chairman, thank you.
Senator
Does
Stewart.
this mean that this would be the definition of milk only in those 11 states?
Mr. Chairman, I think, according to my talking points over in Europe, they use it, and that's part of the problem is the enforcement of dairy-specific terms. As a result, project labeling is actually much stronger in other comparable English-speaking nations. The same almond, quote, milk brand sold in the U.S., Canada, and the U.K., but only in the U.S. is the term almond milk displayed. So truth in advertising, I would think.
This is the current federal definition.
All right. The enactment clause that was read, have we moved that amendment? Okay, so I'm going to leave that on the table for right now. Why don't we do this? Was this bill heard in subcommittee? No. No? Okay. Is anyone here to testify in support of the bill? Why don't you come up and give us the reason for the bill?
Absolutely.
Thank you.
Mr. Chairman, members of the committee, Eric Paulson, Virginia State Dairymen Association, representing dairy farmers in Virginia since 1907. This is already the definition. This definition was pulled straight from the federal code of regulations. So this is already the definition of what milk is in the United States. We're simply adopting here on the state level. We have standards of identity for a reason. When you talk about, you can't take sugar, water, artificial flavor, and sweeteners and call the product orange juice. Orange juice has to come from oranges. Same thing, you can't have maple-colored corn syrup and call it maple syrup. Maple syrup comes from a tree. It's very clear. The reason we do this is because these products have different nutritional value. When you think of milk, you think of protein, you think of calcium, you think of your vitamins. Other plant-based products don't have that same standard. They can have, and the former FDA commissioner talked about that, where we've seen cases of rickets now in this country and protein deficiencies in children that you only see in countries that have famine because the parents are feeding the children rice milk. We believe consumers have a choice. These products should be there, but in most of the world, they're called a different name. Almond beverage, drink. Same thing you do with those orange products. They call them orange drink, or they call it something else. You just can't use the word milk, and there's a reason for that. Like we said, this is already federal. This mirrors the federal language regarding it. This bill passed with bipartisan support in North Carolina and Maryland, and it passed out of the House already with bipartisan support as well. And we believe that having the delayed enactment of allowing 11 of 14 states is a pretty high threshold to meet, but it'll allow enough robust conversation. So for those reasons, we support the bill.
Okay, any questions for this gentleman? Senator McClellan.
Thank you, Mr. Chair. I'm not sure if this is for you or for the patron, but so as I understand this bill, if soy milk that is sold in the store would have to be rebranded, is that right?
Correct. It'd have to, another name, and that's what we've seen. We have products that are made in the United States. When they ship them into Canada, they have to put a different label on it.
Follow up, Mr. Chair.
Okay, can I have some order up here, please? Thank you, Madam Senator McClellan.
So, Mr. Chairman, soy milk has been sold and labeled in the United States as soy milk since the 40s. It has been referred to by the Department of Agriculture as soy milk since the 60s. So what is the confusion that you think people have over?
It mainly goes back to the nutritional conduct. In the federal dietary guidelines, soy and some of these other ones don't meet the definition of dairy. Unless they're properly soy, I think if it's properly fortified, can meet those definitions as an alternate beverage, but a lot of the other ones do not have to meet those same thresholds.
Follow-up question, Mr. Chairman.
Yep, Senator McClellan.
Aren't the labels, aren't they also supposed to identify the percentage of, the amount of and percentage of protein or other things that are in the milk?
Correct, and I think some people who might look at that might be able to see it, but most people think of milk that you have something in mind already when you think of milk, and you assume they're all equal. They might not come from the same source, but you think they're the equivalent, and that's not the case.
Final question.
Senator
Mr. Chair.
McClellan.
So since ancient times, people have called the liquid in a coconut milk. But I don't think anyone is confused as to whether coconut milk is dairy or not. I think the issue here sounds like you don't want people to be confused that plant-based products are not dairy products. But I don't think there's any confusion as to the differences between plant-based milk and dairy milk when for centuries for coconut milk, and at least since the 40s for soy milk, people have referred to them as milk, and there doesn't seem to be any confusion.
Okay, was that a question?
Isn't that right?
All right. Any other supporters, Senator Reeves?
I think Farm Bureau, well.
Yep, please.
Good afternoon, Mr. Chairman, members of the committee. Stephanie Kitchen with Virginia Farm Bureau. We do support the bill for the reasons already stated. And to get to Senator McClellan's statement about the confusion of labeling, yes, consumers may realize what they're getting is not from a cow, but a study in 2019 actually showed that 73% of consumers thought that almond-based beverages had the same nutritional value, the same amount of protein as actual milk dairy products do. And actually, it's 8 times as much protein in dairy milk as it is to alternatives. So I think there is some confusion there. But what this really gets at is fair enforcement. As has already been stated, there are existing standards of identity on the books. This is not creating something new. This is a step towards fair enforcement for what is already out there. In addition, our dairy industry is struggling greatly. In 2018, we lost on average 1 dairy farm a week in Virginia, and in 2019, that increased to 2 dairy farms a week. So unfortunately, this is a trend that is not being reversed anytime soon, so we think this bill would send a very clear message of support to our dairy industry, who's greatly in need of that at this time. So we do ask for your support of this bill. Thank you.
Okay.
Mr. Chairman.
Yes, sir.
Members of the committee, Kyle Shreve, Virginia Agribusiness Council. For all the reasons you just heard, we support the bill. Thank you.
Okay. All righty. Anybody with a deferring viewpoint, come forward. And please state your name and defer.
My name's Christine Solom from Charlottesville, Virginia, and some of you may know me as the Goat Lady.
Okay.
Okay, I'm going to approach this bill from a different angle that no one has seen, I think, before. And I have an amendment which I've given to several people, which I hope you will add to the bill. Mainly, I hope that you will kill the bill because it is a violation of freedom of speech and other items which I'll go into in a second.
Okay.
However, my first priority is this bill sneakily will hurt herd shares in Virginia. Now, for those you may not know, herd shares are for people that do not want to drink pasteurized milk. And it is illegal to sell raw milk in the state of Virginia. Therefore, people have bought a share in a herd, and then they own the cow, they own the milk. It's their milk. They pay a maintenance fee, and they go and get their milk. Now, 2 years ago in the Senate, there was a bill put in by Senator Obenchain.
Yes.
Okay.
I'm still-
And you know
still
that was
recovering from
defeated.
that, by the way.
There was also put one in the House of Delegates by Delegate Knight, which has put in the companion bill, HB 119,
Okay.
this year. So there's a history there. This bill sneakily, or maybe there are unintended consequences in quotation marks, would take care of goat shares in Virginia. It would render them illegal. And it's done through misbranding. At first case, you look and say, this has nothing to do with goat shares. But if you look at it, it has everything to do with it. On the bill, the definition of milk. Milk means a lactose secretion practically free of colostrum obtained by the complete milking of a healthy hooved animal. On and on. On down, it's put in the Administrative Process Act, which states, the board shall develop and implement a plan to enforce the prohibition established in subdivision A, and I'll read that in a second. Such plan shall include a ban on the sale or offer for sale of any product that violates such prohibition, including any plant-based product that is misbranded as milk.
Okay.
The prohibition is if it purports to be or is represented as milk unless it meets the definition of milk. Well,
Okay,
you put
ma'am,
that in the
ma'am,
administrative process. I'm showing you, I'm getting there.
Well, you got to get there very quickly. 'Cause
I know,
got
I
a
will,
line of
I
people
will.
behind you. And
If
really,
you go
I
in the
should put you on
Administrative
5
Process
minutes.
Act, they're going to look at that and say, your milk isn't healthy because your animals are not tested as in the industry. If you look at a food should be deemed misbranded,
Okay, ma'am, I can't just have you read documents. I got
okay,
a
all right,
room full
but
of
it's
people here.
misbranded if its product is not labeled.
Okay.
And if it's in package form, which would be milk.
Okay.
And also delivery is considered. So doing all that, they're going to bring in herd shares. What we're proposing is amendment.
Ma'am, okay.
I'd like to speak to the amendment. It will take me only a second.
Well,
If it purports to be, or.
Ma'am, amendments only come from the panel. So I think if you want to.
Okay, some have copies of the amendment. We want to exclude herd shares, where it says that it shall not include breast milk. Then also,
Okay.
the subdivision shall not apply to human breast milk or the acquisition of milk for one's personal consumption through herd shares. That would not destroy your bill. I do not agree with the bill.
Okay.
I think that people should have the right to have coconut milk or almond milk. It's a bad bill. If you pass that bill, you're making coconut milk and almond milk more illegal
All right,
than
thank you.
handguns, because
Thank
you can
you.
buy a handgun.
Okay, you have stated your point eloquently. All right, I'm going to put the remaining speakers on 3 minutes because normally I would have done 5, and that was frankly more.
Okay.
Okay,
I
3
have more to
minutes.
say.
Thank you, madam.
All right, that's all right.
Next up.
Hi, my name is Susie Crows. I represent VICFA, Virginia Independent Consumers and Farmers Association. And for some of the reasons that Christine Solom just stated, we also are opposed to the bill. We feel that that section in between lines 98 through 100 that talk about the administrative act where you're putting in a plan is just too loose. And I would like to see the bill killed because of that. And certainly if it does go forward, I'd like to see some tightening up on that. Thank you.
Okay, thank you. Next.
Mr. Chairman, I'm Jim Riddell with the Virginia Cattlemen's Association, and we wanted to go on record supporting this bill. We represented cattle producers all across the state since 1948. The bill would mirror the existing federal language and regarding the definition of milk and the Food and Drug Administration currently uses. And we wanted again to say 30 years ago there were 1,650 grade A dairies in Virginia. Today there are 450 grade A dairies in Virginia. So we would appreciate the support of the dairy industry.
Okay,
Thank
so
you.
you're in support. All right.
In support.
Okay, Mr. Chairman, members, I'm Dan Colgrove. I'm in opposition on behalf of the Plant-Based Foods Association, which is the business trade group that represents the companies, small and large, that make these products and that buy American commodities and turn them into products. We think briefly this bill is one of those solutions in search of a problem because the products are already in full compliance with all current FDA regulations, and as such are clearly labeled that they're plant-free or veggie or something of that nature. To make it even more clear, because we want people to understand that we've also adopted voluntary standards that go even beyond what's required by the FDA. So we would respectfully suggest that this is a bill that is not necessary. Thank you.
Thank you very much. Okay, yes, sir.
Hi, I'm Mark Onley with the Good Food Institute, and we're opposed to this bill. I'll echo what the Plant-Based Food Association said, that this bill is a solution in search of a problem. Proponents have already said that FDA's current definition for milk requires a lacteal secretion requirement. State and federal law already prohibit false and misleading labels. So if these labels are false and misleading in any way, right, that's already prosecutable under the law. So what this bill does is it seeks to do something different than address false or misleading labels. It seeks to do something different from what FDA has. It seeks to make it a Class 1 misdemeanor here in the state of Virginia, punishable by up to 1 year in jail and $2,500 in fines to label something almond milk. Right? That's a pretty high price for calling something that's been used for decades, as has been noted here. Courts that have ruled on this issue have looked and have ruled that this is not misleading to consumers. It's likely a violation of the First Amendment. And one federal judge put it akin to thinking that consumers would think that ebooks contain paper. People know how adjectives work, how modifiers work, and this is obviously clear. There's no consumer confusion here. I urge you to vote against this bill.
Can I ask a couple questions? And
Absolutely.
You may know, is there a federal Food and Drug Administration definition of the word milk?
There are things called standards of identity, and I'm not a lawyer and don't work in this, but I understand that there is a standard of identity for milk that requires the lacteal secretion component, and it's similar to the language in this bill.
Okay, and further question, does anyone have a copyright or a trademark on the word milk? I assume not.
I'm not a lawyer, so I couldn't say. I don't believe so. And something to know is that these plant-based products do not represent themselves as milk. Their selling point is that they don't come from animals, that they come from other sources. That's why people buy them, and that's why they seek them out. Or if you
Right.
don't buy it, it's because you can see on the label it's from almond or soy.
I understand
Right.
that. Okay. Any questions for this gentleman? Okay. Senator Reeves, you get the last word.
Mr. Chairman, I would just tell you, I don't think it's a felony. I read the bill multiple times. It doesn't say anywhere in my bill that it's a felony to mislabel milk, but I got to go to our committee and proxy.
Okay,
so.
we've got the bill in front of us. We had that amendment, which I'm still not quite sure I've got my arms around. Did anyone want to move that amendment? No, the elephants, that was the last bill, Stanley. Okay.
No elephant milk in here.
Anybody want to move that amendment? Okay, I don't have a motion on the amendment. I have the bill in front of me. Somebody give me a motion.
Mr. Chairman,
Senator Favola.
I move that we very gently PDI this because I really don't see the reason for going forward with the bill. I think consumers understand the difference between a cow's milk product and almond milk or other kinds of plant-based milk. Again, I don't see the problem here that we're attempting to solve unless the milk industry, the cow-based industry is really trying to increase its market share. But other than that, I don't see a public reason necessarily.
Okay, we have a motion. Do I have a second?
Mr. Chairman?
Yes, sir. Senator Obajing.
Substitute motion.
I have a substitute motion. Well, you got to make the motion first.
Yeah, he read my mind. Having, representing the #1 real dairy county in Virginia and recognizing some of the challenges being faced by the dairy industry, and I would move to report the bill.
Okay, we have a motion and a second to report the bill. Open the roll. Oh, it's to re-refer to finance. Okay.
They asked for it.
All right, open the rolls.
Yeas 10, nays 5.
Okay, the bill reports 10-5.
Mr. Chairman, can I come back, go proxy, and then come back from our other two bills?
Yes, sir.
Thank you.
All right. Thank you, Senator Reeves. Senator Boysko's been waiting super patiently. Thank you, Senator Boysko.
Yeah. And my co-patron, Senator Stanley, is going to join me for this because we, once again, have joined forces.
Okay, let me do this. We're doing this a little bit ad hoc, but since this went to a subcommittee, I'm going to have the subcommittee chair describe the bill and the action taken by the subcommittee.
And, Mr. Chairman, we have a substitute.
Yes. Okay, why don't we get to the subcommittee report and then we'll get
Thank
to
you.
there. Yep.
Do we have the sub? Let's pass that out. Okay.
There you go.
And I move the substitute.
Second. Okay, we've had substitute moved and seconded, and it's being distributed right now. All in favor of adopting substitute, say aye.
Aye.
Any opposed? All right, substitute is adopted and before us. Mr. Senator Marston.
Thank you, Mr. Chairman. This bill passed our subcommittee 3-0, as reported with a sub, and it prohibits the breeding any dog or cat or for participation in research, experimentation, or testing that is not required pursuant to federal law or regulation. The sale or transfer to a manufacturer, institution of higher learning, or contract testing facility outside the United States. So we're not allowed to send them overseas. You're not allowed to do it for experimentation or testing or research. And we thought it was a good bill. It came out 3-0. Senator Boysko, does that about cover it?
That explains it very clearly. Thank you, Mr. Chairman.
Okay. Before we kind of get to the committee itself, I know we had live testimony in subcommittee, and normally we're not going to redo people that testified in subcommittee. I think we had at least one witness that was not available in subcommittee and is available. And if we do have a witness that didn't testify in sub or was not available and wants to testify now, I can give you, say, a minute, maybe two. Ms. Hooper.
Mr. Chairman, Elizabeth Hooper with Virginia Tech. This is the first I'm seeing the substitute, so my comments are going to reflect the Senate Bill 669 as originally written. We did have an issue with the bill, which we've shared with Senator Boysko's office as well as Senator Stanley's office. Our Virginia Maryland College of Veterinary Medicine annually acquires dogs that are instrumental in teaching veterinary students clinical skills to prepare them for the successful careers in private veterinary practice. All of our dogs are extremely well cared for and find their forever home at the end of the academic year through our own adoption program. The research community is continuously adopting new techniques and technologies to improve the well-being of animals, whether they be in your home or in a research facility. Dogs contribute to our understanding of both animal and human diseases and how to prevent, treat, or cure them. Research with dogs has and continues to lead to life-preserving and enhancing treatments in the areas of diabetes, heart disease, kidney disease, organ transplantation, spinal cord
Elizabeth, I hate
injury.
to cut you
Yeah.
off, but have you looked at the substitute? Because that may address some of these concerns.
I think that actually the problem comes with the first little I. Because I wonder if our attorneys would still have an issue with participation or use in research, because those animals would still be in research at our veterinary school. And I'm not an attorney, and I don't play one on TV.
All right,
Mr. Chair.
why don't we do this? Senator Morrissey.
Would you look at line 12, the accompanying clause beginning with that, and tell me whether or not, I'm sorry. I'm sorry, I forgot your name. Elizabeth, could I ask you a question?
Get back up. I'm sorry. I didn't mean to
My
wave you
fault.
off. Senator Morrissey.
Ms. Hopper, would you look at line 12 and that modifying clause that says that is not required pursuant to federal law or regulation, and tell me
Yes,
whether
sir.
or not that doesn't assuage your concern?
No, sir, it would not, because I don't believe our vet med programs are required by federal law.
Just final question, Mr. Chair.
On my good side.
Don't some federal laws actually, in order to conduct research, and you're speaking to an animal lover, but
Yes.
don't they require that the testing be done on animals?
They may for certain federal grants, but that's what I'm saying. For as far as teaching in a vet med school, I'm not sure that federal law stipulates,
All right.
and
Thank
I would
you,
have to
Mr.
go back
Chair.
to campus and ask. Or hopefully someone else in the group may be able to ask.
Mr. Chairman?
Okay,
yes.
Senator Obenshain.
Can I just ask Ms. Hooper?
Yes, sir.
A question or two. So why don't you get the animals, well, first of all, how do you use them for teaching?
So it was explained to me, so think about when they're being spayed or neutered, or when you're running an IV into their veins, or when you're trying to clip their toenails, things like that. So simple things.
How do you, why can't you get them from the Humane Society?
I believe that is Humane Society or the SPCA or other entities such as those, or that's actually outlawed in Virginia.
Prohibited by law?
Yes, sir, it is.
Okay, so the only way that vet students can be taught some of these methods is by, is through these animals?
We would either acquire them through breeders such as those in Virginia, or some institutions across the nation, not necessarily in Virginia to my knowledge, could breed them ourselves.
Okay.
You know any vet students who aren't animal lovers?
No, sir.
All right, let's stay on track here.
Yes, sir.
Ms. Hooper, thank you.
You're welcome.
Who else did not speak at the subcommittee, and again, speak for a minute? Yes, come forward and identify yourself.
Thank you. I'm Dr. Cindy Buckmaster, and I am actually a member of the research community and also former director of one of the largest research animal care programs in the nation. And I want to speak specifically to your question, Senator Morrissey, because I think it's a good question. Aside from vet training, I think what that particular point is noting is the fact that when candidate drugs, are eligible for testing to determine whether or not they'll be safe for human patients, there's a federal requirement to work with animals, okay? But the problem then is that the bulk of research is not in that space. The vast majority of research, federally funded research, is in the basic research that informs the development of those drugs to be tested. And that's where most of research is. And that research is really about understanding the health of living systems, because you cannot understand what's wrong in a system, what's broken, unless you understand how it functions when it's functioning properly. And that's where we spend most of our time, because, believe it or not, we understand very little about intact biological living systems. They're enormously complicated on the organismal, cellular, genetic, and molecular level, and we know just a little bit. It's kind of like if you go and bring your car to the mechanic, right? And the mechanic listens to the car, there's a problem, it jiggles, he points, he feels that he sounds funny, and then the mechanic says, oh, I know what's wrong. The only way the mechanic can pick that out is because that mechanic is exceedingly well-versed in what that engine looks like and how it functions when it's functioning in a healthy manner. That is why the animals are so necessary in research. And dogs, and I know that you're on time, but dogs happen to be exceedingly powerful models for the study of human disease, because they get many of the same diseases we get, which makes sense because we're all dog lovers and we've grown up with them and we've evolved together and we share the same environment and the same foods and all of these things. And so they are exceedingly powerful because they're exceptional models for a variety of diseases. I could go on, and I know that you don't want me to. But suffice it to say that the dogs then also benefit tremendously from the work we do. This bill would essentially cut off, as I read it, all of the basic research on which all of drug development is established, because
Mr.
basic
Chairman.
research would not be permitted.
All right, Senator Marston.
Mr. Chairman, if you read line 11, what we're talking about here is keeping them, raising them, or breeding them for the express purpose of producing offspring. If you can obtain an animal through someone who is not trying to produce offspring for these purposes, then you're perfectly fine. It's just that we do not want the people in the business of breeding animals for research and experimentation purposes. It does not mean you cannot use animals in research, is the way I read the bill, Mr. Chairman.
Okay, let's do this.
May I
Let's
speak to that?
tell you what. Let me see. Is there any other witnesses that did not speak in the subcommittee that would like to come forward and speak? And again, just for a moment. Yes, madam.
Good afternoon, Senators. My name is Alyssa Hatfield. I am a Virginia resident and the science advisor for the National Association for Biomedical Research. We're located in Washington, D.C., and represent more than 360 member institutions and their hundreds of thousands of employees who engage in biomedical research using animal models. Our members represent private research companies, pharmaceutical companies, academic research, and veterinary medical institutions. Our members do work that touches on human health, pet health, and in even improving the health and well-being of agricultural animals. I know, I've done this kind of research myself while obtaining my Master's of Science in Laboratory Animal Science from Stanford University. In a time of increased competition, the United States' position as global leader in medical research rests on a fragile ecosystem that is the public-private partnership. Increasingly, that fragile ecosystem is under strain from a combination of pressures and competition internally and externally, including unscientific public policy attacks domestically, which is what we see here. As this fragile ecosystem is struck with blow after blow, employers who work so hard day in and day out to take care of these animals will lose their jobs. More than 600,000 people die each year from cardiovascular diseases, one of the leading causes of death in Virginia. But it would be more without the coronary bypass surgery, pacemaker, and heart valve replacements that are all thanks to research dogs. More than 800,000 people in Virginia live with diabetes. It is thanks to insulin discovered in research dogs that this is possible. Dogs bred for research. Cochlear implants, helping the deaf to hear again, are thanks to cats bred for research. Dogs in research are helping to develop cancer drugs for both pets and people and have contributed to the hip replacements that help both Grandma and Fido. These are just a couple of small examples of ongoing research with research cats and dogs.
Okay, all right, let me just, and I feel like we had a subcommittee for a reason, and none of this was apparently heard, and I'm not blaming you, okay? I'll take the blame. But I'm a little bit, and this is very substantive information. I'm not discounting it whatsoever, but I feel, a little bit that I'm getting one side, which is great. Why don't you conclude your remarks, and then anybody else, what I'd like to do is just stand up, say who you are and who you represent and what your position is. And again, this is people that did not speak to the subcommittee, and I want to get the sponsors to get their rebuttal, which they deserve.
Yes, sir. To sum it up, this bill directly undermines the research and development. Also, this bill is an unprecedented bill that no other legislature in America has attempted because of its broad-reaching impacts on biomedical research in this country.
All right.
Thank you for your time.
Okay. Just come forward and say,
Holly Hazard from Humane Dominion, and I strongly support the bill.
right.
Molly Armis, the Virginia State Director for the Humane Society of the United States, and we strongly support this bill as well.
Okay, great. All right.
Hello, I'm Jim Harkness with Envigo. I oppose this bill.
All right.
Mr. Chairman, members of the committee.
Senator Boysko.
I would love to be able to bring us back on track and talk about what this bill actually does.
Right.
In no certain circumstance does it ban testing. This talks about prohibiting breeding offspring for the use of future testing in Virginia. And just to address the fact that one of our speakers just suggested that this has never happened in any other states. There are a number of bills in other states, Minnesota, Washington, Maryland, New York, California, Rhode Island, Delaware, who have all made some provisions around this area. Let's get back to the core reason that we carried this bill, though. There is a business called Envigo. They operate what can only be described as a dog breeding facility farm in Cumberland, Virginia, where thousands of beagles are bred each year for the sole purpose of being sold to laboratories for experimentation. These dogs are subjected to the terror of being packed and confined during lengthy international transport, including to Japan and Taiwan, where animal protection laws and regulations are lax and altogether non-existent. There has been video footage taken at the facility by federal inspectors revealing sick and injured dogs were denied adequate veterinary care, including a beagle with mammary mass the size of a small orange, several dogs with red and inflamed skin, dogs with torn and bleeding paws. Dogs were held in rusty, broken enclosures with several inches of moldy fecal material building up under the flooring, and food given to the dogs was contaminated with living and dead insects, mold, rodent feces, and other contaminants. These dogs were denied even a solid resting service and lived on wire flooring. In some areas, the cages were stacked up on top of one another, and the beagles kept at the bottom of the cage were surrounded by walls stained with the waste from the dogs above. Some of the cages were caked with several inches of feces, rotted, and covered with black mold. According to the U.S. Department of Agriculture, 59,401 dogs were used in research, tests, and experiments, and an additional 6,387 dogs were held in experiments facilities without dogs. We're talking about several thousand dogs in Virginia at this facility where these dogs had no opportunity for any sort of decent treatment. We're talking about banning the breeding. We are not discussing the actual research and development that the veterinarians and others discussed. Okay. So I'd just like to make sure that everyone on the panel here understands what we're talking about, which is not trying to stop research for medical use. Thank you.
Okay, thank you, Senator. I think we've heard a lot, and we've had a chance to discuss it up here.
Okay.
Do you have a motion?
Thank you, Mr. Chairman. Mr. Chairman, they do bring a very important issue to the committee, but I'm a little concerned that we need to look at this more in depth, particularly based upon some of the testimony we had from the biomedical research folks. So I think maybe it may be prudent for us to carry this over for the year. Let's get some more information, and perhaps we can make sure that we're not moving too swiftly on this issue.
All right, we've had a motion. You have a second? Second. All right. All right, we have a motion and a second to carry this bill over for the year. Clerk, open the roll.
Thank you.
Yeas 11, nays 3.
Thank you. Thank you.
All right. Do you want to bring it back? Pillion's a yay, so it's 12-3. Okay, thank you, everybody. Who do we have next on the list? I have Senator DeSteph. Anybody got a DeSteph sighting?
I don't think it's something different than the subcommittee heard 222.
Oh, okay. All right, well, before we do that, Senator Reeves is back in the House. Okay. Senator Reeves.
Thank you, Mr. Chairman. Appreciate the committee's patience. Let me go proxy. Mr. Chairman, I have Senate Bill 769. Mr. Chairman, this bill was brought to my attention by a locality. It's not actually my locality. I think the locality is Senator Morrissey's, but I call this the DEQ Transparency, Stability, and Accountability Act. And what brought it about was, well, first I think we have a substitute, if I'm correct, right? Mr. Chairman, if we can move the substitute.
Okay, I got a motion and a second to move the substitute. All in favor, say aye.
Aye.
Any opposed? All right, substitute is adopted and in front of us. If you can describe the bill, Senator Reeves.
Sure, Mr. Chairman. What it does, the bill brings transparency, stability, and accountability to the DEQ decision-making. It also addresses, gives some teeth to anything or any time the agency gives its word in a consent agreement, that they keep their word to prevent the rules from being changed after companies have spent a lot of money investing millions of dollars based on those. It does, what the bill does, it allows all parties to know the actual basis of a DEQ decision, creates an actual record for court review of DEQ directors' decisions, requires actual evidence to be cited when decisions are made that directly affect localities that use landfills, and I have quite a few localities here to talk about that. It requires the director to take into account all the localities affected by his actions, not just a host location. And I also have former Attorney General Troy here to speak to the issue, but it does take, like if you look at line 24 on the substitute, in which it has lined out in the opinion of the director and changed that based on facts, not just an opinion. And so I think it brings some clarity, some transparency, and some accountability, especially in the legal process of it. And with that, I'd like to hear from our witnesses if we could.
Okay, do we have any witnesses in favor of Senate Bill 769? Mr. Tony Troy. Do you realize I was your summer associate 26 years ago?
I do.
Okay.
Yes, sir. You
I'm
did
still
a
waiting
great
on my
job.
evaluation, by the way. Okay, thank you.
Mr. Chairman, members of the committee, very briefly, the way the current system works with DEQ, or in fact any administrative agency, if there is a dispute, you go to the agency. If there's a formal hearing, that's taken in front of a hearing officer. That is usually an independent attorney appointed off of a list provided by the Supreme Court of Virginia. That independent attorney hears all the evidence, expert witnesses, exhibits, and makes a, quote, decision, unquote. Decision, in fact, is a recommendation to the agency head. What this bill says is if the agency head rejects any of the recommendations made by the hearing officer, that he simply must articulate the facts and the reasons why he is rejecting the recommendation. Now, the problem you have here is when the agency head makes a decision and doesn't announce the reasons behind any rationale, and then it goes to the circuit court of the city of Richmond. Under our law, the circuit court is bound to give deference to the decision of the administrative agency head. In other words, the court, even if it would come up with a different conclusion, has to say in its mind, are there facts that support the agency head's decision, even if I, as a judge, would make a different ruling? So all this bill basically says is to DEQ, if you're going to make a decision, tell us why, so we understand whether we should appeal or not. And there's a lot at stake here because people go through these hearings. They're not inexpensive. you have attorneys, you have experts, and then to come up with a decision and have it rejected without any rationale, this says that practice should stop.
Mr. Chairman.
Yeah, Senator Stanley.
Just a series of really quick questions.
Sure.
General Troy, does the DEQ director participate or even observe these formal hearings?
No, this is the hearing officer itself, and then the director is given the, quote, what I call decision, unquote, to reject it, confirm it, or modify it.
Mr. Chairman.
Senator Stanley.
So the hearing officer's recommendations are based on what? Witness testimony, evidence, whatever comes before the formal hearing, is that correct?
Expert witnesses, exhibits, argument of counsel. It's like a regular trial.
Okay, Mr. Chairman.
Senator Stanley.
So then at the end, how much weight is given to the hearing officer's recommendations?
Well, by law, the administrator can simply reject the hearing officer's decision.
Even if he's not there?
Even if he's not there, and right now, under the law, you don't know why he rejected the hearing officer's decision. This bill would change that.
Mr. Chairman, final question.
Senator Stanley.
Thank you, Mr. Chairman. So from what you're telling me currently, what we have here under the code, I'm to understand, and I don't want to be accurate here, that the DEQ's director's decision is therefore entitled to some deference, even though he doesn't participate in this formal hearing. But the person, the hearing officer who participates in the formal hearing, is entitled to no deference in the final decision. Is that correct?
That's correct, and our courts are told to give, quote, due deference to the findings made by the director, even though he did not participate in the hearing.
Thank you, Mr. Chairman.
Okay, Senator Morrissey.
Mr. Chairman, it may be helpful before we have any more testimony to give the backstory to this as the folks have.
Yeah, I have a feeling that I see a line of witnesses. Why don't we get to these witnesses, and then I think there's a story here we need to know. But
would you like me to share that first, or wait till we hear the witnesses?
Why don't we hear from the witnesses, and then we'll get to it. Are you all in support of the bill?
Yes.
Please come forward.
Good afternoon, Mr. Chairman and members of the Senate Committee. I'm the former mayor and current councilman for the city of Petersburg, the host city. The Mayor Parham could not be here today. I'm here representing. He and I have attended several meetings with DEQ. The director refused to meet with us. We had to have the AG's office to intervene to allow a meeting with us, and we have been sidelined on several regards with respect to his decision to closing CFS. This came about after the mayor and I attended the hearing. There were witnesses giving great testimony and with respect to this, and then the lowest, denominator of environmental impacts took precedence over the major ones that they did not find. And so with respect to that, I have my staff, administrative staff here, as well as Dinwiddie County and Prince George to speak, and we stand solidly on our support for this bill moving forward. I do want to say that this impact would be a $3.1 million impact to the city of Petersburg. As you know, city of Petersburg went through its time, its financial, I get nervous sometimes, so I apologize.
Please.
But we did have our financial distress during the time when I was mayor. I got beat up a lot, yes. But at that time, CFS was a great business partner with us to keep us moving forward. And so was the state, I might add. But to have this decision come about just to close this particular facility, which is a great business in the city of Petersburg, will affect the citizens of Petersburg and will increase their tax base or their refuse cost.
All right.
Moving forward.
Thank you, sir. I'll tell you, before, I'm going to sort of go back and reverse a decision I made 2 minutes ago, which was erroneous. Senator Morrissey, can you give us a little bit of background? Because I think some people know what was going on here and some of us don't.
Sure.
Thank you.
Mr. Chairman, members of the committee, there is a dump that's located entirely within the confines of the city of Petersburg. It accepts trash from Petersburg and continuous jurisdictions. In February of 2017, Meridian Waste purchased that landfill, and it continued to operate it. Thereafter, they invested approximately $7 million in the facility, including a transfer station. as they should do it. DEQ then inspected the premises over the next year, and on 5 different occasions sent letters to the landfill saying that there was no deficiency. Then all of a sudden there was a complaint filed by DEQ, and then a hearing was held. And that hearing was held in June of 2019. And this is where the problem that General Troy addressed. During the hearing, evidence was proffered by both sides. Witnesses testified. There was a hearing officer that listened to all the evidence and ruled in favor of the landfill.
Okay.
Then the decision went to the director of DEQ, who Senator Stanley said was not there, and it was reversed. It was reversed without a written findings of fact. And that is what this bill is attempting to address, that there at least be findings of fact by the head of DEQ.
Can I ask you a question, Senator Morrissey?
Certainly.
Has there been a legal action taken saying that that's an arbitrary and capricious action by the DEQ?
There has been a hearing held in Richmond Circuit Court, but because and I think I have this correct, because DEQ made that decision by the director, the judge, whether he was right or wrong, ruled in favor of DEQ. Let me just say this. As folks that have heard me on this panel before know, I'm almost 100% going to default in favor of the environment. But what's also important is due process.
Yes, sir.
And it was troubling that there was apparent not only a lack of transparency here, but that there was a endeavor by the city of Petersburg and other jurisdictions to meet with DEQ and say, hey, tell us what the problem is, and that meeting never took place. And the last thing that I'm going to say, and now that I've given you the back channel, is I think I might be the only panel member that has actually got out and walked that entire dump with his boots on, up and down Puddle Duck Road, climbed that dump, climbed down it, and it's entirely within my district. So I know a little bit about the dump other than just reading things.
You were door knocking?
While I was door knocking.
Okay, all right. Thank you, Senator. We have some other witnesses here. Please come forward. Please don't take too long. I think we're getting the gist of it.
I promise. Good afternoon, Chairman, members of the committee. My name is Marie Grant, and I'm here representing Dinwiddie County. Dinwiddie County values transparency and supports the logic that if a decision is rendered, the why is included. Should the Tri-City landfill close, waste trucks will be redirected through Dinwiddie County to the alternate site in Lunenburg County. This route takes trucks through US 460 and the Courthouse Road interchange, which is the most problematic intersection in Dinwiddie County. We've had several fatalities at that intersection, and VDOT is currently working on a strategy. The design is poor, and are working to address that. In addition to that, there's a concern about the litter that spills over from the trucks as they travel 460. We have already begun receiving complaints from citizens regarding the extra traffic. Further, as a vendor, if CFS Meridian Waste are required to transport their waste products further, they incur additional costs, which they will then in turn pass on to their customers, the localities, and then we will in turn have to pass that on to our taxpayers, and that's an unfair burden.
Right.
Just in closing, we appreciate the opportunity to have a voice and also to know the rationale behind decisions that will ultimately significantly impact our locality.
Thank you, madam.
Thank you.
All right. Yes, sir. Very, very succinctly, please.
Good evening, Mr. Chairman, fellow members. My name is Michael Purvis. I'm the Director of General Services for Prince George County. I come before you today to share our concerns about the projected avenue by which the actions are been asked to take at that city landfill. It is our opinion and our understanding that the deterioration of the roadways by the consecutive continuous running of vehicles to remove it and the continued waste that will be a result of those trucks will add to an already stressed infrastructure of keeping the roadways clear and an already stressed fee structure of repairing our roadways. So we ask that you consider an alternative to the plan that DEQ has laid out. And at this point, I'll answer any questions.
I don't think we have any questions, but thank you, sir. All right. Anybody else? Make it super quick. Thank you, sir.
I'm Donald Hunter, to Board of Supervisors of Prince George. I merely want to echo some of the comments made in respect of your time, sir.
Thank you, Mr. Board Chair. Okay. I know there's an opposing point of view, and I see at least one person representing it, so, Mr. Paler.
Thank you, Mr. Chairman, members of the committee. Yes, I might have a different view. This is not the place to litigate any decisions that the department made one way or the other, so I'm not going to get into that. I am going to take issue with the fact that the agency did not follow the hearing officer's recommendations. It's clear to us and to my attorneys that we did. And I'm going to take issue with the fact that that they didn't understand the basis. All of the basis was in the record. But as to this bill, the biggest concern is to not turn the Administrative Process Act on its head. If the decisions of the hearing officer are dispositive, then that takes any discretion away from the director or any subsequent judge that may hear that. And so I think as a just as a system issue, this is counter to the way that all of our processes have been done. So I'll take any questions.
Thank you. Senator Morrissey.
Mr. Paler, first of all, thank you for the good work that you do at DEQ, and I have been so many times, including my career in the House, on your side. I've actually read the report in June of 2019, and my understanding from reading it is that the hearing officer agreed that the landfill had operated correctly under the consent decree, and more importantly, he said that DEQ failed to meet its burden of proof requiring closure. Am I mistaken in what I read?
There were, and I don't remember the exact number, I can call some other folks up here. I don't think we should litigate this here, but there were 6 or 8 issues that were there, and the officer found in favor of the agency's issues on all but about 2 of those, and the other 2 were, so it is true that maybe one or 2 of the findings the hearing officer didn't substantiate. The rest of them, they did.
One final question.
Yes, final question, Senator Morrissey.
I actually went out there 4 times to landfill and spent 2 or 3 hours each time, and I looked at the letters that were issued by DEQ. Is it not true that DEQ issued no deficiency letters in November 29th, 2017, December 22nd, 2017, May of 2017, June of 2017, and finally, May 31st of 2018?
I'm sorry, Mr. Chairman, I don't have that information in front of me. What I do know is that all of the technical staff at DEQ supported this decision, and we rarely revoke permits. My attorney was.
Let me jump in here.
Yeah.
Okay, this is not a trial on what happened in Petersburg, okay? And so, Senator Morrissey, very skilled trial attorney. You're not on cross-examination, David, so we're fine. This is a bill that impacts every locality in the state, okay? So everybody make sure they understand that. Who else would like to testify on this bill? Okay, before we make a motion, I do have one amendment, and I'm looking at line 14. Okay, well, we may have more. Where it says presiding officer explicitly based. And I've been raised to hate adverbs more than anything else in life. I would like to take out the word explicitly and just say based on the evidence presented. If I can get a second to that.
Second.
All right. So I make that motion to strike the word explicitly. All in favor, say aye.
Aye.
Any opposed? All right,
Chairman.
explicitly is
I
out.
just
Yes,
have
sir.
one question.
Senator Stanley.
I proposed an amendment which I believe will be a friendly amendment. It creates a rebuttable presumption, and I believe Dave Barry has it for you. Might give you a little, see if the patron.
Okay, do you want to report that amendment?
Yes, Mr. Chairman, on line 14, after the word hearing, there'd be a new sentence that says, For any decision on review brought pursuant to Section 2.2-4027, in which a hearing officer has made a recommendation to the department on a factual issue, a rebuttable presumption shall be created with respect to such facts, and the court shall give deference to such factual recommendations.
Okay, can I just ask before we vote on that, how's that different from the APA currently, Senator Stanley?
Mr. Chairman, I'd respond to your question by saying I think it's better laid out inside of that. While it may not differ, it certainly clears everything up, and there is not any question as to how much deference is given to the hearing examiner's findings.
Okay. All right, we've had a motion. I have a second. All right, this has to do with the rebuttal presumption of findings of fact. Senator Stan, you want to speak briefly to the motion since it's substantive?
Certainly, Mr. Chairman, just very briefly, what we're trying to do is, I think, set out that, right now, from the questions that you heard me ask, it doesn't matter what happens and goes on with the hearing examiner or what those findings are. The director can just make a finding, from what I understand all of this to be, willy-nilly and without any basis. In fact, I think what we're doing here is creating that work that was done at the trial level at the hearing examiner creates a rebuttable presumption of those factual findings and the determinations that are made. As we know in the law, a rebuttable presumption is that, rebuttable with facts itself.
Okay.
Question.
Senator Favola, have we voted on this amendment yet?
No.
No.
Okay, before we vote on the amendment, Senator Favola has a question.
Maybe one of the lawyers can address this, or maybe general counsel can, but can you please confirm for me that any administrative hearing process that would still exist as a result of this decision remains based on the information that we have before us?
Mr. Chairman, I'd answer the gentle lady by saying absolutely. Absolutely. It doesn't change the hearing structure. It's just after it occurs, and if there's another part of the process, that is given deference. That's the deference that has not been given in this case.
Right. Okay. Just for those of you that don't practice law, administrative proceedings are like any other trial. You got to put your evidence on before the hearing examiner. You can't bring up things afterwards. So. Okay, we have a motion, we have an amendment before us. All in favor say aye. Aye. Any opposed? All right, the bill has been amended. It's now before the committee.
I think, yeah, I will second that.
All right, I have a motion to report and I have a second. Clerk, open the roll.
Yeas 15, nays 0.
Pretty good on the dais, dude. I like that. Pretty sure.
See, Reeves, we're not so tough.
Oh, I have my seat made here for you.
All right, Senator Reeves, what do you got?
Mr. Chairman, I think we have one that came out here 7-7 the other day, so it's still in the body of the committee, and I'm not trying to beat up on DEQ. This was the bill that just was asking if we could take the 2-year inspection period for stormwater management ponds to 5 years to kind of help businesses with that process. It has nothing to do with the fee structure. They can still collect all their fees each and every year, but it's, in my opinion, and folks that I've talked to that have these and own businesses and properties and everything else, it's somewhat excessive. 5 was fine. You have to keep a bond in perpetuity as long as the property has a stormwater management pond. So if there was a pond that failed because we got 37 inches of rain one day and it washed out some structure, because all these ponds are made differently now to handle different aspects of water runoff and those sort of things, then that's there as well. All I'm trying to do is keep them going from every 2 years to 5 years. And that was the bill.
All right, we had this bill heard last week. It tied 7-7. I think we had a pretty robust debate. So if anybody has anything new to say on it.
Mr. Chairman.
Okay, Senator Favola.
I offer an amendment. Would you consider no more frequently than every 3 years? And that was.
Can we settle at 4?
I think 3 would be my comfortable.
All right, well.
I'd be fine with that. Every 2 years is just, Mr. Chairman, I would just tell you, somebody who has it, and I know Senator Stewart deals with this, with all the folks he has that he deals with, it's just, it's not a matter of paying the fees. And originally, some of those inspections were to help collect those fees. I don't think anybody has a problem with all the fees. It's just the inspections get relentless.
I need to have a motion from a member of the committee.
My motion was an amendment for every 3 years rather than 5.
Okay, so from 5 down to 3. Do we have a second?
Second.
Okay, we have a motion and a second to take it from 5 to 3. All in favor, say aye.
Aye.
Any opposed? Okay, the bill is now in front of us at 3 as opposed to 2.
Second.
All right, we have a motion and a second to report the bill. Clerk, open the roll.
Yeas 12, nays 2.
Thank you, Mr. Chairman.
All right. Next on the queue, I have Senator DeStef or Suravel. DeStef, there he is. Senator DeStef.
Mr. Chairman, we have two quick ones that, from the Menhaden Subcommittee.
All right, why don't we do, if it's a Menhaden report, let me hold on that. Suravel, is yours not as Menhaden? What's yours?
Chemical storage.
Wonderful, okay.
Mr. Chairman, you sure you don't want to do Menhaden?
Okay, why don't we do this? This may be as good a time as any to take up the Menhaden issue. So, Scott, this is going to be a while. So you go back to your meeting. We're going to probably take at least a half hour on this, probably more. All right, I know we had a Menhaden subcommittee put together, and that was Senator Mason that was in charge of that subcommittee. And so I'm going to turn it over to him to give a subcommittee report.
Thank you, Mr. Chairman. One point of order, can I roll in multiple bills at the same time, and do I have to do them individually?
You can do it
As a block. All right, Mr. Chairman, the Menhaden Subcommittee met. As you know, this has been a long-standing issue in the Commonwealth of Virginia, and all parties have come together and come to an agreement. And that was incorporated into Senator Lewis's bill. How about that? No, that's not good. So, Mr. Chairman, each patron was offered the opportunity to present their bill and/or to incorporate their bill into Senator Lewis's 791. Senator DeStef incorporated Senate Bill 157. He also incorporated Senate Bill 158. Senator Cosgrove, who's done years of work on this topic, incorporated Senate Bill 194. He also incorporated Senate Bill 357. Senator Hashmi, who's new to the issue, but was a catalyst in this effort, rolled her Senate Bill 402, and Senator Stewart, who has also done a mountain of work over the years on this topic, rolled his Senate Bill 1054 into Senator Lewis's 791. And unless Senator DeStef has something to say about that, I so move.
I did not want to roll 157 in, which pushes fishing for Menhaden outside of the Chesapeake Bay.
Well, that's what we did in the committee, sir, on a 3-0 vote.
Okay, hold on a second. Let's do this. So, Senator DeStef, we're not forcing you. If you want to keep 157 out, we can do that, and we'll take that up separately. But is there a motion to roll the other bills in?
There is.
Chairman.
I'm sorry,
Mr. Chairman, the
I'm sorry, I
committee
wanted
voted to
to
do
roll
that.
157, but not 158.
Okay, was Senate Bill 158 voted?
My committee report stands, Mr. Chairman. We
I-
rolled all of those bills in 3-0.
Okay, why don't we do this? Can we roll in a bill that the patron does not want to be rolled in? Typically, you do not. But we can just take it up in PBI, the bill, and then that's your right as a sponsor.
Happy to do it that way. I'd rather not roll in 158. 158 prohibits.
Okay, let's do this. 158 will stay out, but
Thank you.
otherwise.
So Senate Bill 157, 194, 357, 402, and 1054 rolled into Senator Lewis's bill 791 by a 3-0 vote. And Mr. Chairman, I so move.
Okay. All right, so we have a bill to roll all of these bills. We have a motion to roll all of these bills except 158 into this omnibus bill, which is Senate Bill 791. I have a motion and a second to do that. Clerk, open the roll. This is to roll in.
Yeas 14, nays 0.
Okay, 14-0, so they're all in. Go
Thank you,
ahead.
Mr. Chairman. The subcommittee also heard Senate Bill 222, Senator D-Steph's bill, and that I believe he amended to have a fine of $20,000 to $25,000.
$10,000, Mr. Chairman.
$10,000 if the terms were violated. The committee passed that bill by indefinitely on a 3-0 vote, Mr. Chairman, and I so move.
Okay. We have a motion and a second to pass by indefinitely. What's the number?
222.
222.
222, and since it's already been heard in subcommittee, we're not going to redo it all over again. One step ahead of me. Okay. And that's for PBI.
Now, Mr. Chairman, Senate Bill 158 that Senator D-Steph asked to be removed from the block, I believe prohibits fishing in the bay for these fish. You may give Senator, it's your prerogative for Senator D-Steph, but when you're ready, sir, I have a motion.
Okay, why don't we do this? It's not looking good, Senator D-Steph, but you're here and you have a right to speak to your bill, Senate Bill 158.
Well, thank you. I really appreciate the opportunity to speak to this. What we're trying to do is push the fishing for Menhaden outside the Chesapeake Bay. So we're pushing 3 miles outside of the Chesapeake Bay Bridge Tunnel, which puts you outside of the bay. That's a gentleman's agreement we had years and years ago that's been violated multiple times. When there's processing and fishing in the bay, we end up having cleanup at our hotels that are on the bay. And it's an expense to our fishermen. I'm sorry, it's an expense to our hotelers. And, you know, having little Johnny come out of the water in a white swimsuit that's no longer white is never a pleasure to mom. And again, nobody else in here gets calls. I get those calls. I get pictures, calls. Senator Frank Wagner used to get them as well. And that's why we had the gentleman's agreement that's been violated multiple times. So I thought it was time to codify it. And this was a perfect opportunity to do that.
Okay.
Mr. Chairman.
Senator Marston.
Senator DeSteph, it was presented to me that one of the difficulties that led to the violations this year was the fact that the ocean side, if you will, of the Bay Bridge Tunnel was too rough for too much of the season, and so therefore they chose to harvest further in, which again led to the violations.
Mr. Chairman, if I may answer that specifically.
Go ahead.
I'm
Yes,
happy
sir.
to, Senator Marston. In the Chesapeake Bay, when you have 8 large boats out there with purser nets, it's not too rough. These are large boats. And if you look back to not just the newspapers, but everything else, they violated the catch limit multiple times. So they overfished beyond their limit multiple times. That's why Senator Lewis and I had 250-plus people, fishermen, come in and talk to us at a town hall meeting on this. And, you know, when you overfish these, you have less dolphins in the bay, you have less bluefish, and it just really messes up everything. These are the bait fish for the entire fishing population in the whole ecosystem.
Okay, thank you. Just, I'm going to remind everyone, this was a subcommittee issue, so it's going to be a very abbreviated conversation.
Yeah,
Yes,
Mr. Chairman, so what you're saying here is that the rough oceans were no excuse to fish where they fished?
Mr. Chairman, Senator Morrison, absolutely.
Okay, thank you. Senator Lewis?
Mr. Chairman, just make an observation as to the bill. As somebody who's been wrestling with this oily little critter for about 17 years now, the fundamental thing we've been trying to accomplish was regulation by the VMRC. We put a period at the end of a very long sentence this year, and we have shifted the regulatory authority over to the VMRC. Right. And so what I would suggest is that we let the VMRC regulate, which is the argument that we have constantly made throughout this, and that any other bill now dealing with the regulation of, again, this slimy little critter is premature at best. And so with that, I would move that we already motioned on that?
I'll motion.
Go ahead.
Mr. Chairman, based upon Senator Lewis' comments and others, I move to pass by indefinitely.
Okay, we have a motion. Do I have a second? Second. I'll second it. Okay. All right, the bill's been motioned, and, the motion's been made and seconded to PBI, Senate bill. This is 158.
Mr. Chairman, members of the committee, thank you very much.
Thank you, Senator DeSteph.
And finally, Mr. Chairman, Senator Lewis carries the comprehensive bill that incorporates an agreement reached by the administration, by the industry, by the bait fishery groups, by the Chesapeake Bay Foundation and other significant organizations, including the sport fishermen who have been very vocal on the topic. And so if you'd like to give him just a couple of quick seconds, or I'll make a motion.
Actually, what I'd like to do, and this has been an issue we've had since I've been coming down here, which is almost 20 years now. Senator Lewis, why don't you go up and take the dais and just kind of walk us through the components of this bill we're going to vote on.
Thank you, Mr. Chairman.
And by the way, I'm not presuming any of this will pass. We got to speak to our audience and tell us what's going on, because this is a significant change in the policy of the Commonwealth.
Mr. Chairman, members of the committee, as Senator Mason said, you did a good job chairing this subcommittee. Kudos again to Senator Stewart, in line for the Nobel for 2020 for finally bringing this big shift in policy, as the chairman said about. It's a simple bill, Mr. Chairman, members of the committee, and the gravamen of it starts on page 8, line 205. And you can see that it shifts the regulatory authority over to the VMRC, and the commission should only adopt regulations for the management of the fishery between October 1 and December 31st, unless there's an emergency regulatory circumstance that requires intervention otherwise, and should work to ensure compliance with the ASMFC regulations. It also directs that the Commissioner of the Marine Resources will establish a Menhaden Advisory Commission, or committee, and it gives the makeup of that committee. And so we think we've got some safeguards in there as to when regulations shall be adopted for the industry. And again, Mr. Chairman, in my association with this, not as some of you may recall, 10, 12 years ago, I was on the other side of this issue, and it was on there for a number of years. But it finally occurred to me that if for no other reason than pure public trust, we had to shift this fishery from the only fishery we regulate, a part-time citizen legislature. We had to shift it over to the experts at the VMRC, where we have staff and that regulate every other fishery that we have. And so that's what this bill has done, Mr. Chairman. I want to thank sports fishermen. I want to thank the conservation industry, everybody in the administration especially who worked with Senator Stewart and the rest of us to get this across the finish line. That's the bill, Mr. Chairman.
Okay, thank you. Any questions for Senator Lewis? Okay, anybody here to speak in favor of the bill? Yes, sir. Mr. Secretary.
Chairman Peterson, members of the committee, Matt Strickler, Secretary of Natural Resources. Very briefly, we support the bill. It's a compromise that's been hammered out, as the senator said, over a long period of time. So, thank you.
Thank you, Matt. Yes, sir.
Mr. Chairman, members of the committee, Chris Moore, Chesapeake Bay Foundation. I want to thank all the parties who got this across the finish line. It's a great deal of work on everyone's part, and we support the bill.
Okay.
Mr. Chairman, members of the committee, Brian Hoffman, Deputy Director at Friends of the Rappahannock. You may know the Rappahannock River is where omega protein and a lot of this industry is located. We're in support of this bill. Thank you.
Yes, sir.
My name is Steve Carter Lovejoy with the Sierra Club, and we support this bill.
Thank you, Steve.
Mr. Chairman, members of the committee, my name is Jamie Bronco with the James River Association. We support the bill and also appreciate the work that everyone's put into this to get us this moment. Great job.
Okay.
Mr. Chairman, Mike Town, Virginia League of Conservation Voters. We support the bill. Thank you.
Mr. Chairman, members of the committee, Nikki Rovner, the Nature Conservancy supports this bill.
Thank you.
Mr. Chairman, Pat Calvert, Virginia Conservation Network. We also support this bill.
Thank you, Pat.
Mr. Chairman, Mark Bowles, representing Omega Protein, and we support this bill.
The lion shall lie down with the lamb. Okay. The 7 signs of the apocalypse. Okay.
Mr. Chairman, members of the committee, A.J. Erskine, representing 2 bait fish companies in Virginia. We pack fish for watermen and crabbers, and we grind chum for sport fishermen. We support the bill. Thank you.
Okay.
Thank you. Mr. Chairman, Steve Atkinson, Virginia Saltwater Sports Fishing Association, and we strongly support this bill. Thank you.
Great.
Mr. Chairman, if I could also say that Doris Kraus-Mays, on behalf of the AFL-CIO, spoke in the subcommittee in support of the bill.
Yep. Senator Morrissey.
Mr. Chair, I would just say that having sat next to Senator Lewis a dozen years ago when he was trying to push this, I just want to say, couldn't you get a little support for your bill today?
Yeah.
Couldn't you line up a little more support? Congratulations.
I tried to get the Farm Bureau on board, but they wouldn't come.
Congratulations. Congratulations on moving this bill along. It took a long time.
Too. Yep. You can vote. Senator Stewart.
Thank you, Mr. Chairman. Senator Lewis, thank you. And I also want to I think it's important to thank the administration Those of us who have been around here for a while knows that the governor worked on this issue since he and I came in.
Absolutely.
Senator Peterson together, we found ourselves on opposite sides of that issue for 12 years. But we've come to a global agreement here, but I want to thank him. I want to thank the governor. There were a lot of people who really resisted this going to VMRC because they thought perhaps there was going to be some nefarious purpose or nefarious action with VMRC to injure this industry. And I think it was the governor's assurances, at least with me, and he's a man of his word, and I take him at his word, that he wouldn't allow that to happen. So I think that was a big part of this whole deal. The General Assembly, as I understand it, has retained the area where the fishing can occur versus going to VMRC, which was another important part of this deal. And everybody did a heck of a job, Senator Lewis, for bringing this together, and I move to report the bill.
All right, thank you. And before we get to the vote, I just want to also say, do we need any amendments? Oh, for God's sake.
Oh, my God.
Okay. All right, well, hold on. Let me just say, I went to Senator Mason actually 2 months ago when we were in Harrisonburg, and I asked him to take on this issue, and I knew this was going to be a huge issue. And he did a wonderful job of steering the ship. And I want to thank all of the senators that participated. This is a chance where we actually came together and got something done. And so, having said that, I'm going to support the motion. Clerk, open the roll. And that's refer to finance.
Thank the committee.
Yeas 14, nays 0.
All right. Okay, before we get to, yeah, all right, let me do this. Is Suravel back? I chased him out. Okay, all right, why don't we do this? I want to get to the nutrient bill last. Okay, if you got a simple bill, go forward. Senator Stewart. Well, all right. All right.
Mr. Chairman, members of the committee, I've actually got two bills. Let me call Senate Bill 1064 first, because there are folks here from the city of Richmond that have been waiting to hear this bill. And I'm going to be brief on this. I'm working with the folks at the city of Richmond to try to come up with something that may be palatable to everybody. And so even if the bill is not as you like it today, I'm hoping everybody will consider moving this forward in the process so that we can continue to work together, because it's important that we fix this in a timely manner. The issue here is the combined sewer overflow for the city of Richmond. Actually, it's about 20-some overflows that discharge into the James River. And over the past 5 years, we got about an average of 2 billion gallons of raw sewage going into the James River untreated. Now, there's a reason for that, and that's when we have rain and their system can't handle it, the stormwater mixes with their sewer system, and that's why they call it a combined sewer overflow. We dealt with this issue with Alexandria a few years ago, and we all worked together and we came up with a solution. We've since put money in the budget for Alexandria to help them fix theirs, although they're bearing the brunt of the burden, I suspect. And I have committed, if we can move this forward, to do the same thing for the city of Richmond, to try to help them get money to do this, because it's a big project, quite frankly. And this thing didn't just happen yesterday. It's evolved over years. But if you look at the report from DEQ, 2018 was the worst year. It was almost 3.4 billion gallons of raw sewage went into the James River. And in the years surrounding that...
What was that number?
3.4 billion. I've got the numbers, actually, if you want them. 2019 was about 2 billion. I don't have the exact number. 2018 was 3.335 billion. 2017 was 1.668 billion. 2016 was 1.961 billion. 2015 was 2.682 billion. 2014, did I say 2015? 2014 was 1.804 billion. So roughly, we're looking at about 13 billion gallons of raw sewage going into the James River over the last 5 years. And that affects everybody. And the city doesn't want this to happen. They have been crippled by the cost of fixing this thing, and I acknowledge that, and we've had that discussion. And I'm not here to be difficult for them. I'm actually here to try to help them so we can get this thing fixed, because, I mean, it truly is a public health crisis. And not only does it affect the people in the city of Richmond and the neighboring areas, all that flows to Hampton Roads, and it settles in James City and the lower bay and the eastern shore like a giant septic tank. And it affects, you want to talk about catching menhaden out of the lower bay. Wait till you see this stuff floating down there, because I have fishing down there. And so what my bill does, it gives them 5 years for DEQ to identify how to fix the problem, and then it gives them 2 years to construct it. That 2 years is not realistic, and I know that. But that ultimately was the compromise we came up with Alexandria. So I started in the same place. This is a much bigger project. It's going to cost more money. I think we talked yesterday, I think it was 21. They've got 21 outfalls, and some of those are worse than others that need to be fixed. But it's a big thing, so I expect we're going to need more time. But what I'm asking the committee to do is to move the bill along through the process. Let me continue working with the city, because here's what I want to happen. Right now, the way this thing is done is they identify, something that they can do, and they find a little bit of money, and they fix a little piece. And this has been going on for a long time, and they are currently under no time limits whatsoever. I mean, this could continue for another 100 years. They are under consent decree with the EPA. The problem is Trump has relaxed all of the regulations in this area, and they can go back and renegotiate. I don't know why they would, because they don't have any timeline now, but actually the restrictions could be loosened even more. And so what I want is to come up with a timeline that works, that gets this thing done. And what concerns me a little bit, I will be honest with you, is I'm aware that Mayor Stoney's done his budget for 2020, and out of that budget, there's only $4 million for wastewater treatment and $2.3 million to address the combined sewer overflows. And what I want to do is get them serious about this and get on a fast track, and let's work together to get this done. So that's my bill, and I suspect there are people who'd like to speak. I don't know if there's anybody in support of it, but certainly those who might have concerns.
Mr. Chairman, may I ask a question? I know we all want clean river, and that's very important to all of us, especially those of us who live in the city and downstream from it. But I do know that the projected cost on doing the cleanup and doing this work is fairly large for a city that is facing severe budget issues. I was just curious, is the city meeting its compliance for federal standards at this point? Is it meeting the requirements of its permits, or has it fallen out of compliance?
Well, let me see how I answer that. They are in compliance with their consent decree, and so they are not complying with the Clean Water Act, as it were. And so what they did was they entered into a consent decree with the Environmental Protection Agency because they couldn't comply with it, and were able to get this relaxed compliance. Does that answer your question? And
yeah.
Dave Paler's here. He knows, he's
Maybe we
forgotten
could-
more about this than I have,
Yeah.
but that's the upshot of it. They haven't been able to comply, so they got a relaxed standard, and currently they have no timeline. They could continue to dump 2 billion gallons a year of raw sewage in the river for the next 100 foreseeable years.
Perhaps we could hear from DEQ.
All right, why don't we do this? Do you have anybody in support of your bill?
I didn't ask anybody to speak.
Okay, well.
But there may be,
All right.
yes.
Oh, my gosh, okay.
And I'm just going to
Citizen.
say, this came up actually from my constituents who called these episodes in the James River brownouts. And they have to pay attention when there's rain to see if they can go use their kayaks in the James River or swim in certain areas because the bacteria count is so high. And there's a website in Richmond that's actually watched so we can determine what the bacterial count is so that people don't jeopardize their health to go swimming in the mighty James.
Doctor,
So,
can I ask a question?
yes, sir.
Where is the point source? Where is it actually coming into the river?
There are a multitude of outlets into the river. Are there 12, 27, 21? There are a multitude of outlets, and they are marked on a map on the website that shows you where the high danger areas are. But some of the places like Pony Pasture, where our kids go swim all the time, is one of the areas that's affected. And down where all of the traffic is in the new building, all I can think of is Reed's Landing, but that's not it. But so it's up and down the James in all these different areas that it flows out of.
Thank you. Okay. Any other people here to speak in support, spontaneously or by planning? Yes, Peggy.
Spontaneously, Mr. Chairman.
Thank you.
Peggy Sanner, Chesapeake Bay Foundation. I appreciate today, as I have in the past, the effort that have been made by Senator Stewart and Senator Survell with respect to Alexandria. His concern about the CSO in both of these cities and elsewhere is real and appropriate. As I've told him, we support ensuring that our waterways are free from feces of all sorts. And so that, on that basis, we support this bill, but we do so with the caveat that what he has said today about the very high cost, what Senator Hashmi has mentioned about the difficulties experienced by the cities, all of those should be taken into account to ensure that the city is not burdened. We happen to know that the city has been working on its water quality in many important ways, in a very serious way over the last 5 years. So it's an important effort, but it's not, the city should be taken into account. Thank you.
Yes, thank you, Peggy. Okay, anybody else want to speak in support?
Yes. Good afternoon again. My name is Jamie Bronco, James River Association. I have a statement as well that we can pass around
Sure.
to committee members, but I'll just be brief and echo what Peggy's already said. This is a really critical issue for the James River Association. We care about the combined sewer system, and we want to see that is resolved so that it's safe to recreate in the river and folks can enjoy the James. We acknowledge that the city has done a lot of work to that end, and we have been a partner with them for decades in that effort. And before learning of this bill, we have been talking with the city about pursuing some legislation and specifically some funding to help with this problem in the next session. So we appreciate Senator Stewart's work on this, and we would like to have a seat at the table and work on this next year and hope to get a specific timeline in place and some resources to help the city with this real serious problem.
Okay, hold on one
Mr.
second.
Chairman.
Let me get, I got Senator Pillion first in the line here. Go ahead.
Does the administration have a position on this bill? Because I know they're certainly concerned.
Administration. Matt?
I'm sorry, I didn't hear the question from the senator.
Do you have a position on this bill? Because I know you're concerned for the Chesapeake Bay.
Quickly, yes, sir. Thank you for the question, Mr. Chairman. We certainly understand that combined sewer overflows are a water quality concern. We support efforts that Richmond and Senator Stewart and others are working to address those serious concerns and hopefully do so in a more timely manner potentially than is contemplated under the consent order.
So just to follow up, Mr. Chairman.
Yes, go ahead, Senator Billion.
That is you are in support of the bill?
No, sir. That's not what I said. We have no position on the legislation itself.
Okay.
Okay.
Is it strongly neutral?
That's fair. I don't think the. If I can just clarify my statement quickly, the timeline in the bill is something that the senator and I have spoken about. It's a pretty tight timeline. I think given the challenges that Richmond faces in a multitude of areas, it's a timeline that's probably we need to consider and is a little too tight.
Okay, that's helpful. Thank you. Senator Morrissey.
Senator Strickler, if I could ask you a couple of questions.
Give me a promotion, huh?
Commissioner, excuse me.
Well, I'll take that too.
Senator Stewart said that in the last 5 years, there's been over 13 billion gallons of raw sewage. Do you agree that's because of the combined sewage overflow that has been deposited into America's first river? Do you agree with that estimate?
Mr. Chairman, Senator, thank you for the question. I don't have the numbers right at my fingertips. I don't believe that Senator Stewart would present a number that wasn't accurate, but if DEQ could come up and maybe they could give you the real
Follow-up
answer.
question.
Senator from Morrissey.
I got to tell you, both of us represent the city of Richmond. Senator McCollum does as well. And I am aware of these brownouts. That's a very kind and generous word to be used, because I'm out there on the weekends with my 4 little babies, skiing and tubing, and it is disgraceful. What more important thing does the administration have to do than take care of that raw sewage, that fecal material that is being dumped into, Senator Donovan called it America's great river, the mighty James. It's America's first river. What more do we need to show you so that you can move from strongly neutral to 100% on board?
Mr. Chairman, Senator Marcy, thank you for the question. I think what I would like to do is kind of put this in perspective. The issue with the whole Chesapeake Bay cleanup is we have a ton of problems with sediment, nutrients, bacteria, pollution going into the bay. These acute issues of combined sewer overflows are serious issues. They're public health issues and ones that we need to and would like to put more emphasis on, and certainly, as I said, look forward to working together on that. As far as the things that we have, through our scientific evaluation, shown that are the most important things to do to restore the Chesapeake Bay, these are not ones that rise to the top of the list based on their overall contribution. So what that does is I'm just trying to frame it and put it in perspective of the multitude of other factors that are bigger contributors of pollutants to the Chesapeake Bay. Now, certainly in the acute circumstance with respect to these brownouts or whatever you want to call them, that's a challenge that we certainly need to address. And like I said, look forward to working with the committee and the city to do that.
All right,
Mr. Chairman,
thank you, Mr. Secretary.
before he leaves,
Senator Obenshain.
Later, we're going to deal with nutrients coming off of farmland. How does the quantity of effluent that's coming out of these point source discharges and going straight into the Chesapeake Bay compare with the nutrients coming off of farms in the Shenandoah Valley? Is it more or less?
Mr. Secretary, go ahead.
Mr. Chairman, Senator Obenshain, thank you for the question. And that's the point that I was trying to make, so I appreciate you asking me that directly. These discharges pale in comparison to the contributions of non-point source agricultural pollution.
Okay. All right, why don't we do this?
Really?
Oh, well, hold on, guys. All right, this is not a debate right now. Hold on one second. Do we have any people?
I would like to see that data, though.
1 second, Senator. Do we have any people that have a differing position on this bill other than?
Mr. Chairman, I think the city needs to speak.
Well, that's why I'm asking. So come forward, representative of the city or any other group that wants to speak on this bill and hasn't spoken yet. Yes, please.
Mr. Chairman, Ron Jordan representing the city. I'd like to introduce Calvin Farr, our Director of Public Utilities. He'll take about 5 minutes and give you the big picture.
You know what, take your time. We're not going to put you on the clock yet.
Okay. Good afternoon, everybody. Yeah, I'm the guy that has to get it done, so definitely we oppose this bill as written, but we do not oppose the spirit of the bill. We are trying our best to clean up this river and do our part. And I just want to repeat that we don't oppose the spirit of it. The challenge is the timeline.
Hold on 1 second, sir. Could I please have attention to the speaker? Could I please have attention to the speaker? Proceed, sir.
Yeah, so the concern really is the timeline, all right? So we talk about billions of gallons of overflows. We got to recognize there's a decrease in those billions. The system was created to actually discharge billions 100 years ago. So it takes a while, it takes a long time to get it done. So we've been at it for a number of decades now. We've spent $315 million. We're seeing a lot of good results. We have probably over 400 more million to spend, including in these improvements. The wastewater treatment plant, we've invested $120 million there, and we are increasing our capacity, meaning that about 550 million gallons per year will not hit the James River. We have, and there's a lot of quotes about the number of outfalls, but so we have 25 active, but we've eliminated, we had 46, eliminated 21. We're going to reduce overflow events by 42%, and we have increased our combined volume captured and treated to 91% capture. So, I mean, I appreciate meeting with Senator Stewart. It was a good meeting. Definitely, we can work together on the wording of the bill. I'm not completely against defining a timeline, but it is difficult to define a timeline. So our challenge here in the city is most of the costs are on our ratepayers, and we have a quarter of our folks at poverty level. So it's really hard to, increase rates drastically. So our goal really is to modestly increase rates over time, so where it's affordable to our folks at low income. So that's the challenge. To spend that kind of money in 7 years, it's nearly impossible. So, but those are my comments. Right now, we have a snapshot of our CSO program. It's really a snapshot in the middle of it. So, of course, you'll probably see the results you don't want to see right now, but we've made drastic improvements over a number of years.
Mr. Director, I'm going to ask you a question. Probably other people would ask the same. At the rate you're going now, at what point would you have this situation solved?
Can't answer that question right now. I can tell you how much we can estimate. Another thing we have to do is we have to continue to evaluate what we planned on doing. So if we had a plan 15 years ago, does that plan still hold? So as we're moving through the CSO program, water quality standards get stricter. So we have to build in for that too. So right now, we're actually in the middle of reevaluating some recommendations we plan on doing to see if we can do some other things to kind of speed it up and improve water quality. So at this moment, I can't really answer that question. We have a number of dynamics here. So say you give me the $400 million right now. I'm not confident it can be spent in 7 years. There's doing a lot of specialty work, and it's not a matter of just digging up pipes and putting in new pipes. It's a specialty type work. So the contracting base is really not there to even do that kind of work in an accelerated manner. So, and it's a number of other factors, the affordability issue, and things of that nature.
All right.
Mr. Chairman.
Let me get, I think Morrissey was in first, but Senator Morrissey and then Senator Favola.
Thank you, Mr. Chair. Mr. Director, I got your first name, it was Calvin, but I didn't get your last name, sir.
Yeah, Farr, Calvin Farr, F-A-R-R. Yes, sir.
Right. Now, when you say that you oppose the bill, but you don't oppose the spirit of the bill, I don't quite understand what you mean. Does that mean you don't have the money?
So the when I quoted $425 million to continue with the program, I'm not against spending that money. It's the acceleration of spending $425 million. And what I see, 5-year, determine what the issue is and construct it in 2 years, it's impossible. I mean, get an environmental permit on a certain project may take 2 years to get. So it's not a matter of balking at the price tag on it. It's just needs some time. It's not practical.
Further question, Mr. Chair.
Senator Morrissey.
You stated that with some of the monies that you've spent, were successful in preventing 550 million gallons from entering the James River.
Yes, we will, yes.
The number that we heard, though, is 13 billion have reached it, so that's 1/26th of the raw sewage that's entering.
So we have to look at the data. So you could say over time it's 13 billion, but you can also see that it's reduced over a number of years too.
All right, further question.
Senator Morrissey.
Well, we're looking at, I'm sorry to cut you off, but the last year's 2 million, or 2 billion. Before that was a little more. So next year it could be 1.5, could be 1 billion. I mean, we're talking about billions of gallons, so it's not going to go to zero within a year or two.
Well, what troubles me is that the figures that we have is 1.8 billion in 14, went up to 2.6 billion in 15, then 3.4 billion in 2018. So we're going in the wrong direction, aren't we?
Well, Mother Nature didn't help us in 2018. 62 inches of rainfall compared to our usual 42.
Further question.
Senator Morrissey.
Several years ago, I introduced a bill and was successful in getting point source introduction of nitrogen prevented from going into the river. And it wasn't difficult. I mean, it was a little difficult with a Republican-controlled House. We got it in. I feel almost like I have done nothing when I was prevented nitrogen from getting into the James River. I want to work on preventing phosphorus from getting in, and then we hear billions of gallons of raw sewage. Here's my question. What possibly could be a greater priority than preventing this sewage in?
Okay. First, you shouldn't feel bad. We've reduced phosphorus and nitrogen.
We have.
Quite a bit. We can get those results to you. To even kind of insinuate that it's not a priority for us is not true. Clearly, it's a priority. It's a struggle getting the revenue we need in to cover those costs, and that's the situation, and it takes time to do it.
Okay. One final question.
Senator
I heard
Morrissey.
that the patrons say that he found money, state money for the city of Alexandria, and seemed to indicate that he would be willing to find money for Richmond. But I think what was unstated but was implied was that we need some cooperation from Richmond as well.
Absolutely.
I see Mr. Jordan working, Ron walking closer to the microphone.
All right.
I think it's a matter of scale. I think the money that was available for Alexandria is about 40 million, somewhere in there, 20 million.
I think it's 25 and 8.
25. We're talking hundreds of millions here is what the need is. And something that Mr. Farr hadn't mentioned yet, Richmond already has the highest wastewater treatment rates in the state, in a city with 25% poverty rate. So that's part of the challenge in putting this on the ratepayers. I think our concern, and we've talked to the senator about this, and we're going to have these conversations with the senator no matter what the outcome of the bill here today, is the timeline, and we can certainly work with the senator on that. But in order to advance the timeline, we need substantial state assistance. And we're talking hundreds of millions of dollars here, not 40, or the last time the state assisted the city was with about 60 million, and that's been 6 years ago, I believe.
All right, Senator Favola.
Thank you. Thank you for coming. And we appreciate the challenge ahead, and I think everybody agrees that this is a problem that we need to act on. I guess this is a Section 1 bill, so it's directing, the Department of Environmental Quality to work with the city. But I guess, Mr. Farr, could you produce a plan by July 1st, 2021, which would, be a year from this July, that really lays out how you can get to cleaning up the James River to reach an appropriate level that would always be swimmable and available for recreation and other purposes, because we need a detailed plan, both with steps and costs. I'm a little nervous about moving forward with something before we have a plan from the city, but I want to hold the city to a deadline for that plan.
Yeah.
Would be my interest.
Okay.
Go ahead, Mr. Farr.
So just please don't hold me to that date. We have to figure out what it would consist of. So I know that's not the answer you quite want to hear, so I can't just say in 18 months we'll have a plan. But it's safe to say I'm not going to tell you it's going to take us 3 years to come up with a plan. So we're going to be aggressive about determining this plan and getting with the senator and going forward.
Okay. We've been going a while here, folks. What I'd like to do is, I think we've had pretty robust discussion on this. We act on a motion.
Mr. Chairman, I have another.
If I may, just very briefly, Calvin and I had a really good meeting, and I think we made a lot of progress in that meeting. So what my bill currently says is they've got 5 years to identify this and come up, and then 2 years for construction. So we know that's unrealistic. Calvin's been working, trying to figure out what they can do, and then I met with more folks today. And I do believe they want to do this. How do I say this? I trust Calvin. But there are people who Calvin works for that might drag their feet. And so what I'd like to do is keep the bill in its fashion. Let me continue to work with him to come up with a more realistic timeline as we move this thing through the process.
All right.
I guess that's the way I would say it.
Okay, well,
Mr. Chair.
yeah, let me make an obvious point. This is a Section 1 bill, okay?
That's right, yeah.
So it's not going into the state code.
No.
And obviously, we've got a few miles to go before we sleep. Senator Marston, do you have a point you want to make?
Just very quickly, as I trust Senator Stewart, this scared the heck out of me with Alexandria with the timeframes, but he said, don't worry about that. You know, we're trying to work this, just keep this in progress and keep it moving. I think that's what has been the result in Alexandria, and although this is a different and larger problem, I would move that we report the bill.
Okay, I got a motion to report.
And send to finance, excuse me.
Mr. Chairman, one other comment.
Okay, well, let me, Section 1 bill goes to finance?
No, why would it go, no?
It doesn't need to go to finance.
Right.
There's going to be, I mean, I will tell you that I plan on putting a budget amendment in very soon for the city to work on this,
Mr.
but
Chairman.
that'll go to
All right,
finance.
hold on one second. I had a motion, I never got a second for it. All right, I have a motion and a second to report the bill. If you have a comment about the reporting of the bill,
That's my comment.
all right, Senator Favola, then to Senator Hanger. Senator Favola.
I am cautiously going to vote for this, but under the expectation you will continue to work with the city and be able to come up with a more realistic timeline. I mean, that's what really has me bothered. Maybe by the time this gets to the floor or out of finance, you'll have a more reasonable timeline. Is that fair?
Yes, Mr. Chairman, Senator Favola, that's my goal, and that's what I've discussed with the city and specifically Calvin. But my concern is that if we don't keep pressure on this, some folks in the city will relax, not Calvin, because I believe he and I are going to be able to work through. I think we can work through this, but if we don't keep the pressure on, some other folks may relax on this.
All right, I got last comment by Senator Hanger, and then we're going to vote.
Thank you, Mr. Chairman. Just a quick comment on why it needs to go to finance. We've been dealing with Richmond combined sewer overflows and Lynchburg for a number of years. My figures, we've spent $51 million in Lynchburg. The state has $69 million in Richmond. We put $25 million into Alexandria already, and we've got a request for $65 million this year. So when we say you're going to do something, there are cost implications for the whole state if we're really going to make it happen.
Understood. Okay. All right, we have a motion before the body. Clerk, open the roll.
Yeas 13, nays 2.
Thank you, Mr. Chairman. Members, do you want me to do my other bill, or you want me to sit down?
You know, I got Senator Suravel here, and so,
Thank you. I have one easy one and one complicated one.
okay, Senator Suravel, why don't we take the easy one first?
Easy one is 646, and there's a sub on that, which is a lot bigger than it needs to be.
Okay, Senate Bill 646.
No, it amends a really long code section that has lots of words I'm not touching in it. Staff has been doing an excellent job. Now that they can collectively bargain, I'm expecting them to negotiate combat pay.
You'll represent them, right?
Yeah, happily.
Senate Bill 646.
Could I get a cup? I gave away my copy.
I don't see 646 on the docket.
It was THC docket. It was the hemp docket.
Okay. All right, did this go through HEP subcommittee?
Yeah.
All right. Well, what we've been doing is when something went through a subcommittee, I let the subcommittee chair discuss what was done, and then.
Although I'm not sure he's even seen this sub before. Yeah.
I talked to him about it.
Well, why don't we at least let him say what was reported, and then you can tell us what you got.
Okay.
Go ahead, Joe.
Did you like it?
I don't think he heard you.
Senator.
Coffee, thanks.
Morrissey.
Oh,
It says 646.
okay, hold on. Excuse me, I was. All right, Mr. Chair, members of the committee, I have learned more about tetrahydrocannabinol in the last couple of weeks than I ever thought I would need to know. But this bill that was patroned by Senator Survell changed will change the concentration, if I have this correctly. The gist of this, the problem with this bill is the concentration of tetrahydrocannabinol in the THC determining, certain testing. And I think, if I have this correctly, Senator Survell, we need to change the concentration level. Is that right? And the committee was in support of that?
Close, yeah.
All right.
What action did your committee take, Senator Morrison?
To report it.
Okay.
Unanimously.
All right, so that was what was presented in the sub. Senator Survell, what's different now in this substitute?
I think there's like a hemp coalition or something, and there was a U.S. Department of Agriculture regs that were pending in a comment period, and there was some further discussion about exactly how to do this to make sure we don't criminalize the growing of hemp. And so DFS has been working with those stakeholders to come up with a definition that appropriately carves out agricultural hemp from THC, or from marijuana, so we don't end up prosecuting hemp growers as marijuana growers.
Okay.
And the sub, I think, presents peace in the valley on that by specifically defining hemp as having a specific concentration of what's called delta-9 tetrahydrocannabinol, which is the psychoactive content of THC.
All right, why don't I just cut right to the chase? Is there anybody opposed to this bill? It was reported from subcommittee unanimously. You have a substitute.
Second.
Okay.
Whoa.
Okay, hold on a
I
second.
got to adopt the sub first.
We got to adopt the sub, and then I see a young lady standing behind you, too.
She's with DFS.
Okay, can I have a motion to adopt the substitute? Someone, second. All right, all in favor of adopting the substitute, say aye. Aye. All right, before we get to a motion on the underlying bill, is there anyone that has a position on this bill that needs to be heard?
Mr. Chairman.
Yes,
State
Senator
Police-
Obenshain.
State Police okay with this?
Yeah, the Department of Forensic Science does the testing for them, and they're the ones that requested it's an agency bill.
Okay, all right. So
And it also has an emergency clause, I would note, because there's some clever criminal defense lawyers like Stanley that could actually win cases right now if he read this carefully.
He needs a win, okay. All right, Senator Morrissey.
Senator Survell, I'm looking at my notes in the subcommittee, and if I'm correct, the administration, Kyle Schriever, the executive director of Virginia Agribusiness Council, Martha Moore with the Farm Bureau, the hemp food industry, were people that participated in the discussion and are in support thereof?
I think so. I don't know. Well, they weren't at the committee. They weren't at the subcommittee. Yeah, they weren't at the subcommittee.
Okay, I think everyone's in support on this. Okay, look, let's get moving. So we have a motion and a second to report the bill. Clerk, open the roll. Anybody have Pillion's proxy? All right. Here you go, okay.
Yeas 14, nays 0.
All right, congratulations, Senator Surville. On to the next one.
Great. Okay, so the next one has to do with above-ground chemical storage regulation. There's a sub for that.
Move substitute.
Second. Motion second to adopt the substitute. All in favor, say aye. Aye. Any opposed? Okay, substitute is in front of us.
Thank you, Mr. Chairman. So this bill has to do with the regulation of above-ground chemical tank storage. Right now, we have regulation of below-ground chemical tank storage, and we have regulation of petroleum above ground because of the Mantua disaster that I think Mr. Chairman's familiar with.
Very familiar.
But we don't have regulation of other chemicals that are stored above ground. In 2015, Senator Watkins put in a Section 1 bill asking DEQ to study this problem. And there was a stakeholder process which resulted in the publishing of a 28-page report which has just a series of recommendations, two of which I'll point out. Number one is DEQ, or the stakeholders wrote, a key step in the development of more comprehensive chemical storage in Virginia would include a framework for inventorying and registering a defined universe of chemical storage facilities and the inventory of materials in Virginia. Because by creating an inventory of what's there and where it is, then we would know how to regulate it. And it also recommended to clarify targets, the basis for regulation, the type of regulation, and they talked about specified chemicals. And just to have an understanding of what we're talking about in terms of the chemicals that are in play here, we're talking about things like formaldehyde, urethane, nitroglycerin, strychnine, carbol, chloroform, acetone, vinyl chloride, benzene, trioethylene, all kinds of nasty stuff. So what the bill does is it directs the State Water Control Board to regulate this above-ground storage of tanks that measure more than 5,000 gallons. And that 5,000 gallons was a compromise. The original bill you had in front of you was 1,320 gallons. 1,320 gallons is maybe at the size of 2 sofas. Just so you understand what 5,000 gallons is, that's 24 cubic yards, or I went on the internet and found out it's a pool. It's about 10 foot by 10 foot by 6 foot deep, just to give you an idea how big of a tank we're talking with 5,000 gallons. The bill directs the State Water Quality Board to adopt regs that establish requirements for the registration, certification, inspection, and other requirements for the tank owners and a schedule of fees that covers the expense for DEQ's expenses and all that. So the bill is, I think, revenue neutral. It also requires tank owners to register their tanks, pay the fees, develop a release response plan, so a discharge response plan, so that in case some of this stuff gets out, they have a plan in place to deal with it. It requires them to upgrade certain older tanks, install containment infrastructure, and has certain notification responsibilities, and demonstrate financial responsibility, which is something we do on all of our other types of regulations like this. And it creates a hazardous substance above-ground storage fund to administer these fees. It also provides for civil and criminal penalties associated with violations, and fines would go to the Virginia Environmental Emergency Response Fund. The bill excludes any kind of activities associated with farms. That was one of the original, another negotiation. The original bill did not. We put that in the substitute, so farms are out. And just to have an idea of what we're aiming at, there was a spill a couple of years ago at Tinker Creek, which resulted in Roanoke, Benton area, which resulted in Tinker Creek getting seriously spoiled and thousands of fish got killed. West Virginia also adopted regulations similar to this after there was a spill in West Virginia which ruined drinking water for a pretty significantly sized city for about 2 weeks. And that's why we need to have these kinds of rules to make sure that our drinking water isn't destroyed and fish and people aren't killed and hurt and stuff. So that's basically what the bill does.
Okay, thank you for that summary. Do we have anyone here to speak in support of Senate Bill 626? Come forward.
Mr. Chairman, members of the committee, thank you. My name is David Flores.
And let me just begin by saying we're going to do a 5-minute clock on this just from now on.
Understood. Yep.
Yep, go ahead.
My name is David Flores. I'm with the Center for Progressive Reform. For 30 years now, the state of Virginia has had laws on the books regulating oil and gas tanks, safeguarding public safety, health, land and water resources from spills from these tanks. And the industry in the Commonwealth in that time has adapted and has continued to thrive. Why not, since then, have there not been hazardous chemical regulations preventing chemical disasters? The patrons and proponents of Senate Bill 626 have collaborated with several members of industry, as Senator Surville mentioned, including the Farm Bureau, American Electric Power, and the DEQ to respond to their concerns by making sensible revisions to this bill before the committee. The bill provides a critical safeguard against chemical disaster and harm to drinking water by requiring registration, spill prevention, and response for tanks that store hazardous chemicals. There's no federal law on chemical tank spill prevention. Although Virginia has comprehensive laws for oil tanks, again, has no law on these hazardous chemicals. More than a dozen other states, as was mentioned, West Virginia, but also Pennsylvania and Delaware have adopted state regulatory programs for these hazardous chemical tanks. Our bill is modeled off of the best elements of those programs and also takes account for flaws or weaknesses with those programs as well. You may hear opposition from industry who are limited in number, but do not be persuaded. The opponents want an open-ended study bill, lacking regulatory authority and registration of tanks. But the General Assembly has already passed a study bill on this issue in 2015, which was patroned by former Republican Senator John Watkins. DEQ has already conducted that study on the need for tank registration and regulations. Senate Bill 626 is the next step for this legislature in protecting Virginians from hazardous chemical spills. You may also hear from industry the claim that these regulations would cost billions of dollars. But the industry has not offered any evidence to support this claim. In fact, this bill proposes a number of modest fees for inspection and registration. Inspections, for example, based upon information we learned from West Virginia, could cost anywhere from $500 to $1,500.
Sir, just to interrupt you, you're halfway through the time for your advocacy, so just, you got others behind you.
Oh, I'm sorry. I thought it was 5
Well,
minutes.
why don't you just wrap up and then we'll get to just, do you have a summary sentence?
No, I'll pass it on.
Okay, thank you, sir.
Good afternoon. Again, my name is Jamie Bronca with the James River Association. We support this bill. We ask that you move this on out of committee. This is an issue that we have a very strong connection to for many years. You heard about the spill in West Virginia. There have been spills around the country. There's a spill in Delaware. The commonality between the spills in West Virginia and Delaware is we had these horrible spills, and then the states went to create comprehensive regulations to understand where these things are located and how we can prevent the spills. We don't want to wait for a spill to happen in Virginia. In many cases, the substances we're talking about in these tanks are far more concerning, far more toxic than oil or gas. This is a compromise bill. It's something we've been working at for years. The General Assembly already voted unanimously that this was an issue of great importance in 2015. We believe this bill picks up where we left off with that study and makes a great path forward for us to address chemicals and prevent
Mr.
spills.
Chairman.
Thank you.
Okay, gentlemen, okay, sir, suspend the time. Yeah, go ahead.
You said that this was a compromise bill. Was industry brought into the compromise?
Yes, as Senator Surville mentioned, we've been talking to the Farm Bureau. We've been talking to Appalachian Power. We've gotten a lot of feedback from DEQ as far as making sure this is a program that will work for them, that they can implement. And we've been in ongoing conversations with the Virginia manufacturers. And the number that you see in the bill, 5,000, that is significantly higher as a threshold for regulation than what was originally in there and what you see in other state programs. Oil is 1,320. We've raised that up to 5,000 as a way to work with industry and address their concerns, so not as many tanks are as addressed. And we're open to continuing these conversations with Surville's lead to make sure.
Mr. Chairman, my question was industry. You mentioned Farm Bureau and DEQ. They are not industry.
All right. Okay, why don't we do this? Let's just get through the speakers, and then I'm going to open up. Well, obviously, we have people in opposed, and then we're going to do questions. All right, go ahead. I think there's at least 2 minutes left. Proceed.
Good afternoon. I'm Noah Sachs. I'm a professor of environmental law at University of Richmond, speaking here in my personal capacity. And I've been in support of this bill for a long time. I've been working on these issues really since the 2014 tank spill in West Virginia, where a tank corroded and shut down the water supply of Charleston, West Virginia, and it raised the alarm for me about how dangerous these tanks are near water supplies. And what I want to emphasize about this bill is that there is a gap in state and federal law. We have comprehensive regulations for oil spills and for oil tanks, and nothing on the books for chemical tanks. And in my view, there's no health or safety justification for that. It's just a gap in the law that needs to be filled by us as a preventive measure. And this is a reasonable bill that gives authority to the Water Board to set the details of regulation. And it has a much higher threshold than other states that have taken action in this area. So to give some examples, other states that regulate chemical tanks begin regulation at 250 gallons. This substitute amendment starts at 5,000. So I urge you to support it.
Thank you, sir. All right, very quickly, because we have 40 seconds.
Mr. Chair, Steve Carter Lovejoy with the Virginia Sierra Club, and we support this bill.
Thank you, Steve.
Mr. Chairman, members of the committee, Joe Wood with Chesapeake Bay Foundation, and we do support the bill. Thank you.
Okay, thank you, Joe.
Mr. Chairman, Philip Musegas from Potomac Riverkeeper Network. We support the bill.
Thank you.
Mr. Chairman, Pat Calvert, Virginia Conservation Network, also support the bill. Thank you.
Okay, wonderful. All right. Why don't we do this? You got in 10 seconds to spare. All right. I'm going to assume there's some people opposed to the bill. Wow. Okay. Why don't, Madam Clerk, we went a little over 5. Why don't you make it 7 minutes? And if you all want to make a line, Kyle, or somebody come first. And don't everybody say the same thing, please.
Mr.
Go ahead,
Chair-
Brett. Yes, sir.
Mr. Chairman, Brett Vassey, CEO of the Virginia Manufacturers Association. We saw this bill the first week of session. Usually this is a bill we work on over the course of a year. The size and magnitude of this is immense. So to affect all 6,000 manufacturers in the state of Virginia, every university that we know of that carries facilities of this size, state is going to be affected. We don't know the magnitude, but here's the bottom line. Over the last 2.5 weeks, we've been working with the proponents of the bill, trying to find a compromise in principle and specifically as a substitute. We have distributed that substitute that where we reached an impasse on compromise. We reached that impasse on Sunday. So we've shared with you a substitute by email. You all have that. Senator Surabel shared a substitute with us a couple hours ago. We haven't had a chance to completely digest it, but let me, in the interest of time, be really, really short. The representation that we're fixing a problem for West Virginia is problematic for us because we believe, candidly, that these substances and these tanks are regulated by no less than 16 other regulatory authorities. And we have industry here who can verify that it's everything from water permits, air permits, local building codes, fire codes, boiler pressure permits, hazardous waste management, toxic pollutants, priority pollutants, release exemptions, the list goes on and on and on. The point is, what we've tried to relay to the proponents, it's not that these tanks and these substances are not regulated. They're just not regulated in the way that they want them regulated, through a tax and a registration system. They're regulated in a number of other ways. What we've suggested in our substitute is a way to work with DEQ to basically to harmonize what we're already providing. And by the way, all of these tanks are already provided in an annual report. It's called EPCRA. It's a federal requirement. It's provided to DEQ. They know all the same information. So we have tried to provide as flexible as we can. We appreciate the patron in working with us, but we just have not reached that full compromise that we were hoping for. So in interest of time, I'm going to back off and let some of the industry folks tell their story.
Okay.
Ask him a quick question.
Senator Lewis.
Brett.
Yes, sir.
So let me ask you this. So when you reach this impasse, is it that there is no more room or that you just ran out of time?
I think in time, we probably could have got there, Mr. Chairman, excuse me. Senator, I think we probably could have got there except for one provision. The registration is an assumption that that is somehow a proxy for good practices. We contend that focusing on the inspection standards and the operator standards, so that for visual inspection, that's where we need to focus. The root cause of why those failures, which by the way weren't manufacturing sites, they were agriculture sites, where those failures that were cited earlier failed. We think that those are the areas we ought to focus on, not creating a big regulatory system where we're focused on just registering tanks. And by the way, some of these tanks are Homeland Security regulated, so putting them in a public database is an infrastructure. I mean, that's a serious problem. Okay. So there's a lot of work in this bill. It's not as simple as, well, we're just going to register for a $300 fee.
All right. Thank you. Kyle.
Mr. Chairman, Kyle Shreve, Executive Director of the Virginia Agribusiness Council. Not to repeat, but we do believe that this bill is very large. We're talking about, under the underlying bill, not having time to have looked at the substitute, we were talking about over 1,200 chemicals that this would pull in to a new standard at which we're not sure how it measures up to what we're currently doing under federal guidelines. And we do appreciate the inclusion of the on-farm exemption. However, my industry looks at, and my organization looks at the entire supply chain, including forestry, including my member partner, the Virginia Forestry Association. Poultry, which you're going to hear about in a second, is already regulated under their permit for DEQ, which this would pull in. And so there are a lot of unanswered questions. We did try to work in good faith. 5,000-gallon tanks pulls in a lot of new tanks, and we are very concerned and therefore oppose the bill. Thank you.
Okay. Hobie.
Thank you, Mr. Chairman. Hobie Bowen, President, Virginia Poultry Federation. We have concerns about this for the reasons that have been stated. Poultry plants have detailed plans for routine maintenance and inspection of storage tanks, and in the event of a spill, there's going to be rapid action in compliance with existing programs. For example, we use anhydrous ammonia for refrigeration. And if you were to have a leak there, you'd have about 15 minutes to make notification of that to avoid very significant penalties. And DEQ, they can speak for themselves, but if such a leak occurred, they would be responding immediately. We just feel like this measure warrants additional examination and consideration. Appreciate the farm exemption. That's certainly helpful. The threshold, I think we had proposed something well higher, than what's in the bill. So it came way closer to the original introduced threshold than what we had proposed. But just feel like it should be carried over or looked at further before we,
All right,
complex. Thanks.
I'm going to exercise chairman's prerogative here. I think, can I assume that the rest of y'all are opposed to this bill? Okay, I think we've heard a lot, and I think we're ready for a motion.
Mr. Chairman?
Yes, sir.
I think Senator Serval's brought an issue here that deserves to be looked at, but it is much more complicated than I think we're going to figure today, because we've still got more bills and a short amount of time to do it. So I think it's prudent if we move, if we carry this bill over for the year, and I so move.
Second. All right, we've had a motion to carry the bill over for the year. Clerk, open the roll.
Yeas 13, nays 0.
All right.
Great, thanks.
Thank you, Senator. Okay. And I want to thank everyone that testified on that. What do we have left in subcommittee reports? Why don't we start there? Marsden, I'm looking at you.
Yep, hold on just one moment, Mr. Chairman. Let me get back to my script here. Thank you, Mr. Chairman. We have our subcommittee on companion animals. We have Senate Bill 272, which is Senator Bell's.
Okay, 272.
Bill on tethering animals, adequate shelter and space. And let me pull this up. I believe we have could we report the amendments on Senate Bill 272, Dave?
Mr. Chair, we have two line amendments on line 42 after the word animal. Insert this phrase that comes from a couple lines below. The phrase is, that is not actively engaged in conduct that is directly related to agricultural activity on property with a zoning classification, if any, that permits such agricultural activity. And then the second line amendment on line 43 after AM, 6 AM, strike the remainder of that line and then all of line 44 and through the word activity on line 45. So roughly moving that phrase just a couple lines up above.
Thank you. Mr. Chairman, I would move those line amendments.
Okay. We have a motion, a second, to move the line amendments. All in favor, say aye.
Aye. Mr. Chairman,
Motion carries. Go ahead.
Mr. Chairman, thank you. We passed this out 3-0. This deals with the subcommittee. I'm sorry. We had a change on that at the afterwards that didn't get recorded. And I spoke with Senator Pillion and confirmed that it was a 2-1. Senator Pillion was opposed. And thanks for reminding me. But what this does is provide for the care of animals who are tethered outdoors. It deals with the length of the tether, which is at 15 feet or 4 times the length of the animal. It had been 3 times the length before that, and 10 feet in length. So it gives us a little more length here. And what the bill does is deal with the temperature variances of 32 degrees in the cold and 85 degrees Fahrenheit or higher, and certain weather events that a dog is not allowed to be tethered. And these are between the hours of 10 p.m. at night and 6 a.m. when people are unlikely to be there with their dog or observing if it's in distress or having any problems. So it was a 2-to-1 vote, and unless there are any questions, would move to report.
Okay, just so we're clear, there's not going to be any new testimony on this. We've been heard in subcommittee. Any commentary from the committee about Senate Bill 272?
I've got a question for the subcommittee chair, really quickly. How does this compare to Senator Spruill's bill from last year? Do you remember?
Not in any detail.
Okay.
Senator Lewis, although Senator Spruill was there for part of the hearing and was smiling. So.
Okay, all right, thanks.
Mr. Chairman?
Senator Obenshain.
I thought I'd understood that this kind of reverted this back to Senator Spruill's bill more like it was introduced last year, and that kind of jettisoned the changes made during the committee process. Am I mistaken?
I'm unaware of the changes to Senator Spruill's bill. I was not subject to those last year.
Okay. Does staff, I mean, I'm not assuming not everyone was on this committee last year, but is this similar to Senator Spruill's bill?
It is similar to what he had last year.
Okay.
I can't speak off the top of my head to what differences there are.
Okay, all right. Look, the bill's in front of us, folks.
Second.
Mr. Chairman?
Senator Obenshain.
I just would say that, I mean, we just adopted Senator Spruill's bill last year. It hadn't even been in place for a full year. I don't know whether the committee heard that there are problems with the implementation of it. I just would hope that maybe we'd wait and look at it next year. If there are problems, I just think it's too soon to revisit this.
Just let me respond to that. Senator Spruill's bill did not become law. It washed up in the House, so.
This is very similar to that.
Yeah, all right. Look, we have a motion and a second. Clerk, open the roll.
Yeas 7, nays 7, 1 abstention.
Okay.
Thank you, Mr. Chairman. Next.
All right.
Next bill, Senator Stanley's Senate Bill 304, reported with substitute 3-0, and it's requested by Finance. Could we pass out the sub, please?
All right, 304, can we distribute the substitute?
Move substitute.
Okay, so motion and second to adopt the substitute. All in favor, say aye.
Aye.
Any opposed? All right, substitute, 304 is in front of us.
Thank you, Mr. Chairman. And what Senate Bill 304 does is requires that the public animal shelter shall annually file with the state veterinarian a copy of the intake policy, the number of animals on which a euthanasia procedure was performed at the request of the animal's owner with an accompanying consent form, and such number, the number of animals the public animal shelter presented to a licensed veterinarian prior to euthanasia. This is just merely a bill that would give us information about these rates of euthanasia. As you may be aware, Mr. Chairman, there are shelters who accept animals, dogs, if you will, from citizens who come in saying my animal needs to be put down, and others who will refuse those. So that's the bill. It was 3-0, and I move to report the bill as I report the substitute and re-refer to Finance.
Okay, we've got a motion and a second for report Senate Bill 304. Any other comments? No. Okay, clerk, open the roll.
Yeas 15, nays 0.
All right. Next bill.
Thank you, Mr. Chairman. The next bill is Senate Bill 310. Again, it was recommended to report 3-0 with a substitute. So if we could pass out the substitute. and it's also requested by Finance, and I would move the substitute.
Second.
All right, we have a motion and a second to adopt a substitute. All in favor, say aye.
Aye.
Okay, opposed, and substitute is adopted. Go ahead.
What this bill deals with, Mr. Chairman, is that when somebody gives notice of their willingness to adopt or take custody of a dog or cat that has already become the property of the shelter in accordance with subsection D, the animal shall not be euthanized and shall be kept at a certain number of days, commencing on the day immediately following the day upon which notice is given, unless the requester claims the dog or cat sooner. In other words, we're not going to euthanize the animal until a certain time period has gone by when somebody has requested that they could adopt or accept the animal. And so that is the, and it shall not apply to any dog or cat that the public animal shelter has reason to believe has seriously injured a human or that the shelter intends to euthanize pursuant to Virginia law. So that is the bill. It was 3-0, recommended to report as a substitute and is requested by Finance, and I would so move.
Okay,
Second.
any commentary on the bill? All right, clerk, open the roll. Next bill.
Yeas 15, nays 0.
We've dealt with Boysko and Spruill. Mr. Chairman, I would move that I go last with mine. It was not heard in committee because it was going to be amended, so that's one that would come before the full. My bill, Senate Bill 891, I'd like to do after we've dealt with everyone else's.
Okay. All right, so that is the temporary end to the.
Well, excuse me, Mr. Chairman.
I was gonna say, that is the
I'm
end.
sorry. We have Senator Stewart's bill, which was not heard in subcommittee, but it had been assigned to subcommittee.
337.
Which is 337, animal cruelty conviction list established.
I prefer you strike it.
Mr. Chairman, I think I'm going to ask to strike that one. I've done enough bills this year.
Okay, we've got a request to strike 337. All in favor, say aye. Aye. Is that to be a recorded vote?
Yes,
Clerk,
sir.
open the roll. Okay.
Yeas 15, nays 0.
All right, and then while we're on that, in that, I also need to have a motion to strike Senate Bill 1067 from Senator Kiggins. That was a message from her office, strike the bill. Okay, we have a motion and a second to strike Senate Bill 1067. Open the roll, please.
Yeas
Okay,
15, nays 0.
and Senator Marsden, do you have anything left?
I do. I have two left, Mr. Chairman. The first one is Senate Bill 1004. We heard testimony on it last time. This is about, establishing a plan for wildlife corridors. It's already begun at DGIF. If I could very quickly, is the director still here? Is DGIF? Yes, thank you. You could.
I have to leave.
This bill, Mr. Chairman, puts together ask the Virginia Department of Transportation to consider the impact of roads on wildlife corridors in its project. This is about connecting non-contiguous wildlife areas to be able to cross infrastructure and to create a network for animals to move, to breed, to stay away from human contact, avoid the serious number of traffic accidents involving wild animals, deer primarily, and automobiles. It will, if we can start to do this, It will save money. There's no money involved here. I'm hoping that wildlife organizations or conservation organizations would be able to sponsor some of these crossings at some point in time. And DGIF has already begun looking into this area, and if you could proceed and explain where your agency is at this point in time.
Yeah, Mr. Chairman, Ryan Brown from the Department of Game and Inland Fisheries, and we don't have an official position on this bill, but I would tell you this folds in nicely with the Governor's Conserve Virginia initiative and also wildlife action planning that we do. Corridors for movement of wildlife and habitat are key considerations of our department from a population standpoint, and of course avoidance of human-wildlife conflicts are also very important things to the department. So I think you do have some of the bill proponents here, if you'd like to call on them, or I'm happy to take any questions.
Okay.
Fine with this.
All right. Do we have a, okay, we have a little bit of a technical difficulty up here. And, okay, I'm trying to leave my proxy for Marsden, but it did not. I apologize. To suspend for 1 second. I have to leave to go to another committee room. I'm going to leave my proxy with Senator Marsden. Senator Stewart will chair the committee in my absence, which will not be long. I hope everyone understood that. Thanks.
Enable him to vote from.
Yes, ma'am. Would you like to speak to this?
Thank you. Good afternoon, Mr. Chairman and members of the committee. My name is Susan Holmes, and I'm here today on behalf of the Wildlands Network to urge support for SB 1004, the Wildlife Corridor Action Plan that passed unanimously out of the House Agriculture and Natural Resources Committee last week. Every year in Virginia, there are over 61,000 deer-related crashes on our highways, costing $533 million annually, according to VDOT's own statistics. Virginia is usually in the top 10 of states with vehicle deer collisions. The Wildlife Corridor Action Plan will list priority projects to encourage road safety and wildlife movement. It also asks VDOT to consider options for reducing animal vehicle collisions. Importantly, this legislation builds on and supports existing state conservation plans such as Conserve Virginia and VDOT's own initiatives. For example, when VDOT installed fencing to funnel deer through underpasses on I-64 near Charlotte, it led to a 98% reduction in deer vehicle collisions. Already 8 states, including New Mexico, Maine, New Hampshire, have passed wildlife corridor protection bills. And at the federal level, Virginia Congressman Don Beyer is leading a bipartisan wildlife corridor legislation that passed last week in the House Natural Resources Committee. The U.S. Senate has also passed a bipartisan transportation bill that will provide $250 million to support state wildlife crossing projects. Finally, over 50 Virginia and national groups, including the Nature Conservancy, Virginia Conservation Network, the Virginia League of Conservation Voters, the Audubon Society, Sierra Club, and Wild Virginia, all support SB 2004. This is a common sense approach to protecting wildlife safety and human safety and Virginia's wildlife, and I urge you to support the bill. Thank you.
All right. Thank you very much. Are y'all in support, if you would? We're just running out of time, so if you wouldn't mind
Zachary
saying
Sheldon
who you
of the-
are and that you support.
Mr. Chairman, members of the committee, Zachary Sheldon of the Nature Conservancy, we support this bill.
Thank you.
Mr. Chairman, Pat Calvert, Virginia Conservation Network, also support.
Thank you.
Steve Carter Lovejoy with the Sierra Club, we support it.
Thank you.
Thank you.
Are there opposite viewpoints with regard to this bill? Anybody who opposes it? Any questions of the
Department of
paper?
Transportation.
Mr. Chairman, I'm
Mis-
going to move
Is
that
anybody
we
here from the
report it.
Department of Transportation that would like to weigh in on this? I don't know that there
I
is.
move to report.
Mr. Chairman,
Any
just
questions
as
of
a
the
last,
patron first, real quick?
well, as a last thing, this requires a report coming back in 2022 as they sort of put this map of what it would look like together. And this is something that they want to do, and it doesn't cost any money. They can do it with existing resources. Does not need to go to finance. And hopefully one day we will start connecting all the dots throughout the Commonwealth of these wildlife areas. And this is very exciting. It's going to save a lot of property damage eventually if it's constructed. It will also protect wildlife from being hurt and keep people from being injured. And this thing just wins on so many levels. I'd just like to get it started, and it'll be back in 2022 with a report.
All right, there's a motion to report. Is there a second?
Second.
Motion properly seconded to report the bill. Clerk, please open the roll.
This is just the plan.
There you go. You got it. All right, bill report's
Yeas
10 to
10, nays 5.
All right, what else do we have? We still have patrons with bills. Senator Lewis, do you have a bill?
I have
We've been voting for
both got large.
Right, you get the greenhouse gas bill. Senator Peterson wants you to go next. Yeah, you're waiting, Senator Mason. Taking orders from the chair. He said he wanted to be here for your bill.
all these people.
Senator Lewis, what would you like first?
Let's do the short one first, if the chairman doesn't mind.
And that is?
783.
All right, Senate Bill 783.
This is, well, as introduced, it dealt with marine resources participating in carbon market participation. But there is a substitute, Mr. Chairman, and I would ask the substitute be adopted.
Senator Marsden moves, Senator Hanger seconds the substitute. All in favor, please say aye. Aye. Opposed? No. Ayes have it.
All right, Mr. Chairman, members of the committee, what the substitute for 783 seeks to do is deal with SAVs, submerged aquatic vegetation. We've had a tremendous success in restoration efforts with SAVs, particularly on the Eastern Shore. In addition to its habitat value, the restoration work has shown that restored SAV meadows can capture carbon rates at higher than forests on a per acre basis, amazingly enough. So the Verified Carbon Standard has created a program which recognizes and quantifies the value of SAV restoration and capturing carbon. So what this legislation does is authorize DEQ to participate in carbon markets, and the legislation ensures that any revenues that are generated from the sale of these carbon credits will be used for SAV restoration research and administrative costs. The legislation is needed to clarify that DEQ can participate and has the authority to do this. As originally introduced, the department was actually VMRC, and it was felt that the substitute was needed because it was more adept at handling carbon and carbon trading and participation in carbon markets. And in addition to that, we talked to the aquaculture folks and we took out restoration efforts, I believe was the word that we removed from submerged aquatic vegetation efforts, restoration or efforts.
All right, any
That's it.
questions for the patron? Is there any opposition to this? Is there a motion?
Mr. Chairman, I move to report.
And re-refer to Senate Finance?
Oh, dear
And I will
Lord.
re-refer to Senate Finance.
All right, motion properly seconded to report the bill and re-refer to Senate Finance. Clerk, please open the roll. Okay,
Yeas 15, nays 0.
bill reports unanimously, Senator Lewis. Hope the next one's as easy.
Somehow, I doubt it.
All right, what's your next number?
The next one is Senate Bill 1027, Mr.
Senate
Chairman.
Bill 1027.
That deals with the Regional Greenhouse Gas Initiative, something you all probably have heard something about over the years. I believe there is a substitute, Mr. Chairman.
Could you distribute the substitute, please? Senator Marsden moves and Senator Hanger seconds. Substitute, all in favor, please say aye. Aye. Opposed, no. Ayes have it. Substitute is before. Senator Lewis, tell us about it.
Now, Mr. Chairman, let me, procedurally, there are a couple of amendments that I have been asked to submit that may have some controversy to them, apart from the underlying merits of the bill itself. And I'll defer to the chair as to how you want to. There will likely be some discussions for some stakeholders on one of the amendments. The other amendment, I think, is non-controversial.
Why don't you tell us what the substitute does first, and then
Okay.
you talk about the amendments that you want to talk about because it's your bill.
All right, Mr. Chairman. Senate Bill 1027, Mr. Chairman, authorizes the Department of Environmental Quality to establish, implement, and manage an auction program to sell allowances into a market-based trading program, and that is market-based, consistent with the Regional Greenhouse Gas Initiative. The bill also provides that 45% of the revenue from auction allowances will be deposited into the Community Flood Preparedness Program. This is the new version of the Virginia Coastal Resiliency Fund that we established, Virginia Shoreline Resiliency Fund we established a couple of years ago, which previously has gone unfunded. It is estimated that with current projected price of the carbon allowances, a carbon allowance is 1 metric ton of carbon, we may be looking at as much as $100 million a year in revenue from the carbon auctions. So 45% of that would go into that fund. The fund is used, has reconstituted by legislation this year that's working its way through the Assembly. The fund would be directed towards statewide application for frequently flooded and recurrent flooded areas, infrastructure programs and such as required to ameliorate the flooding problems across the Commonwealth, but particularly in Tidewater, Virginia and coastal Virginia. 50% of the revenue would be directed to the Department of Housing and Community Development to support low-income energy efficiency programs, including programs for housing developments. DMME will provide technical assistance upon request for those efforts. The bill further provides for a joint annual report to both houses of the legislature specifying the annual reduction that's been achieved of greenhouse gases, the revenues collected, and a description of the expenditures of the revenue. This initiative began on a regional basis in 2005. The regional greenhouse gas initiatives were fully implemented and went online in 2009. There are currently 9 members. New Jersey was a member, dropped for a number of years at the outset, then dropped out and is now going to rejoin the Regional Greenhouse Gas Initiative this year. Since inception, the program has helped cut carbon pollution from power plants by more than half in the region. Over Reggie's first year, 8 years, electricity prices in the region fell by 6.4%. This program, again, as I referenced at the outset, is a market-based solution to carbon reduction and essential to the battle against climate change. The program establishes this market-based solution, and it is modeled after a successful other cap-and-trade market-based solution that we used with acid rain many years ago under President George H.W. Bush. The Research Analysis Group is an international economic consulting firm. They determined during the first 3 compliance periods of the RGGI program for the states that were participating, the program yielded a net benefit to those states in that region of $4.7 billion. Those states had more than 40,000 job years, that's a 1 full-time job for 1 year, created, and air improvement was improved, air quality was improved, thereby resulting in a healthier population. I think it's important to note that many of the RGGI states have had levels of unemployment and economic growth over the years of their participation that have rivaled and in some cases surpassed ours. And so that's, in summary, the bill, Mr. Chairman. I would say that in all the states that have participated, and I think that's given evidence for the fact that New Jersey, after having opted out for a number of years, is seeking to get back in. I think the roads, the cars still travel on the roads, the lights still come on when you flip the switch, the kids are still in school, everybody's test scores are doing well, and so the world went on after they participated in RGGI. And it also gives us some significant resources to battle the results of climate change and flooding, which is of tremendous importance to us, as Mr. Chairman knows, for those of us particularly in coastal Virginia, but also for folks in Danville and other areas that are experiencing frequent flooding due primarily to the change in our climate and these tremendous storm events that we're incurring. So that's the bill, Mr. Chairman. That's what the bill does. And again, as I said, there are a couple of amendments, one of which I don't think would be at all controversial, and one of which will probably generate some discussions amongst some stakeholders.
All right, let's first, are there any questions of the patron from the committee? Do you want to talk about your amendments now, or do you want to let folks speak to your bill first? Which do you prefer? It's your bill.
There's a question, Mr. Chairman.
Senator Favola.
I apologize. In this fund, is there an opportunity for private money to come into the fund? I mean, like I've set up funds and I've frequently added language allowing for private donations.
Mr. Chairman, Senator Favola, the fund, there is a separate bill. The fund is also set out in here, but we also have a separate standalone bill which has worked its way through this committee and is working its way through, I think it's passed the floor of the House already, which reconstitutes that fund. It allows to receive federal funds. I don't know, I can't recall if it allows itself to receive private dollars or not.
You got a friend that wants to help you there.
Staff has pointed out that on line 50.
It says private funds.
It says private funds.
Okay. We'll take anything we can get.
Yeah, it's on line 50 in your bill, so, okay. Thank you.
Yep,
Okay.
thank you.
Any other questions?
Mr. Chairman, I think I would like to address those amendments
All
now.
right, Senator Lewis?
I think we have one amendment that, again, will probably not generate much controversy, and that deals with cost recovery. And so I'll let others more knowledgeable about that come up and speak to that.
All right. Who has the amendment, Senator Lewis?
The amendments are actually in the original substitute, so we'd have to report the amendment, Mr. Chairman. We don't have a paper copy of it.
All right, let's report the amendment before we have discussion on it, just so we know what we're talking about.
Mr. Chairman, I believe this is the correct amendment. It's an enactment clause that says that the costs of allowances purchased through a market-based trading program consistent with the provisions of Article 4 of Chapter 13 of Title 10.1 of the Code of Virginia, as added by this act, are deemed to constitute environmental compliance project costs that may be recovered by a Phase 1 utility or Phase 2 utility as defined in subdivision A1 of Section 56-585.1 of the Code pursuant to subdivision A5E of that same section.
All right, what does that mean? Or maybe everybody else understand it, just so we know what it means.
I'll let him tell you.
No. Mr. Chairman, Bill Murray from Dominion Energy, known in this language as a Phase 2 utility, APCO as a Phase 1. Typically, in the past, environmental compliance costs have been capital projects on which utilities do earn a return. You had this issue with coal ash last year and some legislation in this committee. The allowances are a straight pass-through. They're not it lands, it's a dollar-for-dollar recovery. There's no margin. So this just clarifies that whereas the existing code thinks only of projects that allowances also count as an environmental compliance cost, that then lets us and the commission track what costs are going with which power plant. We thought about proposing fuel, but that's one proceeding where everything's sort of jumbled together. This way you can track Greensville Power Station. It's this much. We calculated the cost for our customers per month. For the first 5 years, the average is $1.22 a month. The 10-year average is about $1.14 a month. What will happen over time, while the allowance cost will go up per unit, the number of units you've got to buy as you decarbonize goes down.
Okay.
Mr.
All
Chairman.
right, questions? Senator Obenshain.
Yeah, just a couple of questions. And so my understanding is that implementation of this bill is going to cost Dominion and other utilities money. And you're going to simply charge the customers your actual cost.
Straight pass-through.
All right, no rate of return.
No rate of return, no carrying cost.
But you don't know what those costs are going to be yet.
What we're estimating, we've had in the past, we don't have any now. In the past, we have been a RGGI participant in other states when we've had fossil plants. We know the RGGI market reasonably well. Looking at our units, projecting allowance costs, what we're coming to, and because there is no recovery issue, it's easier to calculate. As I said, we're looking at about $1.22 a month for a 5-year average, and then about $1.16 a month for a 10-year average. Year to year, looking at this, it ranges from a high of $1.38 in 2024 to a low of about 84 cents in 2032, which is right a little over $1 on average.
That's helpful. Mr. Chairman, so what is that per year statewide?
We're thinking it's right around $100 million typically from our customers. So if you think about Dominion, we're about 40% of the land area, but about 70% of the people.
Right. So.
And I defer to the fiscal impact statement on the bill for the total, but we're thinking for our customers, it's around $100 million.
Okay. So Senator Lewis mentioned the $100 million that's going to be generated for the state from this bill. That's another $100 million.
As I understand how this works, Senator, we're essentially those with a compliance obligation pay this in essence to the RGGI fund. Whether that goes directly to state or RGGI, I'm not sure the mechanics, but we're the ones paying it and recovering it from customers.
Okay, so the customers, Virginia.
Customers pay us, we pay the state in essence.
All right.
We're acting as a pass-through in this instance.
So, and just so I understand, because this is not my area, Frank Wagner knew more about this than anybody I knew, and he's no longer here. So the $100 million a year that we're going to make is actually going to come from the ratepayers who are paying this. Is that correct? Is that how it ends up?
That's how environmental compliance costs work, whether it's coal ash or adding controls on coal stations. In this case, it's allowances. Yes, sir.
Thank you. Any other questions of Bill on the amendment? Anybody else want to speak to the amendment? Otherwise, is there a motion on it? Motion properly seconded to adopt the amendment. All in favor, please say aye. Aye. Opposed, no. I think the ayes have it. All right, it is amended as such. Senator Lewis, you have another amendment you want to talk about?
We have a second amendment, Mr. Chairman, which deals with the issue of long-term contracts in implementation of RGGI. That's an issue that most RGGI states have tried to deal with. We actually have two, I think, standalone bills that are working their way through here that are dealing with long-term contracts and how that fits into the RGGI scheme. This particular amendment, which I'll ask, I guess I better ask the amendment be reported.
Mr. Chairman, this is a long amendment, and in a couple spots I will just summarize. It adds a new code section called Energy Conversion or Energy Tolling Agreements. If the governor seeks to include the Commonwealth as a full participant in RGGI or another carbon trading program with an open auction of allowances, or if the department implements the final carbon trading regulation, and it's cited, in order to establish a cap and trade program, then the definition of the term life of the unit contractual arrangement under the final regulation shall include any energy conversion or energy tolling agreement that has a primary term of 20 years or more, and pursuant to which the purchaser is required to deliver fuel to the CO2 budget source or CO2 budget unit, and is entitled to receive all of the nameplate capacity and associated energy generated by such unit or source for the entire contractual period. And, any purchaser under an energy conversion or energy tolling agreement shall be responsible for acquiring any CO2 allowances required under the final regulation in relation to a CO2 budget source or unit that is subject to such agreement.
Sorry to make you go through that, Mr. Chairman.
So at the end of the day, if there's a contract to provide energy between two parties, we're determining how that's going to be handled rather than the parties. Does that summarize it?
And there's more detail to that argument, and there's a logical reason why that may be the case. I thought this was an important enough issue to bring before the committee to make a policy choice. Okay. I don't know what I don't even know what the administration, Secretary Strickland's here. I don't think they have a position one way or the other on this amendment. But I thought, again, give these parties an opportunity. This does not cost, these other bills that are passing through here cost the program money. They cost allowance revenue. This does not.
Does everybody understand the amendment?
Mr. Chairman, exactly what producers does this cover?
I'm gonna let them speak. Senator Ruff, we've got both sides here to lay it out for you.
All right, come on up. Y'all pick a designee and give on each side of this issue. Whoever would like to, please don't be shy. Somebody come on up.
Members of the committee, Ken Hutchison on behalf of Tenasca, and I will beg your indulgence as you gathered from the explanation of the amendment language. It's very complicated, so I just want to take a brief amount of your time to try and explain what we're doing here.
It's just an amendment, Mr. Hutchinson.
When you hear what the dollar impact of one company is, you'll appreciate it. Tenasca is the 940 megawatt power plant located in Fluvanna County with 29 employees and enough power to generate electricity for 940,000 homes. Tenasca has had a contract with Shell since 2001, where Shell delivers the gas to the facility, Tenasca converts it to electricity, and then Shell pulls 100% of the electricity off of our facility. This contract was signed long before carbon regulation, RGGI, all of the greenhouse gas taxes, before they were even contemplated. So this contract predates all of that. It does not speak, therefore, to who would be responsible 20-some years later for the purchases of allowances that would be contemplated in Senator Lewis's bill. We have been notified by our partner Shell that they, according to their review of the contract, they do not view themselves as being responsible for the allowance costs. I would surmise that if Virginia does elect to join the Regional Greenhouse Gas Initiative, we will now be in a situation that's known as the long-term contract issue in RGGI states. Realizing this issue was coming down the road, we earnestly embarked on I think, a very thorough dialogue with the administration, with DEQ, with members here in this room over 2 years ago, anticipating that we would arrive at this point one day. And we have been very, I think, active in our engagement. This isn't something that just came out of the blue. We've been very.
Can I ask a quick question?
Yes, sir.
Just while you mentioned that, you talked about being active with the administration, all these other state agencies. Have you tried to negotiate with Shell over this issue?
I've got Larry Carlson from Shell right here, and I will let him speak to the conversations that have taken place directly.
So you have?
Between the two parties.
Well, I don't want to sidetrack you. You have tried to negotiate this issue. Is that what you're saying?
Yes, sir.
Okay. Go ahead and finish up.
We would note that in every instance where a state has joined RGGI and there has been a long-term contract issue, the statute standing up RGGI in those states has made accommodations for the long-term contract issue. And in 3 states where that long-term contract issue existed, the states set up a set-aside allowance account whereby allowances that are from the master pool are awarded at either free or discounted rates to the long-term contract holders to prevent them from having to buy allowances. In conversations with the administration and doing the math on what 940 megawatts of power generates on an annual basis, the allowance cost based on 2018 numbers, we calculated that we would need to procure $40 million worth of allowances by the time our contract ends in 2024 with Shell. Our original approach with the administration and with DEQ was to seek similar treatment with the set-aside reserve allowance account that the 3 other states had instituted in New York, New Jersey, and Maryland. It became pretty apparent early on in the conversation that a $40 million decrease in what the state would realize in revenues from the allowances sold, that was a non-starter. We were asked to come up with an alternative solution to this problem. The amendment that Mr. Meacham read would clarify that the party in the contract that controls the fuel to the facility, when the plant runs, how much it emits, takes the electricity away, and controls how much carbon is emitted into the atmosphere, so should simply be the party responsible for procuring the allowances. In this arrangement between Shell and Tenaska, Shell directs when the plant runs, how hard it runs, and has the existing ability today to pass along any allowance costs, 100% of their costs, into the market. Senator Lewis's substitute would clarify that Shell, in this situation, would be responsible for procuring the allowances. So here are the consequences of not adopting Senator Lewis's amendment. It would create a loophole that would give Shell a $40 million advantage into the marketplace, ahead of Dominion, APCO, and every other independent power producer selling into the open market, PJM, across state lines. They would have a $40 million discount on their power. It would create a situation where you have 2 classes of emitters, those who purchase the allowances and those who do not. And ironically, Shell would be financially incentivized to run the plant at 100% capacity, thus generating higher emissions into the atmosphere from the Fluvanna facility. And finally, and the reason we're here today, Barry's here today, it would create a $40 million tax on Tenaska that we would be unable to pass along to anybody because we have one customer, and that customer is Shell. Some folks have merely described this as a simple contract dispute. Others have said, why don't you all sue each other to solve this issue? We believe that that message ignores how other states have done it, ignores the fact that we are not asking for how other states have done it. We want to hold the allowance pot harmless. It ignores the fact that but for the General Assembly perhaps deciding to join Reggie, we would not even be in a conflict with our partner Shell. And it simply ignores principles of fairness and equity. And with that, I'm going to end my remarks and ask Mr. Carlson
Hold on a second.
to join
Ken,
me.
any questions of Ken on this issue from the committee? Okay, if you'd like to have your other
I just
gentleman.
have one
But we
question.
do, Senator Favola.
Maybe it's for the administration, I'm not sure. It sounds like we're changing a business arrangement, or you're trying to close a loophole in a current business arrangement. And I'm just wondering if this is the right vehicle to do that. That's my only question. I mean,
Is that a comment? Do you want to respond
Mr.
to
Chairman,
that?
yes, sir, please.
Go ahead.
Mr. Chairman, Senator Favola, I appreciate your question. We're not trying to close anything through this bill. Right now, our contract is working great and would work great for another 4 years uninterrupted. It would be the decision made by the General Assembly and endorsed by the executive branch to join Reggie that would materially change the environment that we're operating in with our partner Shell, and how a contract that was signed 20 years ago couldn't contemplate the situation that we would be in today.
All right, Senator Morrissey.
that's clear.
I don't see an option.
Senator Morrissey, you have a question?
Ken,
Yes, sir.
you talked about, but for this amendment, there's an incentive for Shell
Can you
to,
come down here? Okay.
It's all right. Senator Morrissey, go ahead.
I think I was trying to follow you, and I thought I was, but there was a point where you said that, but for this amendment, there will be an incentive for Shell to produce at maximum capacity.
Yes, sir.
Which is counter to market forces. Can you, my words, can you explain that a little bit in more detail?
Yes, sir.
That's why I lost you for a moment.
So I think, and Larry can give you maybe a better number, but on average, I think the facility runs anywhere between 70, 80% of the time. When you are able to sell market power at a $40 million discount over the 4 years, you've got a leg up on all of your competitors. So instead of running it at 70 or 80%, you have a financial incentive to run it at maximum capacity, whatever that is, whether it's 100%, 99%. Certainly there are times where the plant needs to power down for various issues, but there would be a financial incentive to run that plant 100% nonstop until they physically had to stop it. And the irony of that is it would increase the emissions from that plant, not decrease, which is the overarching goal of any sort of Reggie framework, as I understand it.
All right, Ken, if your witness wants to add to this but not be duplicative, because we're already
Absolutely.
running over. With this
Larry,
is
do you have
just an
anything you need
amendment
to
on the bill, we've got to take up the whole policy issue.
Do you
Yes,
have
sir.
anything you need to add?
Would you like to add anything?
Yeah, this is Larry Carlson. I'm Vice President of Environmental Affairs with Tenaska, and I'd just like to clarify the contract was signed in 2001, and we talked about Shell being the one that takes the power and bids that into the market. They're the ones that are able to recoup the costs in the market. And they bid that in based on fixed and variable costs, and one of those variable costs is fuel. Another variable cost is allowance costs. For every megawatt hour we generate, we need so many allowances to cover that.
Mr.
And
Chairman,
Senator
and I don't mean to interrupt you, but I mean, isn't this basically asking us to treat Shell like Dominion's being treated?
Yes, sir.
and every other generator IPP.
We're not, I mean, we're not really interfering with a business relationship by this amendment. I mean, this whole bill is what is disrupting the business relationship, right? I mean, it's what's creating the issue.
Right.
The Reggie.
Mr. Chairman, Senator Ebenstein, that is correct. And we come here with meaning no harm to the bill.
I understand.
Are very grateful for the patrons' willingness to have this conversation on his bill.
And we'll talk about the merits later, but that's very helpful for me to understand that basically you all are asking essentially, or you all and Shell are asking to be treated basically the same way as other energy providers.
Well, we're not, I'm sorry,
Any
Mr.
other-
Chairman, we're not speaking for Shell.
Any other questions of the witnesses? All right, if no other questions of the witnesses, I think there's a gentleman who would like to speak to the other side of this, standing behind you. And again, we've gone way over time, but I want you to have adequate time for what you have to say about this as well.
Good evening, Mr. Chairman and members of the committee. I'm Matt Picardi, and I'm with Shell Energy North America. And we're the counterparty of this contract. I guess my initial reaction to that was, so that was interesting. And I can't say I agree with much of what I just heard. So let me pick off a few points before I get into a little bit about what I was going to say. First of all, to create the impression that we're not going to be financially harmed if this occurs is incorrect. We compete in the competitive PJM market. We are not like Dominion. We do not have captive customers that we can pass these costs on to. So this will cause our costs to go up significantly, which means our net revenues to operate the plant will go down, and the money that we have to pay to Tenaska, we will have less money to pay Tenaska as a result of that. So that's one point. The second point I would state is we've had contractual arrangements like this in the past. In fact, we had a very similar situation in California. The legislature did not get involved. They let the parties work it out outside of the legislative process. The third point I'd like to make in terms of the points that I heard is there was a comment that we're going to have a competitive advantage. That is completely false. We compete with all the generators in PJM. In fact, most of the states in PJM are not members of RGGI. So what will happen is when we have to compete with out-of-state generators to sell energy into the PJM grid, which is a very competitive market, we have to sharpen our pencil every day when we put bids into that market to be as competitive as possible. We will lose. And the exact opposite of what you were told will happen. In order for our plant, our costs will go up. We will not get a schedule to be dispatched into the PJM market, and a plant that is less efficient in another state that emits more emissions will be dispatched up. That's called the leakage problem. That is well known in connection with this. So another point I'd like to make is with regard to how the amendment you're being asked to look at. So there's an underlying contract that you've heard about that could address this issue. So putting that aside, they're asking you to amend the model rule. So the model rule has already been considered in front of the Department of Environmental Quality. They've addressed this. It's the same rule that's in place for all the RGGI states. What they're asking you to do is substitute your judgment for the environmental and energy experts that put that rule in place to address this very situation. All we're saying is, please don't change that definition. We're happy to live with it and resolve our dispute, if we have one, with Tenaska. At this point, we did not realize we had a dispute with them, that we did realize the bill was being placed in front of you, but they haven't come to us and said, we dispute this, we demand that you pay it. They haven't threatened any type of litigation, and certainly if they did that, we'd have to take that in consideration. At this point, the entirety of the discussions have been about how the state of Virginia was going to address this, and that's as far as we've gotten. So those are some key points that I wanted to make sure you heard before you made a decision on that. And again, I think the one thing I'd like you to understand is that we've estimated, looking at projected RGGI costs, in fact, we backed into some of the numbers that they use to get to some of the millions of dollars that they say they're impacted by. We've estimated, based on projected RGGI costs that are out there, that we could lose 33% of the net revenues that we earn in the energy market as a result of this. That means less money that we have to pay Tenaska for the right to use a plant that we've had in place since the beginning. So I think I've turned to, I'd like to think I've touched on some of the key issues that you've heard. The message we'd like to leave with you is please leave the rule in place. Do not accept this amendment. And if it turns out we have to enter into negotiation with Tenaska to deal with this or some other procedure, we will do it. You don't have to do this. It has not been done anywhere else. You're doing something new. And please understand, we are financially harmed by this. We can't simply pass the costs on to captive customers. We don't have them. We either run less or we make less money when we run because we're in a competitive market. So with that, in closing, I'd just like to say I appreciate the committee's indulgence in allowing me to shed some light on at least our side of the issue. And I hope you do consider the points I've made, because I'm concerned that you're left with the impression that this issue hasn't been concerned, that it hasn't been dealt with, and that we're not financially harmed. And all of that is the truth. Thank you very much.
Thank you. Any questions of the witness? I'm sorry. Any questions of the witness?
Yes.
Senator Morrison.
You indicated, thank you, Mr. Chair. You've indicated that you've had contractual relations or situations like this in the past, and respective General Assemblies didn't get involved. Can you give us an example?
In California, when they passed their carbon cap and trade emissions allowances back in 2013, we had a contract that was affected by that with a counterparty. We reached an amendment to the base contract without having the legislature to get involved.
All right, one final question.
Senator Morrison.
So is it safe to say this is where you're coming from? The General Assembly shouldn't be getting involved in a business dispute between two private entities. We shouldn't be trying to correct a contract or level a playing field or impose our judgment on something that experts have already weighed in on.
That's my opinion, but more importantly, I think what concerns me about the amendment, the way it's written, I mean, why bother with all the language about putting gas through a plant for a 20-year toll? Just put Shell in there. That's all you're doing. I mean, that amendment's just directed at us, and I don't understand why you would want to be in a position of resolving a dispute between two sophisticated energy firms. Let them do it. That's what I don't understand.
Okay.
Okay, thank you.
Thank you.
Do you have would you like to speak to this?
Different.
Excuse me?
Mr. Chairman, I have a completely different issue with a different amendment to discuss on our company.
So you don't want to speak to this
I don't
amendment?
want to.
All right. Any questions, discussion on this amendment? Mr. Hutchinson, you had a great deal of time. You want to speak again? Really quick, if you want to add something like 2 seconds.
Number one, state legislatures in Reggie states have addressed this issue through the set-aside allowance account. If we were to go that route, that would be great, but that would reduce the revenues by $40 million. And two, what he described as the leakage issue and having to be non-competitive in non-Reggie states, he just described what every independent power producer is going to experience if this legislation passes. They're all going to be uneconomic in non-Reggie states. Shell is not unique to that, and I appreciate the indulgence on the extra time.
Do you want to respond to that in all fairness? Yes. Do you want to respond to that in all fairness?
I don't know who else in Virginia that's in our position that they're worried about. Most of the generation is covered by Dominion and owned by somebody that can recover these costs, so I'm not sure I understand that. Thank you.
Thank you. All right, any questions of anybody about the amendment? Everybody understand what the amendment does?
I think the
Chairman.
Mr. Chairman, I think the administration wanted to say something.
Does anybody want to offer a motion on the amendment or not?
No.
Senator Favole.
I guess my question is, is the bill substantially changed if we don't accept this second amendment, which there are very different views on what the impact happens to be?
Just explained it.
I guess I'll direct that to the patron.
It's just an amendment. You're not going to, the bill will survive without the amendment.
Well, then I guess I would move that.
You finished, Senator Favole?
I was going to make a motion on the amendment, but I can.
Senator Sewell, you have a question?
Well, that clarifies my question. I was just trying to see who was presenting the amendment to us. If it was one just academic, or if there actually was someone moving it in front of us.
I offered the amendment.
Okay.
Is-
Thank you. So do I understand it that you would like us to adopt the amendment, or are you putting it there for us to discuss?
I put it out for you to discuss because I think it's a policy decision that this committee needs to make. I would vote, if the amendment moves forward, I'm going to vote in favor of it.
Okay.
But again, I think, as you could tell from both sides, there's a decision, a policy decision, a legitimate policy decision that we need to think about.
Well, this was.
There's a motion properly seconded to adopt the amendment. Do you have comments on that, Senator Morrison?
I do.
Senator Morrison?
Yeah.
I've listened to both sides, and both sides made compelling arguments, but it boils down to this. It's either we're voting right now on a policy matter, or we're voting on a matter that is resolving a dispute between two energy giants. I've got to tell you, after listening to both sides, and they were both excellent, I feel like I am resolving a dispute between two energy giants, And that's why Senator Lewis, I'm going to vote no to this amendment.
All right, any other discussion?
One other question, Mr. Chairman, and I apologize.
Senator
In the opinion of General Counsel or the patron, I would think this would be setting a precedent for how we deal with future conflicts in this area, or is that fair? I mean, if we're making...
The only observation I'd make, Senator Foley, is we set precedents and then break through them all the time, so.
Well, I know, and you're going to argue that this is unique
All
in
right,
some...
we got a motion properly seconded to adopt the amendment. I think we better open the roll on this one, Clerk. There may be a divergence of views on this amendment. So please open the roll. Looks like it reports. Amendment
Yay,
reports
nay.
9 to 6.
Nay, 6.
Okay. So it's been amended twice now. Senator Lewis, you want to finish up? You want witnesses to speak?
I
in
think we have
support?
people that we've got, it's late, and I know we've got a lot of people that want to voice their opinion on this on both sides, Mr. Chairman, so I'll turn it over to them.
Okay. Could you give us 3 minutes, Madam Clerk, please? For those who'd like to speak in support, come on up.
Well, somewhat in support. Mr. Chairman, LS Power is new to Virginia, new to this session, but not new to Virginia. They're an independent power producer, acquired EVgo, the Commonwealth's vendor for state wide network for electric vehicle chargers. We also own a portion of the Bath County Pump Storage Facility, the Buchanan County renewable tax credits that are given in other states. But we're here to talk about the Doswell Energy Facility in Hanover County.
And if you would tell us quickly what your
Well,
point is,
we need,
because
you've just passed an amendment for Tenaska.
you see the line
Yes,
behind you?
I understand it, but we have another issue similar to Tenaska. We don't have a pass-through in our contracts. We have 4 contracts that expire in 2025. We're not asking for any mediation between another.
Can I ask a question again?
Senator Sirleaf.
I guess my question is also a request. Can we have the amendment reported to us so that I can try to understand it as I hear the arguments?
Mr. Chairman,
for
I
and
would
against?
move the amendment that the staff has.
Is there
I would
another amendment
second
that
it.
Senator Lewis wants us to put forward?
The
Well, I
LS,
just don't know whose amendment
the
it
LS
is or what
Power
it is.
amendment.
It is my amendment.
Oh,
So quickly, the Tenaska amendment does not
Fill the
apply.
clock, Madam Clerk.
The amendment that you just passed for Tenaska does not apply to LS Power. We have a Doswell facility that we just invested over $100 million in recently in Hanover County. We have some of our employees here who traveled and waited all day to be here. We have long-term contracts in place. There's 4 contracts that expire in 2025. We've been meeting with the administration, met with Delegate Herring and Senator Lewis. We've tried coming up with 6 different options, finding ways. There are several long-term contracts that do not allow us to do a pass-through at all. The cost for LS Power to buy those allowances over these contracts is $15 million per year for 2021 and 2022, and $5 million a year for 2023 to 2025. Senator Lewis talked a little bit about New Jersey earlier. New York, New Jersey, Maryland, and Connecticut have all provided allowances for long-term contracts, and that's what we're asking for. We're not asking for you to meddle into our contracts, but we're asking for those set-aside allowances for us.
Do you have a patron that would like to offer an amendment for you?
I believe that I do.
Mr. Chairman,
Senator Ruff.
I moved the amendments that I offered.
And I second
Staff
it.
has.
You want staff to report them?
Yes.
Okay. Would you please report those amendments Senator Ruff has offered?
Mr. Chairman,
Senator Ruff.
this is a series of 3 amendments that are addressing the issue at the Doswell facility that LS operates and that B has been talking about for the last couple of minutes.
I'm happy to go over them if you all would like.
If you could briefly, please.
The first amendment inserts a new definition of pre-existing contractual arrangement after line 94 and 95, although I have an old substitute, so I don't know if I've got the right line numbers. The pre-existing contractual arrangement means a power purchase agreement or similar commercial agreement arrangement entered before May 16th, 2017, and has an effective date. And then the second one is inserting modified language for allowances after, I have it after line 110 and 111 as a new subsection C and D. This establishes and administers a pre-existing contractual agreement reserve account. At least one per year, an entity may obtain allowances at a cost not exceeding 25% of the previous auction prices. And again, this is a little bit confusing. A lot of these allowances are sold at auction, and as a lobbyist, I don't do math, but I know that our request is about $32 million between now and 2025. And Section D has some additional language to talk about the reserve account and how that is structured. A lot of this is very similar to what other states have done already on the set-aside allowance. And then the third adds a clause requiring the allowance recipient to certify to the director that the amount equivalent to the dollar value received from the allowance obtained from the reserve shall be reinvested in equipment and services purchased in Virginia. So the money that we expend and spend will be spent back into the facility. So we'll be reinvesting that money back into our facilities in Virginia. For example, we are already spending, oh my goodness, about $40 million a year in Virginia in our operations and maintenance. I'm sorry, we spent $24 million, expected to spend $24 million in 2020. That's in addition to the more than $2 million of property tax we pay in Hanover. So these amendments allow for a set-aside for other companies to also take.
All right, any questions of the patron or his witness regarding the amendments?
I know it sounds very confusing and it's
Anybody else
late.
who wants to speak to the amendment very briefly, particularly Senator Lewis? Yes, sir, I'm sorry. Identify yourself.
Nate Benferrato, I'm at the Southern Environmental Law Center. We would oppose this amendment. I'm neutral on the Tenaska amendment because it doesn't take program revenues away. This, on the other hand, this set-aside would take revenues away from low-income energy efficiency measures, the recurrent flooding money that can go, a great chunk of that's going to low-income communities as well. So we would certainly oppose this amendment.
Others want to raise your hand if you oppose the amendment? So there's a few back there that do. Okay. Senator Morrissey.
Could I just hear the organizations that are, just their name, that are opposed to it?
Sure. Just identify yourself if you oppose.
Lighttown, Virginia, LCV.
Steve Carter, Lovejoy Sierra Club.
Kendall Crawford, Virginia Interfaith Power and Light.
Harrison Wallace, Chesapeake Climate Action Network.
Office of Governor Northam.
And I mentioned this, the allowance that these folks are gonna, that Reggie will generate for the Commonwealth is $500 million. We're asking for $32 million.
Do you have anybody who wants to support this, to speak, to support it, since you have the opposite view? Okay. All right, is there a motion on the amendment?
Mr. Chairman, there has been a motion and a second, and so
I
I'll call
apologize.
for the question.
I apologize, Senator Ruff. Motion properly seconded to adopt the amendment. Clerk, please open the roll.
Yeas 6, nays 9.
Okay. Very briefly, if you support the underlying bill that has been amended twice, step up and state who you are and that you support it, please.
Nate Benferrato, Southern Environmental Law Center. We support the bill.
Mr. Chairman, Lighttown, Virginia League of Conservation Voters, we support the bill.
Mr. Chairman, Jay Ford, Chesapeake Bay Foundation, we support the bill.
Stephen Carter, Lovejoy Sierra Club, we support the bill.
Matt Strickler, Office of Governor Northam, we support the bill.
Harrison Wallace, Chesapeake Climate Action Network, Action Fund, we support the bill.
Mr. Chairman, Bill Murray, Dominion Energy, we support the bill.
I'm sorry, could he come back?
Don't embarrass him now, Senator Wood.
It's recorded, sir.
Mr. Chairman, Ann Phillips, Special Assistant to the Governor for Coastal Adaptation and Protection. I support the bill. Coastal communities support the bill.
Brian Hoffman, Friends of the Rappahannock and the coastal communities of the Northern Neck and Middle Peninsula deserve this flood preparedness fund, and we support the bill.
Kendall Crawford, Director of Virginia Interfaith Power and Light. We support the bill.
Jamie Bronco, James River Association, and we support the bill.
Mr. Chairman, Pat Coward, Virginia Conservation Network also supports the bill.
Larry Carlson, Tenaska, we support the bill.
Are there those that have a differing view that would like to quickly register their opposing view?
Mr. Chairman, Brett Vassy, CEO of the Virginia Manufacturers Association. I'm sort of in an intermediate state here. Our comments are pertaining to the use of the auction proceeds. We're trying to be consistent over the last 2 years. We're a participant in the RGGI process. You have a regulatory board, the State Air Board, that proceeded with regulation of RGGI, which was said not to be a tax. You now have a statute that allows a tax with appropriation from the tax of that electricity. Seems to be a conflict, and consumers are a little confused, like us, who are large consumers of electricity. We would hope.
It's not a confusion. We're taxing the ratepayers $100 million a year, and that money is going into a fund for other purposes. There ain't no confusion about it.
Okay.
That's the bottom line.
Well, Mr. Chairman, then just to state our point of view, we would hope at some point there would be a conversation about using the SEC, return the funds to the ratepayer through a fuel adjustment clause like we do every other proceed that's returned. Thank you.
Thank you. All right, is there a motion on the bill? Motion properly seconded to report the bill. Clerk, please open the roll.
And re-refer.
And re-refer to Senate Finance.
Yeas 8, nays 7.
Thank you, Mr. Chairman. Thank the committee.
Okay, I'm back. Mr. Chairman. All righty, yes. Senator Stanley.
Mr. Chairman, having voted on the prevailing side by which Senate Bill 272 is not reported with a 7-7 tie, I now move that we reconsider that vote.
Okay, is this getting back to animal tethering?
Yeah, sir.
Okay, all right.
Senator Bell's bill.
Senate Bill 272, motion to reconsider. Senate Bill 272, clerk, please open the roll.
Yeas 15, nays 0.
Okay, the bill is back before us.
I now move that we report the bill in whatever form or fashion you would.
And just very briefly, this is the animal tethering bill that failed on a tie vote a few minutes ago.
Yes, Mr. Chairman.
Okay. All right, we have a motion and a second to report Senate Bill 272. Clerk, open the roll.
Yeas 7, nays 6, abstentions 2.
Because you know what? I'm getting it to the floor.
Okay. Limps through. Okay. Still tethering. Karen, you the last one. Okay, okay, we're getting down to the short strokes here, folks. Senator Hanger, do you want to proceed?
Thank you, Mr. Chairman, members of the committee. I have Senate Bill 747, which hopefully won't take too long because I think the interested parties have worked out the substitute that we have for you. If we could.
Second.
Mr. Chairman, this provides some needed clarification improvements to our nutrient trading program. Mr. Chairman, I've been involved in the development of our trading programs back for quite some time. Back, in fact, when we 2012, I was chairing Chesapeake Bay Commission. I shared our trading plans with Lisa Jackson, who was the head of the EPA at that time, had my picture taken with it, sent it to my congressman who was trying to eliminate the EPA at that time. And so got a good response from him. It provides clarity on who may create non-point nutrient credits and then transfer those credits. It provides clarity by basically mimicking language we have in the code now for wetland and stream mitigation banks. The clarification is needed to ensure that private investment will continue in reducing phosphorus and nitrogen entering state waters. We have a very robust nutrient trading program, and there are some people here above my pay grade that can speak in detail to this if y'all want to hear about it, but I think there's consensus and probably no opposition at this time.
Okay, Senator, do you have any witnesses to speak in favor of Senate Bill 747?
Here's one.
Move to report.
Okay. All right, well, all right, there's no one here to speak on favor of it.
The issues were resolved, and it basically, I can give you a little more detail from my notes here if you'd like.
No, that's all right.
Okay.
I think I got it. Non-point
Okay.
nutrient credits. All right.
Okay.
Do we have a motion and a second?
Yep. Second.
Okay, we have a motion and a second to report the bill. Clerk, open the roll.
Everybody should be very lucky.
Yeas 15, nays 0.
Thank you, Mr. Chairman.
Okay, take notes out there. All right. I know I've got Senator Mason and Senator Marsden and McClellan. I'm going to do Senator Mason just because we had a lot of people here for that bill. So Senator Mason, why don't you proceed?
Thank you, Mr. Chairman. Mr. Chairman, Senate Bill 704, and it has a substitute. First of all, I'd like to apologize to all the people who sat here all day long waiting on 704. We tried to move you along quicker. And maybe a quick explanation, as we do a lot of things, well, I move the substitute.
All right, we've had a motion. Do I have a second to adopt a substitute?
Mr. Chairman.
Hold on a second.
Speak to that.
You may speak to the motion as soon as I get a second. Second. Okay, yes, you may speak to the motion to adopt the substitute.
Mr. Chairman, the reason why I need to speak now is that Senator Mason is working on this. I'm also working on this with a number of the stakeholders, and I've drawn an amendment which is in the nature of a substitute rather than amendments to his substitute. So I would think we need to have the conversation about which substitute we're going to adopt.
Here's what we're going to do. It sounds like we have two competing substitutes for the original bill.
Seems so, sir.
Why don't we distribute them both, and I'm going to ask to withdraw the motion to adopt it right now, and let's have the policy discussion, and then we'll take that up.
I will withdraw my motion.
Okay, so we're withdrawing that motion. There's no pending motion. Please distribute both potential substitutes.
Okay.
And I've got, which one is which?
So
I've got a 229 and a 250. Hanger is 250. Hanger is 220. There you go, right here.
Yes, mine is 2:29 p.m.
Okay, I hope you all can hear me. We have two competing substitutes for this bill, which is the nutrient Chesapeake Bay bill. We have one which is 2:29 p.m., which has been submitted by Senator Hanger. I'm holding that up right here. The timestamp is at the top center. And then we have one at 2:50, been submitted by Senator Mason. I'm holding that up right here. And I'm going to let Senator Mason proceed first since he's the sponsor. We have not yet adopted either one, but that's what we're working off of. So Senator Mason, proceed with describing your substitute.
All right. All right. So, Mr. Chairman, a great deal of work went into this. I mean, you see the green buttons out here. When we started, I might have asked to borrow one. We've done a lot of work to adjust this. It looks like that let me see if I can, together, it looks like the nutrient management still addresses 50 acres or more. I speak to a safe harbor provision in that section where if you've completed an application by December 31st, 2025, you to try to receive cost share funds, either you've gotten the cost share funds and can move forward in your plan, or you are waiting to receive cost share funds, you're held harmless under the substitute because you are trying to get into the game. It looks like both substitutes speak to the same number of cattle okay? And that's about it. So they cover the same numbers, 50 acres, 20 cattle.
Right.
So now we're on page 3 of my bill.
Right.
Well, I'm just saying that they're the same subsets. I'll note line 64, we added a hardship situation that says that you absolutely cannot meet the requirements of the compliance program or the guidelines. And so we're defining that. I'll speak to perennial stream in a minute and how we're going to try to determine what those are. Once again, there's a safe harbor provision that if you've made an application by December 31st, 2025 to try to participate in the cost share plan, or there's not funding and you're waiting to receive funding, you have met the request and you're in compliance with the program. Soil and Water Conservation would enter into a contract with each person trying to do so. And you'll look at line 9192. We have changed that the Soil and Water Conservation Board will work towards an implementation of what stream exclusion practices for hardship situations would be. So that's an addition to the substitute. The next provision, if you fence your stream, it gets destroyed by an act of God or a bad storm, you can reapply within 1 year and be under the same situation. The Department of Conservation and Recreation and Soil and Water are designed just to participate and to help. They're not involved in compliance questions and matters. And then I think this is the most important thing, Mr. Chairman and members of the committee. What we've tried to do here, even pushing out the date as far as we have, we realize that there's concern there. So if you meet the date that we're requesting compliance, and you've not done this, then DEQ and the department would work with you to try to say, okay, we see you have this amount of perennial stream. What can you do? We try to work together to see if there's something to be done. The farmer says, still not doing it. Okay, so you would have 180 days from that point to try to move forward and be in compliance and seeing if we can help you do so. If you are not in compliance 6 months later, you have 365 days to continue to try to have us work with you, try to see if you have time to get it done. And if in fact now a year and a half, almost 2 years later, you have not come into compliance, the only fine is a $2,500 civil fine, which if you come into compliance 180 days after that is revoked. So I mean, we have taken the teeth out of any cost, any fine associated with this and tried to extend the deadline as long as we can. Quickly, Mr. Chairman, if you'll look starting at the determination on line 165, section B, so we will report annually on the progress. Section B, if the Virginia meets the guidelines, the program goes away. Section 2 of that, if the commitment to the Chesapeake Bay total maximum daily load phase 3 WIP watershed implementation plan has been met, the nutrient management plan guidelines go away. Number 3, same. If that is met, the stream exclusion practices would go away. And number 4, if we meet all our goals for the Chesapeake Bay watershed implementation plan, the whole program, the whole compliance guideline just go away. I'll quickly finish with on line 201 and 202, there's been a discussion about what's a perennial stream. We don't want the state to just drop in, hey, this is a perennial stream for you. So we set up an advisory committee with the Farm Bureau, agribusiness, and conservation groups and individuals with other expertise to try and determine what perennial streams are we talking about. And then if you flip over, there's one more group to set up what could be portable stream fencing practices. And then finally, the stakeholder group in 2018, which might segue nicely to Senator Hanger, talks about benchmarks obtained, and you can see from 218 to about 30, this stakeholder group, once again, made up of Farm Bureau, agribusiness, conservation organizations, other people that are working through guidelines to continue along with the process.
Okay, thank you
That's
for
where we
that.
are.
That was well done in terms of being concise and getting to the point. Just so, maybe to ask the obvious, this bill has to do with nutrient management and exclusionary fencing, correct?
Yes, sir.
Is there any other environmental objectives that it's trying to accomplish other than those two?
Just in an effort to meet the watershed implementation plan. And as an earlier discussion, we've made good progress with the agricultural community. These folks are trying. They are working towards this.
Right.
72% of our future goals to meet the plan need to come from agriculture.
Okay.
That's why we're here.
But before I get on to Senator Hanger, what I would like to do is, I know the administration is here. Matt, did you want to say a word, just kind of as an introduction to this bill, before I let the other side have a crack?
Chairman Peterson, members of the committee, thank you for the opportunity to testify. Just to clarify, should I be speaking to the substitute, or should I be speaking to Senator Mason's bill?
Speaking to Mason's bill, the Mason substitute.
Sure. So appreciate the clarification. Senate Bill 704 is a governor's initiative. It's a key component of Virginia's Chesapeake Bay cleanup effort, and an effort that's critical for Virginia's environment and economy. We spent the last 2 years working hand in hand with stakeholders from local government, agriculture, business, conservation, along with scientists, state agency experts, and federal partners to develop our new Clean Water Blueprint, which is the Phase 3 Watershed Implementation Plan. The plan tells us exactly what we need to do based on the best available science to meet Virginia's commitments to the 2025 Bay Restoration deadline. In general, we need to take a number of steps to provide the U.S. Environmental Protection Agency with reasonable assurance that we'll have the legal mechanisms in place to meet our pollution reduction targets by the end of 2025. We have those mechanisms in place, and we have a plan to use them for wastewater and stormwater. We do not have those in place for agricultural runoff, which even after decades of voluntary efforts still represents the largest share of nutrient pollution to the Commonwealth's waters. We certainly appreciate the challenges farmers face, as well as the partnerships that we have with many groups and individuals who are working to implement practices voluntarily, and those partnerships will continue under this legislation. That's why Governor Northam's introduced budget proposes more than $100 million for agricultural water quality, including an unprecedented general fund commitment. But we know for a fact, based on the science, that at the current pace, we're not going to sign up enough farmers for cost share to ensure that we'll meet our clean water goals. So we think something needs to change, and we think that this bill is necessary. I think we'll hear arguments today that this legislation is premature. I would argue against that statement and against that logic. We've been trying to clean up the Bay for 40 years now. We've got some requirements in place on wastewater, stormwater, as I mentioned, and yes, on certain sectors of the agriculture industry. And it's time that we need to consider the same for this sector. So Senator Mason did a great job explaining his bill.
Let me do this. Thank you, Mr. Secretary. I can have a question, or why don't I do this? I'll let a question, but I want to move quickly to Senator Hanger's substitute so we can kind of get moving here. But go ahead, Senator Stewart.
Thank you. Mr. Secretary, and you and I had this discussion, but how is it that you determine fencing is the most beneficial way to keep these nutrients out of the bay?
Mr. Chairman, Senator Stewart, thank you for the question. It's based on the idea that fencing is going to keep livestock out of the stream, and so therefore if they can't get access to the stream, they won't be able to be in the stream defecating and introducing nutrients into the stream.
Is that a scientific approach on your part, or is that something you have from some documented university? I'm just trying to figure out how you arrive at that conclusion.
If we're going to have a conversation about the intricacies of the scientific inputs in the model, I'd like to invite James Davis Martin from DEQ to answer some questions.
All right, let's do.
I got another question.
Well, all right. I mean, one more question, then I do want to get to Senator Hanger before.
And this is, but to my point, because I obviously I care about water quality and cleaning up the Chesapeake Bay. I've brought some pretty significant bills of my own. Unfortunately, you couldn't support them. But how do we know that building a farm pond, like a sediment pond or stormwater management pond, and letting the cows go in it and drink from it and go into the bathroom, whatever they want to do in it, isn't a better way to control this, because all that sediment settles in that pond and clean water flows out? How do we know that's not a better way than trying to fence them from a stream when, I mean, even if you have a zero grade, when it rains, everything flows to the stream anyway? So what empirical evidence do you have that fencing out a stream actually accomplishes anything?
Mr. Chairman, Senator Stewart, thank you for the question. We know that in addition to the fencing, the riparian buffer that's included between the fence and the water body has the effect of filtering out nutrients. Obviously, the wider the buffer up to a certain point, the more nutrient reduction you get. But that is based on sound science. We do have science to support that. The idea of a pond and changing the way that water flows on the land, we certainly do that in the context of stormwater in certain cases. I'm not sure that it's something that's ever been contemplated for agriculture just because of the major modifications that would be required to people's land in those circumstances.
Okay, all right. Last question.
And my point is, why shouldn't we let these farmers figure that out? Why shouldn't we give them the time and the resources and the technical expertise to figure out what works best for them instead of trying to impose this on them?
Mr. Chairman, Senator Stewart, we work very closely with the farm community and the Soil and Water Conservation Board in coming up with the practices that are eligible for cost share under our water quality improvement program. Stream fencing has been shown to be the most effective one. We don't have a cost share for the kinds of things I don't believe that you're envisioning, and that's because the parties, including the agriculture industry, have been involved in developing what is eligible, haven't decided that that's the way to go.
Okay, all right.
Mr. Chairman, I've had my light on. I'm happy to wait until after Senator Hanger asks, but given that this is an administration bill, I do have some questions for the Secretary after.
Why don't we do this? Because again, I want to get this in the proper form that we know what we're voting on before we take votes and even debate it. So Senator Hanger, do you want to present your substitute, which is the competing? You can go to the dais or do it from here. It's
Which would you prefer?
if you go to the dais or went to the lectern, I think I'd appreciate it.
Mr. Chairman, whichever direction we go here,
Right.
I do not see a person sitting out here with a green dot that I've ever seen before. So I would hope that after this gentleman's been here 8.5 hours, I would hope we give them as much time as we can to make their position known. And they're against my bill, sir.
No,
So,
Well,
Senator, we're all going to get heard.
Actually, Mr. Chairman,
Senator
I've been working with Senator Mason, and we're after the same goal. So I think once we adopt my substitute, they're going to be your friend. They're going to want to.
Okay, all right.
we'll see.
Okay.
All right. So Senator Hanger, he's talking the 2:29 p.m. version.
Right, 220, yes, right, that's the one we're looking at. Let me just frame the issue quickly, and I will try to be succinct. I've been involved in this for a number of years. Obviously, Senator Obenchain and I represent the largest agriculture interests in the state, in Rockingham, Augusta County, and the other areas up there that we represent. So been involved, I've been a member of the Chesapeake Bay Commission since, I think, 2003. I've chaired that commission twice. When the administration proposed to put regulatory backstops on some of the practices, the nutrient management plans and the stream exclusion, after we had made significant progress, the Virginia delegation of the Chesapeake Bay Commission then met to say, is this really what we want to do? Because we've had great success where we've incentivized these practices and we're making progress. So essentially the big difference is the administration would ask you to put regulatory backstops in now. We would propose to accomplish the same thing and only put those regulatory backstops in if we fail. Pretty much the same timeline, but also putting within the legislation a plan to get us there by appropriate actions that we can take as a state. Mr. Chairman, in further framing the issue, I would suggest, we talked a lot about the combined sewer overflows, and that's one of the issues we need to address. I would suggest to you, and I think this is a fact, that there are in Alexandria and Richmond area, metro areas alone, there are about 2 million humans that are having raw sewage deposited in the streams. An estimate of the number of animal units, not poultry, but animal units that we're talking about here in the valley is about 500,000. And I would say a significant portion of those, that 500,000, are already fenced out of the streams or have operation that doesn't require them to get their drink or contaminate the streams at all. So I would say that some of the representations about here about where the problem lays are misstated. As I go back to the years I've worked on this, when we began, Russ Baxter, he may be around here today. He always shows up when we're doing these good stuff. But he said in committee,
What's that?
Okay, if we spend $1 billion on point source, we can fix the problem. If we spend $1 billion on non-point, at the waste treatment plants, if we spend $1 billion incentive on non-point ag practices, we can fix it. Non-point stormwater, who knows? 9 to 12 billion is what he said, and I think that's probably what we're talking about, 9 to 12 billion. So we're putting an additional burden on the ag community because we can't afford to fix the other, and that's where we've been. Now here's what the bill would do in essence. We have the same language as far as the goals, as far as the 50 acres of cropland that would have to have an approved nutrient management plan. We have the same language for the stream exclusions. Where we differ is in the enactment clause, which would basically say that these backstops, which the irony of this is, Mr. Chairman, in part, is the EPA proposed backstops if we failed to do what we were supposed to do. Well, we're doing what we're supposed to do, and now we're going to impose backstops on ourselves when the EPA has said, hey, you're doing fine in Virginia. They're giving us some check marks because we're moving along here. So here's the difference. This would have the Secretary of Agriculture, along with the Secretary of Natural Resources, determine where we're at with our Phase 3 implementation. And then if we have not satisfied our coverage sufficient nutrient management plans, have not installed the sufficient number of livestock stream exclusions, or any other combination of best management practices, then at that point, these backstops, which would involve regulatory reforms, oversight, fines for our ag community and things if they were not complying, would go into effect. And how we get there? Again, we've talked about a stakeholder advisory group, and I think we're in agreement on that. But the group that we propose would develop a process to assist operators, not say you go out there and do this. We would take the initiative to develop a process to help our ag community, the landowners, get these nutrient management plans in place. We would also require that a portable fencing program be developed within the next year so that would be available for stream exclusion, because it's extremely costly to put these plans in place in flood-prone areas where it gets washed away with you build high standards. So we need a more economical way of fencing the streams out. Then, and if you will read particularly on the 4th page there, as far as the people we would involve with this, I think we would have a good plan with our soil and water conservation districts and all the stakeholders involved, coming up with a plan. And if we stay the course, Mr. Chairman, with our incentive funds that we're putting in BMP practices, we'll get there. And I feel good about that. I feel good about where we are at this point in time. I don't feel good about putting a regulatory regime on the back of our property owners and agribusiness operators when we're on track and they just need our help and assistance to get to the goal. Thank you, Mr. Chairman.
All right, Senator Hanger, before we take questions, is it possible for someone, for the benefit of the folks in the audience and for the benefit of the folks on the panel, to just summarize what's the difference between these two competing substitutes? I understand kind of the motivations, but...
Well, there's addition to it, and I'll take a short stab at this information. But in essence, the administration's proposal, and it's still embodied, even though he has granted concessions, well, we give you another chance, it imposes, and if you look in there, it's a regulatory regime. It's putting regulations in place which have fines and penalties if you don't comply. Mine would give us the opportunity over the next, we have almost 6 years to meet our goal, to move forward. And if we don't maintain the progress, we don't get there, then the regulatory regime would be
So
put in
it's
place.
fair to say his is a mandate and yours is more aspirational?
Not aspirational, it gives us a roadmap for getting there. It just does not put regulations in place. We have a voluntary program right now, working, don't want to change it now.
Okay, we've got these two gentlemen here. If we have questions from the panel from these two gentlemen and the secretary's here.
Can I answer, Mr. Chairman?
Yes,
Question
Senator Lewis.
Question for Secretary Strickler.
Yep.
Hey, Mr. Secretary, I don't want to put you on the spot. I've been talking to everybody involved in this on one side or the other, including the administration. But if I could get you to comment on 3 things. Number one, and I'm going to put this in one question, hopefully it'll truncate the experience for us. Number one, the progress that we've made. Number two, is there any reason to think we are not capable of continuing that progress, the trajectory on that progress? And then finally, number three, I know you just saw Senator Hanger's bill and you've had an opportunity to glance at it briefly, and you've also heard him explain it, so I'd like to get your reaction to his bill.
Yes, sir. Chairman Peterson, Senator Lewis, thanks for the question. We've made significant progress, and I certainly mentioned this in my opening remarks, and wouldn't want to downplay the degree of progress we've made working with agricultural producers through the cost share program to reduce nutrient pollution to Virginia waterways and ultimately the Chesapeake Bay. We still have a long way to go. The pace of implementation is not what we need in order to meet our clean water goals by the 2025 deadline. So that's the reason why we've introduced the legislation that's compatible with the voluntary program, but what we're hoping to do is through this drive signups to the cost share program to get people in, because there is a date certain that we need to hit to hit our clean water goals. So I've had a couple minutes now to review Senator Hanger's bill, and certainly appreciate his efforts, not just in this circumstance, but writ large with respect to the Chesapeake Bay restoration effort and clean water in Virginia. He's certainly been a champion for a long time and someone for whom I have a lot of respect and admiration and have worked very closely with and will continue to. I think Chairman Peterson's remarks may be close to accurate, and that what this does, it looks like
for me.
it looks like to me is it pushes off the thing that we want to put up front, which is to be clear about the fact that if we don't hit our goals, we're gonna have some requirements, and those requirements are in place, ready to be active if we don't hit those goals. This kind of takes the opposite approach, and I think it puts us in a situation where we're missing out on the opportunity to kind of drive the signups and increase the pace of signups that we really need. There's also a lot of language in Senator Mason's bill, which certainly if we get back to that we can explain, but that was crafted with a lot of thought into what exactly we need to make the program work, including how we're going to do perennial streams and the hardship exemption and those types of issues as well that I think are really important to making this work the right way. So that's my answer to your question.
All right, let me just set a little bit of structure here. What I'd like to do is, there's a lot of people here to testify. I'm going to give each side 7 minutes, okay? So each side will have a chance to testify. I would ask that you focus on, and I know it's hard because you probably just saw these two competing visions, and if you can testify to which one you support, that would be best. But regardless, I'm going to call for sort of each side. I'm going to say for with the Senator Mason side first, and then the Senator Hanger / Farm side second, however you want to divide that. And then once that happens, we're going to ask questions up here, and then we're going to have to decide which substitute we're going to proceed with. So let me start with those that support Senator Mason's bill in the form in which it is right now.
And the substitute.
The substitute. Well, that's
and again,
the form.
Mr. Chairman, we got a lot of pros that do this all the time and support,
Yes.
but please give I know, but these guys have been sitting here all day.
Monty, I
and
got
they're
it.
against my bill, so, but.
I know. You got it. All right, Peggy, come forward.
Mr. Chairman,
Yep.
members of the committee, I have to say I feel both honored and also filled with trepidation in commenting and comparing on bills submitted by Senator Hanger and Senator Mason, who both have been extremely conscientious and thoughtful in the short and long run on these really difficult issues. The good news, I think, for the Bay is that both of these bills would push us along in a direction that we need to go. I would say the care that was exemplified, that is exemplified in Senator Mason's bill for hardship situations, for inducing cost share signups, is not evident in Senator Hanger's bill. Doesn't mean it won't ever be, but those are differences now. The key difference that I see and that I would ask to draw your attention to is on line 66. That is, line 66 in Senator Hanger's bill. That is language that I think is intended to be the trigger. If we have not achieved our goals, then under Senator Hanger's bill, the regulatory process would come in place. I think it perhaps is not as clear as it might be, if I might say that. I think it's a bit confusing in the way it's written. I'm happy to talk about my concerns about it to, in my view, correct it, because I think if that provision is not clear, then the effect of Senator Hanger's bill fails entirely. And so I think it's really important that we look at that really carefully, and I'm happy to offer those suggestions if it's appropriate to do at this time. I would say if we don't make the changes that I think are necessary in Senator Hanger's bill, then I think we have to look at Senator Mason's bill, which provides in it a very careful set of triggers, a very careful set of protections, all to meet the Chesapeake Bay watershed requirements. So I'm happy to proceed with the suggestions that I would have for Senator Hanger's bill, if it's the right time to do that now. Okay.
Go ahead, but just keep in mind we're on a time limit. So.
I know. Okay, so looking at the enactment clause in line 66, beginning at line 66, and I'll just pick it up at 68. There's two secretaries, Secretary of Natural Resources and Secretary of Agriculture, would have to jointly determine that none of the Commonwealth's commitments in the Chesapeake Bay Total Maximum Daily Load Phase 3 Watershed Implementation Plan, in other words, that's everything in the plan, has been satisfied by coverage of a sufficient portion of the Chesapeake Bay cropland by nutrient management plans first, or installation of a sufficient number of livestock stream exclusion practices, or a combination of everything else. I don't know how you interpret that. I don't know how you determine, first of all, what a sufficient portion is. I don't know why it's in the alternative. And I don't know how we determine how each one of these would be assessed against the entire set of commitments in the watershed implementation plan. So
You've taken
I would
half the
offer,
time. Just
I would offer my suggestions now.
Yes, ma'am.
What I think would improve it is to, in line 66, take out the two words at the near the end, none of. In line 69, I would add, after Commonwealth's commitments, for the agricultural sector. In line 70.
Okay, Peggy,
Yeah.
we haven't adopted, you're asking us to amend a bill that hasn't been adopted.
You're right.
So,
You're right.
all right,
But I think that bill needs, these changes need to be made, and I'm happy to do it at the
All right.
right time.
Yes,
Mr.
madam.
Chairman, can I make a
Thank you.
request?
No, I'm gonna let the speaker speak to fill up the 7 minutes. Next person.
Thank you.
These are people in support of Senator Mason's bill, so if you're wearing a green sticker, you may not be support.
Actually, let me run to your net.
You're the man, go ahead.
No, it's support.
Supporters.
Oh, okay. It was in
You're gonna
support?
get your chance, trust me. Supporters.
Who you are?
Hi, I'm Mark Frondorf. I'm the Shenandoah Riverkeeper. I support Senator Mason's bill. One thing that you need to keep in mind is that this is somewhat akin to a high school assignment where you're given a report. You know you need to do it, but if you're not given a deadline, it's never going to be done. And so the deadline and the hard stop is essential to complete our goals.
Okay, thank you. All right, these are still supporters. We're gonna get to you, sir. Supporters, keep going.
I'm Tom Pelton from the Environmental Integrity Project. We're a nonpartisan, nonprofit organization. We did an in-depth study of livestock fencing that's I emailed to all your offices on Friday. I have copies of it here. Essentially, we debunked, there's some myths out there about how much progress has been made. In fact, only 20% of the 1,600 farms have fenced their cattle out of streams in Augusta and Rockingham counties, only 20%. That's a 1% per year over the last 20 years that Virginia has been trying to encourage this. So now it's time to take an approach like Senator Mason has suggested and do a more regulatory approach. 75% of the water quality monitoring sites on the rivers in the valley are contaminated with fecal bacteria, in part because of the lack of fencing.
Okay,
So it's a
thank
good
you, sir.
approach.
All right. Go ahead.
Mr. Chairman, Michael Town, Virginia LCV, we support the Mason substitute.
Thank you. Yes, sir.
Mr. Chairman, Jamie Bronco, James River Association, we support the Mason substitute.
Okay.
Mr. Chairman, Brian Hoffman, Friends of the Rappahannock, we support Senator Mason's substitute. Thank you.
Thank you.
Mr. Chairman, Andrew Clark with the Home Builders Association of Virginia, not the usual bunch that we're standing
Okay.
with, so I think that's indicative of how important this issue
All right,
is.
I'm
and
going
we
to let
support the
Senator
Mason
Obenshain ask a question.
I'm just interested in why the home builders, Andrew,
Yes, sir.
why the home builders support this?
Mr. Chairman, Senator Obenshain, I think for many years, the residential and the commercial development and construction industry has borne a lot of the burden of improving water quality. And I think it's important that we, kind of this is a collective process and that we should all have a stake and do everything that we can to improve water quality.
All right. Proceed. Keep going.
John Gibson, I own Downriver Canoe Company, a canoe outfitter on the South Fork of the Shenandoah River. I support Senator Mason's bill, and we need a little stick behind that carrot.
All right, next person.
My name is Herschel Fitch. I am the Conservation Chairman for the Potomac River Smallmouth Club, as well as my home chapter of the Isaac Walton League of America in Warren County. We, both organizations, do support Senator Mason's bill.
Okay.
Thank you. Mike Osterling, Shellfish Growers of Virginia. Our business depends on clean water. We support measures that maintain and improve our clean water. Thank you.
Yes, sir.
Mr. Chairman, Philip Mesigas from Potomac Riverkeeper Network. We support Senator Mason's substitute.
Steve Carter Lovejoy from Sierra Club, and we support Senator Mason's substitute.
Thank you.
Kim Husky, representing all of the shellfish aquaculture farms on the eastern shore of Virginia. We support Senator Mason's bill. Thank you.
Mr. Chairman, Pat Cowart, Virginia Conservation Network. We're in support of Senator Mason's substitute
All
as
right.
written.
Thank you very much. Before we get to the other side, let me just say, Senator Obenshain had multiple questions and had pinged me, and I did not recognize him. That was my mistake. So do you want to? Okay, we're going to hold those questions for later. All right, folks that support Senator Hanger's position or are opposed to Senator Mason's bill, you've got same amount of time. So I know we've got a lot of people here. Please go ahead, Martha. And start the clock at 7 minutes once more. Well, hold on, wait till she starts. And just, I think.
This is like a football game.
Yes, ma'am, take your time.
Reset the clock.
There's no rush. And just please line up behind her and at a minimum, you'll get a chance to say your name and where you stand, but ideally, we'll get a chance to fully hear everybody, so.
Thank you, Mr.
Martha,
Chairman.
yeah.
Martha Moore with Virginia Farm Bureau. First, I want to say we concur with Senator Hanger that farmers believe we can accomplish the nutrient reduction goals with voluntary conservation practices. However, we feel like we have not gotten the financial and technical support needed to accomplish these goals. When funding and technical assistance has been in place, farmers have implemented the conservation practices. If you go back a few years ago, a super incentive program for 100% was offered. Cattle farmers signed up for that. It took the state 5 years to meet that commitment. When the dollars are there, farmers have signed up for conservation practices. We think that that is a misstatement to say that we can't get to those goals if the resources and the technical assistance is provided. Farmers came here today from the eastern shore to Southwest Virginia to reinforce their commitment to voluntarily implement conservation practices. They don't believe they should have a hammer over their heads that they have to get it done on one hand, while on the other hand, their hands are tied behind the back because the resources aren't there to accomplish it. You're setting them up for failure. The bill focuses on 2 conservation practices with no mention of all the practices that landowners utilize to meet these nutrient reductions. In our opinion, the bill sets up a de facto permit. You don't need compliance assurances or civil fines if it is not a permit. Words like guidance and measure compliance are still regulating farmers. Rules are changing. Nutrient management plan regs are open over the next 18 months, so we don't even know what that's going to contain. We don't have a baseline or a clear definition of what is a perennial stream, and we don't know what a completed contract that would provide that somewhat of compliance assurance. If the Commonwealth wants to achieve this funding, wants to achieve these goals, then we should be mandating the funding that is needed in the needs assessment. We worked for 10 years trying to determine what that amount is. Again, farmers are willing to step up to the plate, but we need that partnership and not a heavy-handed of government. Thank you.
Thank you, Martha. Kyle.
Mr. Chairman, Kyle Shreve, Executive Director of the Virginia Agribusiness Council. A couple things. My comments are going to focus on the stream fencing provisions included in the bill. The two biggest hurdles we have to stream fencing in the Commonwealth is cost of the practice, in which producers right now, according to USDA, U.S. farm debt is at $416 million annually. It's important to remember the cost share program is a reimbursement program. Farmers still have to get access to capital. This past year, we reinstated the Ag BMP loan program, which we supported. In the first 3 months, producers signed up for $12 million. We had to raise the cap to $28 million, and that's not going to be enough if we put in Senator Mason's substitute. Secondly, we've had a long discussion. The other biggest hurdle we face is on rented land. Farmers, 2.6 million acres of rented land right now in Virginia, in which the farmer does not own and has to get approval of an absentee owner to put this on their property. What happens to the cost share dollars then? And you heard the developers say they wanted it. If an owner does not want to put up fencing on that property, I don't care how much cost share you offer them, they're going to sell to a developer because it's easier to do that and end the lease on a struggling dairy farm that they don't know is going to be in business next month. So, Mr. Chairman, the other thing I will tell you is we've advocated for a regional approach, a more targeted approach to our cost share dollars and through the TAC process. Right now, this would make us prioritize these two practices over that regional approach. And we just feel like if we can get the funding, go through a regional approach at this point in time, we prefer Senator Hanger's approach to that. Thank you very much.
Thank you, Kyle.
Mr. Chairman, members of the committee, Kendall Tyree with the Virginia Association of Soil and Water Conservation Districts. Our association policy is to support voluntary programming, and our districts are concerned for reasons echoed by our stakeholders. I recognize time constraints. There remains concern, despite the efforts in Senator Mason's bill, that soil and water districts will be put in the unfortunate predicament to message this and to really damage the trust that we have built with farmers in the field and will set us back heading towards WIP goals. Our districts were founded on grassroots peer-to-peer conservation and feel without fully recognizing and developing a plan and fully funding it, we won't get there with Senator Mason's, but ask you support Senator Hanger's substitute.
Mr. Chairman and members, I'm Jim Riddell with the Virginia Cattlemen's Association, and we're opposed to Senator Mason's bill and amendment. We've worked with you for many years, and many of you helped us put in the Ag Stewardship Program. And that Ag Stewardship Program is a complaint-driven program. What you're doing is we're moving to a system where we're really pushing the farmers off of the land. And I think about it, look at the green pastures and the green areas along 64 and 81 as you drive. You talk about conservation and water quality and keeping the air clean and the water. If we restrict our farmers out of business and we push them off, what have we done? What have we done? So the Virginia Cattlemen's Association is opposed to this. I want to also just mention, we talk a lot about cost share funds. Cost share funds are not what you exactly think they are. You do a project like this, you're going to have a well, you're going to have a waterer, you're going to have fencing, you're going to have clearing land. It's probably going to take you 8 months, perhaps a year. You've got to outlay all that money. $50,000 to $150,000, you have to put it out. I ask you how that would work in your business. The cost share doesn't come until the project's over, and then you have to go and get the cost share. We need to change that. We need to change those rules so we do get the money in piecemeal to help these kind of things happen. I would say that we need to use all the tools in the box to work on water quality. And what's going on here, we're taking the biggest hammer out of that toolbox, and that's what we're using. Work with us. We'll work with you. We've got a record for working with you. We really do. Look at it. Share with it. We'll work with you. So we're opposed to Senator Mason's to bill and his amendments at this time. Thank you very much.
Thank you. Yes, sir.
I'm Gary Hornbaker from Clark County. I would mention that I served 2 terms on the Virginia Soil and Water Conservation Board. At that time, we met the WIP 2 goals and actually exceeded that. And why all of a sudden now the question to you is, why cattle?
Why have cattle been singled out as the only segment of agriculture that you're going after with all these regs? It's unfair. But I will tell you this, I can go back and tell my cattle keeper friends that I went down to Richmond, sat for 8.5 hours, and you know what? They're after us to take the cattle out of the stream. But Richmond could dump 13 billion gallons of sewage into James River, and that's okay. They're going to try to get it cleaned up. Goodbye.
All right. I think we've been waiting for that one all night. Okay, one moment. And we've gone past the 7 minutes. What I'd appreciate is, I know people have come a long way. State your name, where you're from, if you represent an organization, and just tell me of support or opposed. Thank you, sir.
My name is Brian Scrooby. I'm from the Blue Ridge Mountains in western Albemarle County. I'm a beef cattle farmer on a small farm that's been in my family since the 1830s. I oppose mandatory stream exclusion regulations under any circumstances, but I'm fine with the practice if it's voluntary. Anything that'll help the bay, we're all for. I do water testing at my farm, and I'm doing the best I can for the bay. Thank you.
Mr. Chairman, Connor Miller with the Virginia Grain Producers Association. We oppose the bill.
Thank you.
I'm Emily Edmondson. I'm a cattle farmer in both Tazewell and Washington counties. I came a long way to see you. I oppose the bill, but I would go for Senator Hanger's substitute amendment. Thank you.
Thank you.
Thank you, Senators. Justin Pence from Shenandoah County, Virginia. Senator Obenstein's district, I have a small beef cattle farm, and I have voluntarily done all the things, all the projects that I can do on my farm. And we will do things voluntarily. We just don't like them mandated to us, and we want clean water for our kids and future generations. Thank you.
Thank you.
Matt Knuckles from Hanover County. One of your dairy farms lost in 2019. I am now with Virginia Farm Bureau, happily supporting farmers. I oppose the bill. I oppose Senator Mason's bill. Thank you.
Mark Campbell. I'm from Nelson County. I'm an employee of Virginia Farm Bureau. I also have a beef, cattle, and sheep operation in Nelson County. I also am a director for the Thomas Jefferson Soil and Water Conservation District and received a 2016 Clean Water Farm Award for the entire James River watershed. I'm adamantly opposed to Senator Mason's bill and his substitute bill. Thank you.
Thank you.
Lee Pemberton, Hanover County. I'm a retired dairy farmer, and I support Senator Hanger's amendment.
Thank you.
Linwood Broadus, Caroline County. I oppose the legislation, grain and cattle farmer.
Senators, I'm Dennis Jones from Tazewell County and a farm in Tazewell County and Lee County, Senator Pillion. And we will support Senator Hanger's bill and oppose Senator Mason's bill. Thank you.
Jameson Jones, Tazewell County. I'm a member of the Tazewell County Farm Bureau and our young farmers, and I'm a co-owner of a farm in Lee County, and I encourage you to support Senator Hanger's amendment.
Morgan Slavin, sixth-generation beef cattle producer from Augusta County, and we'd oppose Senator Mason's bill. Thank you.
Kyle Sturgis, Northampton County on the Eastern Shore, Chair of the State Young Farmers Committee, and I oppose Senator Mason's bill. Also, grain and aquaculture producer on the Eastern Shore. Thank you.
Matt Hickman, I'm a vegetable and grain farmer in Accomack County, and I support Senator Hanger's bill.
Sands Gale of Accomack County. I'm a grain farmer, and I'm opposed to the bill. I was 2017 Clean Bay Water Award winner.
David Hickman, Accomack County, vegetable and grain producer. I oppose mandatory regulations.
Chris Haskins, cattle farmer from Pennsylvania County. I support Senator Hanger's substitute.
I'm Dave Norfolk from Albemarle County. I'm also president of Virginia Cattlemen's Association, and we support Senator Hanger's
amendment.
Thank you.
Bill Latney, Westmoreland, also have a farm in King William, support Senator Hanger's bill.
Clay Francis, grain farmer from Southampton County, and I'm opposed to any regulated mandates.
Bob Harris, Pittsylvania County, first-generation cattle farmer, row crop farmer, and we oppose any mandatory regulations.
Hi, Mark Dawson, Carroll County, support Senator Hanger's amendment.
John Goodwin, cattle farmer, Spotsylvania County, support Senator Hanger.
James Kane, beef cattle farmer, Louisa, Virginia. I just point out real quick, we were the 2013 recipient of the York River Basin Clean Water Award. Several of the farms I've leased, I've talked to landowners into doing BMPs where I personally picked up what was not covered under cost share. And for all this work, I feel like this is a slap in the face to the ones that are trying to do a good job. Good stewardship of the land is very important to every one of us in this room, not only because we feel it's environmentally sound, but it also helps our bottom line. I'm against Senator Mason's bill, and I would hope you would support Senator Hanger's amendment.
Thank you.
Al McGee Jr., Orange, Virginia, 2017 Chesapeake Bay Grand Basin Award winner. Also, the York River Watershed 2017 winner. I run a beef cattle farm, and I also support Senator Hanger.
Evan Bowman from Greene County. We were the 1999 recipient of the Chesapeake Bay Award from Greene County, and I support Senator Hanger's bill.
Scott Sink, serve as Vice President of Virginia Farm Bureau, cattle producer in Franklin County and Montgomery County. I stand in support of Senator Hanger.
Howard Nestor, President of the Chesterfield Farm Bureau. I've raised cattle. I support Senator Hanger's bill.
Benny Questenberry, Carroll County Farm Bureau President, and I have done some of the fencing out of the streams, and I like to see it if I'm opposed, be it mandatory. As farmers, we gotta, have time to do this stuff. So I appreciate y'all listening to us today, and thank you. Good evening, everybody. Thank you, Chairman Peterson. I'm a poor peanut farmer from Isle County, Virginia, and I've done something today that I've never done in my life, and that's sat on my rear end for 8 hours here today.
It ain't easy.
I'm a fourth-generation farmer. I'm proud to have the opportunity to work this land. There's nothing that pleasures me and my family no more. We have more to lose than anybody by not being an environmental steward. My family's life depends on it, and everybody else that I produce food for's lives depend on it. I am adamantly opposed to this bill for somebody standing over top of me with a hammer telling me we have to do this. We do this naturally because our lives depend on it, and everybody that we feed in this world's lives depend on it. And we want to be able to continue to provide that food source. It's very safe and environmentally sound practices. Thank you very much.
Good evening. I'm Jason Copeland, Isle of Wight County peanut and cotton farmer, and I'm opposed to Mason.
Brian Walsh, Loudoun County, in support of Senator Hanger's substitution. Thank you.
Thank you, Senators. I'm Dana Fisher, originally from a farm in Shenandoah County and now in Rockingham County. I taught agriculture in a high school for 13 years before coming to Farm Bureau to work with farmers. I see them face to face, and the fact that they spent today here with you in this room when they could have been at their homes, at their families, at their farms, at their businesses, says a lot about the folks who are here to do this. We believe in clean water too. We believe in the practices that are voluntary and that are working, and we think that if you allow us to continue to let those projects grow, you'll see the benefits. Stand in opposition to the mandatory regulations.
Thank you, sir.
Mr. Chairman, Eric Paulson, Virginia State Dairymen Association, representing dairy farmers in Virginia. We stand in opposition to the bill. We're an industry that's lost 24% of our dairies since 2017. We're fully committed. We have resolutions in the book supporting both stream fencing and nutrient management plan. But these are currently, this will be an unfunded mandate. There's not the resource there. Even in down times when our industry is losing producers, we still are active participants in this program. So for those reasons, we urge you to support Senator Hangers. Hi, I'm T.R. Jones. I'm one of the last dairy farmers out of Dinwiddie County. We participated in the NRCS programs about 10 years ago, and I think my unique position here is that we had one fail this past year, and directly cited from NRCS was that they didn't have the manpower or the resources to enforce their own rules. So I think maybe before you start worrying about what the dairy farmers are doing, make sure you actually have the power to do what you think you can do. Thank you. Thanks for hearing me.
Thank you, sir.
Good evening, Paige Pratt. Along with my husband and 2 children that are 4 and 6 years old, we farm beef cattle in Smith County. We are past award winners of the Evergreen Soil and Water Conservation District Clean Water Award winners, and we would support Senator Hanger's bill that allows us to have programs that will hopefully allow us to pass our farm on to our children in the future.
Okay. All right, I want to thank everybody. Appreciate that. At this point, we've had both substitutes presented to us. Are there any questions from the panel? I know Senator Obenchein had some, whether to the 2 sponsors or to the administration or anybody else that's been a witness.
Well, Mr. Chairman, thank you very much. And it's been a long day. I will spare the back and forth if I could just make a couple of comments.
Go ahead.
Maybe, I don't know whether motion's in order at this point or not, but, you know, I come from a farm family. And I live in Rockingham County. And I know an awful lot of farmers, and they are the best stewards of the land that you could possibly want. I don't know a farmer who doesn't want to ensure clean water. I appreciate Secretary Strickler and his efforts and his comments. And I found one of his comments to be particularly illuminating, and it really, it may get to the heart of the issue, but he said that we're just not going to have enough farmers sign up in order to meet the Chesapeake Bay goals by the deadline. Now, I guess we've got, and Senator Hanger pointed out a couple of things, we've got a couple of ways we can meet those goals. I mean, we've got the expensive way, which we talked about a little bit earlier, with some of the urban and suburban issues, and we've got the less expensive way involving rural Virginia. The difference is there's 7.5 million people in urban and suburban Virginia, and there are about 44,000 farms in rural Virginia. And, you know, those numbers make it really hard for these folks who are here representing agriculture in Virginia, which, by the way, is our #1 industry, to really be heard and get their voices heard. And this is the Agriculture Committee. And one thing, and, you know, I'm a lawyer by profession. I'm not a farmer. When I started down this path, I learned a lot about farming. One of the things that I learned was that best management practices are just that. I mean, they are, you know, the gold standard. And we want to encourage that. We really do. And I don't know a farmer who doesn't want to implement them, but the simple fact of the matter is that, I guess, 15 years ago when I heard these figures, and I guess they're probably still roughly true, the average farm in Virginia, average farm made $50,000 a year on average in gross income, okay? That's not net income, that's gross income, $50,000 a year. And when you take out the expenses, that ain't a whole lot. And it certainly isn't gonna be $15 an hour that we've been talking about in other contexts. It isn't. And then you look at the cost of implementing best management practices. And right now, best case scenario, I think we're federal and state government are paying maybe 65%, best case scenario, of implementation of those best management practices. The simple fact of the matter is that we're focusing on farms with 20 cattle on it in this bill. And one of the speakers in support of Senator Mason's bill said, you know, by God, the carrot hadn't worked, so now we're going to apply the stick. And, you know, these are small farmers who cannot afford the stick. And, you know, home builders over there, you know, and I love the home builders, and I want to work with them as much as I possibly can, but this land is going to go into development. And you're going to have us jumping from the frying pan into the fire if we mandate compliance and decide we're just going to stick these people with $2,500 a year fines. And I think that we ought to encourage compliance. I think Senator Hanger's bill is clearly the better way to go. And I would hope that we move to adopt Senator Hanger's substitute.
Okay, we have a motion and a second to adopt Senator Hanger's substitute. That was a very lengthy motion, but.
Mr. Chairman, speaking to the motion.
And we've got some people that want to speak on the dais, so please listen up. Senator Lewis.
I'll try and be brief because it is late and everybody has been sitting here for a long time. I want to thank everybody for the progress they've made. I know Senator Mason and Senator Hanger have been working. I've talked to them. I've talked to all the stakeholders. You might imagine my district certainly has a keen interest in this outcome one way or the other. And as our old friend Frank Hall used to say, remember, you've got friends on both sides. Remember that one?
Yes.
So I just want to applaud everybody for their efforts. But let me make a couple of observations here. First of all, we have made significant progress. And just as a personal observation, there is nobody with a keener interest in a clean Chesapeake Bay than an Eastern Shoreman. And I will say, and that includes the farmers on the Eastern Shore, coming from a farm family myself. These folks have worked with the state, with the Commonwealth, and we've made some significant progress. We can do this. I firmly believe that we can. I think Senator Hanger's substitute sets up a roadmap, puts up a framework, makes people talk, makes us keep moving forward. I think we saw tonight from the Chesapeake Bay Foundation, Peggy Sander, she's already got some ideas about how we could potentially improve upon Senator Hanger's language. So people are poised to work on this together. I think it's premature to go with the more aggressive route that's in Senator Mason's bill. So I think we need to take a deep breath. I think we need to pass Senator Hanger's bill, and I think we need to keep working on this because I firmly believe we can do it.
Okay, let me take these in order. Senator Morrissey, I have you next.
Thank you, Mr. Chairman. I'm going to start by saying I'm going to support Senator Hanger's bill. With that said, a couple of observations. The folks that came today from far and away, you didn't waste your time. You left an impression on all of us up here, and so thank you for doing that. The two senators that have not necessarily competing substitutes, different versions, thank you for the work that you've done. Here are my observations. I remember when Senator Stewart was talking about earlier, I cannot begin to tell you the impression that it left on me about 13, I think it was a billion gallons of sewage that is gone into the river and is left untreated. I swim in that river and I water ski, and my kids do. That left an impression on me. And I was disappointed that the administration didn't take a position on it. Now with this, we're talking about, let's be clear, cows going into the river and pooping, okay? And whether or not we're going to put a fence up there. I would have loved to have heard a comparison between 13 billion gallons of raw sewage going into the James River and what we're talking about with those cattle going in there. I didn't hear that comparison. Third observation is I believe that the farmers.
All right, keep talking, Senator.
We'll listen.
I believe the farmers are good stewards of the land, and they want to comply, and they're going to engage in practices, albeit some of them voluntary practices, and I respect that. At the end of the day, I thought that Senator Hanger's bill, which is respectful of what the farmers have done and what they intend to do, is the appropriate way to go. And I appreciate your efforts, Senator Mason.
All right. Thank you. Next, I have Senator Favola in the queue.
Thank you, Mr. Chairman. I do want to thank both patrons for shaping such a lively conversation on an important issue, and there are advantages to both approaches. But I have been persuaded by those who have traveled so far to tell us that they have the most vested interest in cleaning up the Chesapeake and ensuring their groundwater is clean and ensuring that they have a healthy environment to pass on to future generations. So the question in my mind was just how do we best get there? And I believe Secretary Strickland said that their progress has been made. We may not have made as much progress as you would hope, but the farmers and all the stakeholders have been making progress. They've been doing it in a voluntary way. My concern, Mr. Chairman, I am going to support Senator Hanger's amendment, although I have the most respect for Senator Mason. Are we going to have additional resources to put into the whole model of greater technical assistance, sharing best practices, helping farmers get to where they need to be if we come up with a certain schedule of targets? Is this going to be re-referred to finance? Is there money in the governor's budget for enhanced
I'm sure it is.
treatment?
It is requested in finance. Of course. We'll deal with that later.
Okay. Again, thank you to all of you who've traveled such a long distance to be here with us.
All right. Senator Favola, the last one I have is Senator Hashmi.
Thank you, Mr. Chair. I just want to briefly state thank you to both of the patrons for bringing forth this very, very necessary bill. I am committed to environmental progress, making sure that we make the kind of changes we need to have security in our environment. I came in tonight ready to support Senator Mason's bill. I believe I heard the Secretary say that what the city of Richmond is dumping in to the river pales by comparison to what we're seeing from the agricultural businesses. If I'm correct in that, then we have a weighty, significant problem, and we all know we need to address it. I voted against the COS bill because my concern was that it was going to negatively impact our communities in Richmond, people who can not afford to bear that significant burden that we are asking them to do. I really appreciate all of the testimony of our farmers and people from the agricultural community here tonight, just as we cannot shift this burden to the low-income communities in Richmond. We cannot shift this burden to you as well. I think it is equally unfair to do that. And so your testimony was powerful. I thank you for all the insights that you provided. I especially appreciate your commitment to the environment and to clean water, air, and soil. So thank you for doing that. And for that reason, I'm going to support Senator Hanger's bill tonight.
Okay, I next have Senator McClellan.
Thank you. Very, very briefly. I want to make sure, it's slightly in response to Senator Obenshain's comments, but let me just preface it by saying I'm also going to support Senator Hanger's bill, because this is not an urban versus rural issue. This is a Virginia issue. And I think both what's happening in Richmond with CSO and what's happening with the contamination from agriculture are centuries-old problems that the localities can't handle on their own, and one individual industry can't handle on their own. And we have got to address this as a Commonwealth. And since this is going to finance, I'm going to get an opportunity to say the same thing here. We need to prioritize this issue as a Commonwealth and not try to squeeze over here or squeeze over there and say, well, now we're going to make this community pay for it. We're going to make this community pay for it. We have got to find a way to spread the cost to clean up the Chesapeake Bay evenly and the most fairly. Because when you read headlines, and granted, this is the other coast, but when you read headlines about acidity in the water that is dissolving crabs, that's the kind of thing, again, other coasts, but a good illustration. This is impacting all of our communities and all of our industries, and we shouldn't have to choose between watermen and cattlemen. So we need to find a way to deal with this as a Commonwealth and spread these costs more fairly.
All right, Senator Marsden.
Thank you, Mr. Chairman. I remember when this came through the House back in the before 2010, when I left the House. And I was carrot person, and we did voluntary nutrient management plans. And I don't think the progress is spectacular. I don't think it may be significant. That's in the eyes of the beholder. But the stick in me is getting impatient to get this stuff done. We'll be watching. We'll see what kind of progress you make. All of you who are here today have a job to do, which is to go home and talk to the people in your communities to get them on board and get them moving for Senator Hanger's plan. Otherwise, the pressure builds to make things mandatory. But I will support Senator Hanger's bill as well.
Okay, thank you. All right, before I call the vote on the amendment, I'm going to speak last. And it's often said that everything has been said, but not everybody has said it. And so I'm going to exercise a little bit of chairman's prerogative here. I was very honored to be selected as the chair of this committee. I represent a suburban district in Fairfax County, Virginia. I don't have any farms. I try and listen closely to people that are stakeholders in this profession, much like my children and I consume Virginia products, and we actually use the Virginia waterways. But it's been meaningful, your participation today, and it has made an impact. And don't ever think that your coming here was a waste of your time. It was not. It actually made the difference. That's point one. Point two, there's certain people in this building that have the integrity to make a difference on an issue. One of those is the gentleman to my left here, 2 seats. So that made a difference. Point three, this is a continuing issue. Non-point source pollution and the effect on Chesapeake Bay is an issue. Exclusionary fencing is an issue. So we're not solving it today. We're not dismissing it today. We're not deferring it today. It will continue to be an issue. I will continue to work with your representatives in the farming community who do a great job representing you, because we're going to get to a solution like my colleague Senator McClellan said as Virginians. But we're going to do it. We're going to do it together. We're going to do it together. So having said too much, I call the question on the vote. All in favor of the motion to adopt the substitute proposed by Senator Hanger, say aye. Aye. Any opposed, say nay.
No.
Okay, we have, was that Stanley?
I got to vote for my own
It
bill, man.
was not me.
I mean,
All right.
I've been standing here taking.
Please count Stanley as a no on that.
No, you
vote.
do not. No.
All right, the motion carries.
Mr. Chairman, the Chesapeake Bay Foundation had significant amendments, and I think the Senator Hanger said he will certainly make them along the way as they go to finance.
Right. Why don't we're going to take that up at finance.
Yeah.
Right. That's the
Mr.
best
Chairman,
way to do it.
Peggy made some observations
Yep.
there. We may need some wordsmithing, but we'll work on it.
Yes, okay, so the bill is, the Hanger substitute is still in front of us. It's still Monty's bill, Senator Mason's bill. The substitute is now in front of us. Do I have a motion? Okay, we have a motion to report. Motion to report and refer to finance as amended. Clerk will open the roll.
I'm voting for that, man.
Yeas 15, nays 0.
All right.
All right.
Y'all can go home
Nice
now.
work.
All right, what do we have left down up here?
I've actually got another one.
Oh, my gosh, all right. All right, can we take about a 2-minute recess and let our colleagues and friends vacate the room? Do not walk away, members, just let's take a recess.
Can I go to the bathroom?
Yeah.
All right. I'm with Dave.
Okay. Jennifer, do you have a bill?
Well, three.
What happens tomorrow, you're familiar. Thank y'all for being here. Thank y'all for doing it so well.
So now we're together now. We're best buddy David.
I want to show you something. Yes, sir.
Tom Pelton on the Charity Project. Thank you so much for your bill.
Oh, you bet. Thanks for speaking. You did really well.
Could I give you a copy of that?
Give Richard Stewart a copy of that.
Gentleman there?
No, tall dude over there. But I am. Thanks for speaking up, and I will check it out because.
Okay, folks, social hour's over. Back to work. All right, if you're not participating in the next couple of bills, please go out in the hallway. Not trying to be rude, but we still have some more bills we need to get through. Okay, I believe, Senator Mason, did you want to present your next bill?
Yes, sir.
Go
Senate
ahead.
Bill 702. All right, so last year we came to you and we put some fees in on oyster aquaculture. It was a combined working group. We worked all summer and all year. Everyone agreed to raise the fees. The first segment of this bill, 15 to 25, speaks to those fees that we did last year and just ask for them to go to VMRC, which is what we intended all along. Last year was about $440,000. The whole idea, if you recall anything about it, and you probably don't, is we're trying to do away with bad actors. We expect those amounts to go down. That is going to allow VMRC to do more surveying, do more things that promote the industry. Our industry is not here, but they were a little concerned that we were banking on the money to put people in place. Not the case. We're not leaning on the backs of industry there. And I think they've come around to be okay. Then we essentially another dredging fee that we haven't increased since 1970. Sue Line, pay attention. We're increasing the fee. You want to vote no? And literally are going up to from 100 to 300 to 600. We expect that's about $230,000 for the Waterway Improvement Fund. So not groundbreaking things here. First part of the bill came out of the consensus of working group last year. I just want to make sure Mike's not here. At one point, he had a little bit of an issue. I think we've resolved their concerns, and the second fee hadn't been increased since 1970, before Sue Line was born. That's why he should vote yes. That's bill, Mr. Chairman. I move to.
All right, so it's, I'm sorry. Permit fees for VMRC.
Yes, sir.
Anybody in favor or opposed?
Well, we have Ellen.
Come on up.
Thank you, Mr. Chairman. My name is Ellen Bolin. I'm the Deputy Commissioner of the Virginia Marine Resources Commission. This is an agency bill, and we're strongly in support of it.
Great.
Thank you.
Strongly. I haven't heard that in a while. Okay, all right.
Mr.
Yes.
Chairman, Anna Kilius with the James River Association. We also support the bill.
Great, thank you, Anna.
Mr. Chairman, Nikki Robner with the Nature Conservancy. We also support this bill.
Okay,
Mr. Chairman, Chris Moore, Chesapeake Bay Foundation, we support this bill as well.
thank you, Chris. Any opponents? Okay, we operate by motion. Okay, I've got a motion and a second to report the bill. Open the roll, please.
You have to go to finance.
Oh, and to refer to finance.
Oh,
Open the roll.
I mean, they're doing it to themselves, man. Oh, cool. Give your brother a break.
Suter line, where are you? There you go.
Sue Line, yeah, I got that. Open chain, no. Stewart.
Yeas
What's the
10,
matter with
nays
you?
4.
Man, you. All right, thank you, Mr. Chairman, members of the committee. Fun out.
Okay, Senator McClellan.
Thank you, Ms. Chair. If I can present from here, that'd be a little easier. Senate Bill 1075 deals with the problem. What has become clear over the past couple of years, particularly as I've heard from constituents, is that the public's ability to participate in decision-making by the Air Board and the Water Board is hampered by the relatively short public notice given about important decisions made by these boards and the relatively sparse information included in those public notices. Communities particularly affected by Air and Water Board permit decisions currently only receive 30 days notice of public comment periods and barely any information that is understandable to the public about the actions to be taken. So what Senate Bill 1075 does is would expand the period for which notice would be given for those actions for those whose communities will be particularly impacted by the decision in ways that wouldn't be impacted by other communities. And that's the bill.
Okay.
Oh, I have a substitute, I'm sorry.
Oh, there's a substitute?
What I was describing was the substitute.
All right, can we distribute the substitute? Can I have a motion and a second to distribute the substitute? Okay, we have a motion and a second to adopt the substitute. All in favor, say aye. Aye. Okay, opposed, no. But substitute's in front of us. Senator, do you have anything to add?
No, again, this is just mainly giving more transparency and giving our communities an opportunity to be heard. And this was brought at the request of several constituents. There have been a couple of power plants that have been approved in Charles City County in a relatively short period of time and lots of confusion around them. And I just heard from a lot of constituents with respect to those projects and also have heard from others across the state, just that by the time they figure out that they need to comment, it's too late.
Can I ask a quick question?
Yeah, we have a question down here. Senator Obenchain.
And I don't have any objection to public comment, but there are some pretty well-established standing rules. This doesn't affect those, do they? Like standing
No.
to challenge?
No, it does not. It only deals with the notice that will go.
Dave? Okay. Great case called Friends of the Rappahannock on standing, by the way, for agency decisions. I'm about to reverse it. All right, anybody else have any comments on Senate Bill 1075? Oh, hold on, I thought I saw a hand go up in the audience. 1075?
I think they just want to
If you
show their
support it, don't say anything. All right, good. All right, yes, go ahead. We have a motion to report the substitute. Okay, we have a motion. Do I have a second? Okay, I have a motion and a second. Gentlemen. Clerk, open the roll.
Yeas 15, nays 0.
Okay, the bill is reported and referred to finance. I think that's our final bill on this docket. Nope. Marsden had to have a dog and cat bill. All right. One more. All right. Senate Bill 891.
Thank you, Mr. Chairman. There's a substitute and there's an amendment to the substitute.
All right, well, let's distribute the substitute. I've actually got an open space case, an open space easement that the owner ignored his easement and renovated a historic house, and the city of Alexandria let him do it. And I'm representing historic Alexandria, sued him. I've got a writ argument in a few weeks, but part of the argument was standing. You know, that we're not right next door. And I'm like, yeah, but we live in a historic district, and anything that sort of diminishes historic district, we've got to be able to protect it. That's like, well, I mean, because otherwise, you're never going to be able to enforce zoning laws. Okay, I'm sorry, we're talking Supreme Court precedent up here. All right, Senator Marsden, why don't you proceed, please?
Thank you, Mr. Chairman. You want to deal with the substitute and
Yes.
then report the
Oh,
amendments?
I'm sorry. Okay, motion and second to adopt the substitute. All in favor, say aye. Any opposed? All right, the substitute is before us, and then I see an amendment. Do you want to move the amendment?
Yeah, I'd like to move the amendment, yes. And Dave, could you report that?
Okay, I think we've got it in writing.
Okay. I think Dave had a slightly different place to put something.
Yeah, Mr. Chairman, as I understand it, the intent of the amendment is to bring pet shops and private shelters into the one unannounced visit inspection per year. And so I don't think that adding that definition is the right way to do it. Scott and I have talked, and I think it'll be better if we just online. Sorry, let me get this here. Looking at the substitute on line 242, changing that to include pet shops and private animal shelters, as those are both defined terms already. And then the second amendment there is to strike the enactment clause, which would stand.
Okay, hold on. Let's repeat. Strike the enactment clause. I understood that. What was the first amendment?
To include in the paragraph E, that's line 242, pet shops and private animal shelters rather than the word regulated facility. I believe that's the best way to do it.
I'm sorry. Maybe I'm obtuse. I don't understand. You're kind of trailing off there. What is the First Amendment?
The First Amendment would make it so that pet shops and private animal shelters get one unannounced inspection each year. And that's the inspection that's provided for in paragraph E of the substitute.
Okay, so that what is a regulated facility will be a pet shop or a private shelter?
Correct.
All right, do we want to take these amendments in a block? Okay, does someone want to move the amendments in a block? Okay, is there a second? Second. Okay, motion to adopt the amendments. All in favor, say aye. Any opposed? All right, amendments are adopted. Go ahead, Dave.
Thank you, Mr. Chairman. This bill is a shadow of its former self. It started as a larger effort to deal with any number of animal housing facilities, but it's right back to what the original problem was, which was pet stores. And the only way this impacts private shelters, they're already regulated, is that there's going to be one unannounced visit. Other than that, the regulatory process remains the same for private shelters. There is a budget amendment in to create another position through VDAX and the veterinarian's office as a technician to conduct these unannounced visits on our pet stores and also, private shelters. But essentially, what it does is it requires that we go through the APA process to create regulations and and standards and means of compliance for these pet stores so that they can take the care of the animals that they have in their care, and these are companion animals. And there's been a lot of concern. You've heard some of these horror stories in some of these pet stores around the Commonwealth that localities are regulating all differently. This will put it all under one regulatory regime here, through the APA process, there'll be plenty of time for comment and for a participation by the advocacy community.
Okay, is anybody
as well
opposed
as
to
pet
this?
stores.
Any opposed? Okay, we've got some opposition. I'm sorry, I didn't mean to cut you off.
No, but that's the issue is that we have found these pet stores that have had dead animals just stocked in refrigerators.
Okay,
It's been all kinds
familiar
of
with the
issues.
issue. All right. Anyone speaking in support? Okay, come forward and be super brief.
Senator Peterson.
Yes,
and
ma'am.
Committee members. I'm Susan Lowney with the Virginia Dog Army. Members of my group during 2019 visited pet stores throughout the Commonwealth. In every visit, we found violations of the current code. There went from the range of you might consider less severe in that they did not find the required postings that you've set. Some cases, it wasn't fully documented what that information should be. In other cases, it didn't exist at all. That's important to consumers. In more severe cases, there was actual falsification of certificates of veterinary inspection. That's the process that's meant to keep sick animals out of the state. There were instances of controlled drugs being dispensed and dosed without a veterinary license. There was inadequate water supplies.
Okay, Suzanne, I'm going to cut you off because I think we're in good shape on this one, okay? This is for unannounced drop-in visits, correct?
Yes,
And
sir.
you support the bill?
I do support the bill.
Okay, I think, yes,
Thank
ma'am.
My name is Deborah Griggs, and I am with the Virginia Federation of Humane Societies. We absolutely support the bill. The only point I wish to make is that private animal shelters already have unannounced inspections.
Right, so this is just pet shops.
I'm not sure, but we've added pet shops and private animal shelters, right?
Okay, well,
If I could answer, what my understanding is they were inspected, but they did not necessarily have unannounced. This would add one unannounced visit through this. I do have a budget amendment in for the position, so that this will need to go to
For
finance.
VDAX.
And I believe Senator Morrissey has a question for me.
Oh, my gosh, okay.
They do have
Morrissey.
unannounced visits, just to be clear.
Joe,
as your
I'm about
lawyer,
to pay
I
an
advise you to
unannounced
remain
visit to
silent.
Morrissey. All right.
Joe, as your lawyer, I would advise you to remain silent.
One question, 18 parts. It shouldn't take long. Dave, are the pet store shop owners, are they in support of your legislation?
Yes, they are.
All right,
They're behind this bill. They want to be regulated. They want to do the right things. The pet stores that are left here in the Commonwealth are pretty much
Okay.
the good ones, and they
All
want to do the
Thank
right
you.
thing.
I know I had a lady who's not a fan, so please come forward.
I'll take it back. I didn't, excuse me, Alice Harrington, Virginia Federation of Dog Clubs and Breeders, and
Yeah.
I didn't understand all the amendments page.
Yeah, I think you're-
And apparently, the technical committee is removed, the
technical-
advisory
The
committee.
technical advisory committee is removed. It will go through the regular regulatory process.
Okay, all right. All right, do I have a motion on this bill? Okay. You can't second your own motion. Do I have a second? All right, we have a motion and a second to report this bill and refer to finance. I'll open the roll. We'll talk to David separately, okay?
Yeas 13, nays
We're talking
0,
about David separately.
abstentions 1.
Okay, what I'm going to do before I adjourn, first of all, I want to thank everybody for sticking in there tonight. As you probably tell, my immediate past chairman, Senator Stewart, I want to thank him for manning the tiller while I was upstairs. He had just a brief word he wanted to say.
Mr. Chairman, thank you. I wanted to commend you on doing such a stellar job chairing this committee this year. You really did move things along and get these bills done. It's not always an easy job. I wanted to make one other comment. DEQ took a few hits tonight, and I'm not sure they were justified. And I want to say, and I think everybody agrees with me, I've known Dave Paler and Angie since I first came to the Senate. I've never found better people to direct an agency, and I appreciate everything they've done, and I didn't want them to think, it felt like to me they took a few hits tonight that maybe were unnecessarily, and they do a really good job.
Okay.
Don't
All right.
forget Brandon.
Committee is adjourned.